Good morning, everyone. Welcome to the second day of our Fall 2025 oral argument session here in Philadelphia. As you may know, the Pennsylvania Supreme Court is the oldest appellate court in North America. Our roots date back to William Penn's Provincial Court of 1684, and our Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722. In May of 2022, our court celebrated its 300th anniversary here in Philadelphia, and we are privileged to sit on this historic court and to sit in three historic courtrooms in Harrisburg, Philadelphia, and Pittsburgh. Here in City Hall, the facade of the bench is constructed of Mexican onyx, with each of the 7 panels divided by bronze statuary representing the Greek figures of justice, law, and jurisprudence. To the right of the bench is an Italian marble bust of John Bannister Gibson, Chief Justice of Pennsylvania from 1827 to 1851. To the left of the bench is a bronze bust of George Sharswood, Chief Justice of Pennsylvania from 1879 to 1882. Chief Justice Sharswood was a well-respected member of the Philadelphia Bar. Directly behind the bench is a mural completed in 2002 by 2 local artists, Michael Webb and Max Mason. The view is of Independence Hall's southern facade with the historic Pennsylvania Supreme Court courtroom to the left. The interior of both the courtroom and the Justices' Conference Room were designed by George Herzog, an American interior designer and decorative painter. While you are here, I hope you will take a moment to observe the majesty of our courtroom and its tributes to our system of justice. Before we hear the first case, I'd like to remind counsel of a few things. Appellants counsel, please approach the podium when your case is called. I will then give a short summary of the case. Please begin by introducing yourself and your co-counsel and identifying the party you represent. The justices are familiar with your cases, so we ask that you avoid any unnecessary recitation of facts or procedural history, and instead focus on the main issues that we granted review. Counsel is welcome to rely on their briefs for particular issues. In cases in which there are multiple parties represented by separate counsel, counsel should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when they're asking you a question. A justice's question is not meant to trip you up. Rather, it indicates there are particular issues we would like to explore further. I remind you that we do not allow rebuttal. Finally, we have no set time limit for argument. I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, please call the first case.
Brian Baxter and Susan Kinnery versus Philadelphia Board of Elections, RNC. Representing the RNC, Mr. John Gore. Representing the Attorney General's Office, Mr. Brett Grimm. Representing Baxter and Kinnery, Mr. Stephen Loney. Representing the Pennsylvania Democratic Party, Mr. Daniel Volchuk. Representing the Philadelphia Board of Elections, Mr. Ben Favens-Lasky.
In 2019, the Pennsylvania Election Code was amended by Act 77 to allow voters, as an alternative to in-person voting, the option to vote by mail if they so choose, without requiring them to provide a reason for doing so, as is required to obtain an absentee ballot. Thus, a registered voter may request either an absentee ballot, if applicable, or a mail-in ballot, which is then sent via U.S. mail to the registered voter's address. After the registered voter has completed the ballot, the election code requires the voter to place the completed ballot into a secrecy envelope, place the secrecy envelope into a ballot return envelope, and then fill out, date, and sign the declaration printed on that outer envelope. Once the ballot return envelopes are received by the local boards of elections, they are time-stamped, and barcodes on the return envelopes are scanned into Pennsylvania's statewide computerized SURE database of all registered voters, which logs the date and time they were received by the Board of Elections. Under current Pennsylvania law, except for individual counties with notice and cure procedures, if a return envelope lacks a handwritten date or provides an incorrect date, boards of elections discard and do not count the ballot within. We granted review to consider whether discarding ballots whose return envelopes lack a date or have an incorrect date violates the Free and Equal Elections Clause of our Commonwealth's Constitution, and if so, whether the Non-severability Clause in Act 77 requires invalidation of the entirety of that act. Good morning.
Good morning, Chief Justice Todd, and may it please the Court. John Gore for Appellants, Pennsylvania Republican Party and Republican National Committee. I'm joined today by my co-counsel, Ms. Kathleen Gallagher.
We usually see Mr. King from Butler.
I wish he were here as well, Your Honor.
Please proceed.
Thank you. Over a century ago in Winston, this Court unanimously adopted a clear rule that it has adhered to ever since. The General Assembly's neutral, generally applicable rules for how voters complete and cast their ballots do not violate the Free and Equal Elections Clause unless they make voting so difficult as to amount to a denial of the franchise. That is a high standard, and this Court has never invalidated a neutral ballot casting rule under it. Appellees in this case do not even meaningfully engage that standard. They do not argue that compliance with the declaration mandate or its date requirement component is so difficult as to amount to denial of the franchise, nor could they. There's nothing objectively difficult about completing the declaration or filling in the pre-printed date boxes on the ballot return envelope. In fact, following the Secretary's redesign, the compliance rate with the date requirement hit 99.77% in the 2024 general election. The compliance rate has always been exceedingly high and exceeded 99% since the enactment of Act 77. And for voters who do not want to comply with the date requirement, they can simply vote in person. The date requirement does not apply to in-person voting, which is the most popular method of voting in Pennsylvania.
Just to clarify, it's usually not a question of a voter not wanting to comply. It's usually a mistake.
Certainly, Your Honor, but if a voter wants to avoid the requirement entirely, the voter can simply vote in person, which is the most popular method of voting here in Pennsylvania. That's the end of this case. Appellee's free and equal elections claim fails. Appellee's response to this is to ask the Court to adopt a radical reinterpretation of the Free and Equal Elections Clause and to turn the clause into a judicial blue pencil for rewriting the election code. Appellees would have this Court extend strict scrutiny to every word, phrase, and provision in the election code that bears on how voters complete and cast their ballots, no matter how mundane. This Court has already rejected that approach in prior cases, and with good reason. It would turn that judicial blue pencil into a virtually automatic revision of the election code and open the floodgates to litigation on every word and phrase in the election code. The General Assembly's legislative power to make the rules of elections would be transferred to the judiciary, and this Court would sit as an election super legislature in a deluge of cases. And to top it all off, Appellee's requested relief would trigger Act 77's non-severability provision and invalidate the grand political compromise that gave Pennsylvanians the convenience of universal mail voting in the first place. The Court—
That's well said, and I have no idea how we're going to ultimately view your argument. But the fact that the Pennsylvania Supreme Court is charged with the obligation to construe the provisions of our state constitution does not mean that we would be acting as a super legislature.
I take your point, Your Honor. I think my point was that if the court were to adopt strict scrutiny, as the appellees invite it to do, it would be hearing a deluge of cases, and in that sense would be rewriting the election code all the time, because
what is this deluge of cases we would be asked to decide if we adopted a strict scrutiny?
take this case as an example, Justice Donahue.
Litigated. So put
Correct.
the
Okay.
where is this deluge?
There could be challenges to any provision or any phrase in the election code under strict scrutiny. So, for example, requirements around the signature on the mail ballot, requirements for filling out the declaration, requirements for voting in person, requirements around provisional voting, including signature requirements, including requirements around poll books. The election code sets out a detailed and reticulated scheme for how voters complete and cast their ballots. There could be challenges about polling place locations, polling place selection, polling place hours. Anything that's in the election code that bears on how voters show up to the polls or receive a ballot, complete it and cast it, would be within the purview of the challenges here. The point is that applying strict scrutiny to the election code is something this court has already declined to do. It perhaps said it best in the Byrd case at 713 A. 2nd 1107, where it said that, of course, voting is of fundamental significance in our constitutional order, but to extend strict scrutiny to every voting regulation would tie the hands of states seeking to assure that elections are operated equitably and efficiently. This court has never extended strict scrutiny to a claim brought against a neutral ballot casting rule under the Walsh Standard. It didn't do that in Winston. It didn't do that in Pennsylvania Democratic Party, even though it recognized the right to vote is fundamental. It didn't do so in last year's case in Walsh. And doing so would, again, open up the floodgates and erode the General Assembly's legislative power to enact election laws. The Secretary attempts a variation on that theme. The Secretary argues for something resembling more along the lines of rational basis scrutiny. Again, that is not an approach this court has taken. This court has simply looked at the Winston standard of whether the rule itself makes voting so difficult as to amount to a denial of the franchise. Rational basis scrutiny, again, would erode the General Assembly's authority in this area and subject it to judicial review and potentially open this court to hearing cases and cases about the election code. But even if this court were to adopt rational basis scrutiny, the date requirement would easily satisfy it. Look no further than the state's anti-fraud interest. The state doesn't even need to have evidence of fraud within its borders before it can enact measures to deter, detect, and punish voter fraud. But here we have a live example from the Mahaliak case. That was a case in which the date requirement was used to identify fraud when it happened. Now, their response is to point out that the ballot in that case wouldn't have been counted anyway because the individual in whose name the ballot was returned had already passed away. And that's correct. But that alone did not give a basis to suspect fraud. It was only because the outer envelope had been dated with a date after the decedent had passed away that there was a reason to suspect fraud and open the investigation. Fraud was discovered, and the fraudster was criminally sentenced. That alone is sufficient to justify the date requirement. That is, you're correct, Justice Donahue, that they identified that the ballot was invalid and shouldn't be counted. And it was not counted. That's correct. But that would have happened regardless of whether there was fraud or not. It was only because the date requirement that the fraud element of the case was detected, ultimately prosecuted, and resulted in a criminal sentence. But all of that is beside the point, because what the court should do is adhere to its consistent precedent from Winston through Walsh and simply examine whether the date requirement is so difficult to comply with that it amounts to a denial of the franchise. That hasn't been seriously argued here, and it certainly hasn't been shown, because the date requirement, like the broader declaration mandate, is not objectively difficult to comply with. It can be avoided through in-person voting, and even among voters who choose the convenience of mail voting, the compliance rate is exceedingly high, as I said before. Now, appellees also dispute that this court already decided the question in Pennsylvania Democratic Party, but they even recognize on page 42 of their brief that the question of the constitutional validity of the date requirement was antecedent to the remedial question that was presented in Pennsylvania Democratic Party. I'll also point out that what they're seeking in this case, or what they now say they're seeking in this case, is identical to what the petitioners sought in Pennsylvania Democratic Party. They say they don't want to strike the date requirement from the election code or remove the date field from the ballot. They just want relief from enforcement of it. They want the date requirement not to be enforced. That's exactly what the Pennsylvania Democratic Party petitioners wanted. They wanted a remedy of notice and curing from the date requirement. So Pennsylvania Democratic Party is on all fours with this case, even if the court does not believe that the antecedent question was resolved there, as we've argued in our briefs. Ball also addressed free and equal elections clause arguments with respect to the date requirement. Now, they've pointed to footnote 156 from the Ball opinion, which was joined by 3 justices. But that footnote was addressing a different free and equal elections clause issue than the one we have here today. In that case, recall that there was a group of voter petitioners who argued that counting other voters' ballots that did not comply with the date requirement would somehow violate the petitioner's free and equal elections clause rights. And the 3 justices were simply expressing the view that that wasn't correct. So either this court in Pennsylvania Democratic Party and Ball did address and consider the free and equal elections clause's application to the date requirement and resolved it in favor of the appellants, or it didn't address it, and we still win because of the Winston and Walsh standard being the governing standard, and this being a requirement that's not so difficult to comply with as to amount to denial of the franchise. I would like to address a couple more points on the first question, Your Honor. First, the appellants have argued, or the appellees have argued a couple of things. They've said that the date requirement must be unconstitutional because it results in a certain number of ballots being rejected every election. But that's not the Winston test. The Winston test examines the burden or difficulty of complying with the rule. It doesn't address the consequence of noncompliance with the rule. It doesn't consider what happens when voters fail to comply with the rule. If it did, then every mandatory rule in the election code would trigger scrutiny under the free and equal elections clause. And that's not what this court's jurisprudence holds. They also argued that the right to vote is fundamental. We agree with that. But the fundamental right to vote is not a right to be exempt from the rules. It's not a right to an exemption from neutral, generally applicable rules for making a ballot effective. And as this court held in Berg and other cases, the fact that voting is a fundamental right does not mean that strict scrutiny should apply here. I'd also like to briefly address the Third Circuit panel opinion in Eakin, which I know has been brought to this court's attention. That decision actually proves our point. It proves our position that the appellee's free and equal elections claim fails. Even the Third Circuit panel agreed that any burden imposed by the date requirement is minimal. So the Third Circuit panel has likewise confirmed that the rule does not make voting so difficult as to deny the franchise. The Third Circuit panel also recognized that the date requirement does advance Pennsylvania's anti-fraud interest, as evidenced by the Mahaliak case. So if there's any doubt on that score, the Third Circuit panel decision actually supports our reading and our construction of the date requirement and the state's interests that are advanced by it.
Are you going to discuss the holding of the Third Circuit?
Yes, I'm getting to that now. If the court is interested in the holding on the Third Circuit, there's no basis to follow that panel decision here. for a couple of reasons. First, it's not final. We have petitioned for rehearing en banc just yesterday, so has the Attorney General. We expect that the Third Circuit will rule on that at some point, and there may be further appellate proceedings even in the United States Supreme Court. Even the Third Circuit panel, however, recognized that its decision implicates multiple circuit splits under the Anderson-Burdick framework. It implicates a split on whether rational basis scrutiny applies. It implicates a split on whether states and defenders of election laws are required to adduce evidence in support of the state interests. It also implicates a split about the proper standard of review under Anderson-Burdick and whether Anderson-Burdick even applies to mail voting and to regulations when there's an alternative method of voting. The appellees have also argued that the Anderson-Burdick framework is not the same as the standard under the Free and Equal Elections Clause. We agree with that. The standard is the Winston-Walsh standard. The standard is whether the rule makes voting so difficult as to amount to a denial of the franchise. They failed to show that here. The Third Circuit decision actually confirms that on the facts, and so there's no basis to follow the holding or outcome of the Third Circuit in this case. Which was that the date requirement violates the Anderson-Burdick, the federal constitution under the Anderson-Burdick framework.
Thank you.
Now let me turn to the second question asked by the court. Act 77's non-severability provision is clear, and it is clearly applicable in this case. It states, if any provision of this act or its application to any person or circumstance is held invalid, the remaining provisions of this application or applications of this act are void. The non-severability provision covers Section 8 of Act 77, which is what created mail voting and extended the date requirement to it. So any order holding invalid the application of the date requirement triggers the provision. That is what we have here in the Commonwealth Court and in the Court of Common Pleas.
Was there any time limit to the applicability or enforcement of that provision?
Not with respect to the non-severability provision, Your Honor. There was a special jurisdictional provision to bring certain challenges before this court on direct review.
180 days.
Within 180
so
days.
Why doesn't that apply as well to assertions of severability?
Because there was no, within that 180-day period, there was no invalidation of the act or its application that would have triggered the non-severability provision.
Okay, so what happens then? The Act 77 is actually, it becomes part of the election code at that point, right?
It is an amendment to the election code, that's correct.
Right, it is now a part of the election code,
Yes, that's correct.
right? And what is the general approach to severability as to the election code?
The general approach, which again is consistent with what the General Assembly prescribed in the Statutory Construction Act, is that provisions can be severable if they can stand independent, if the rest of the act can stand
Right,
independent.
so how do we square that with your position on severability?
A couple of ways, Your Honor. First, the fact that it's an amendment or a merger under the cases we've cited in our brief doesn't mean the non-severability provision from Act 77 disappeared. In fact, what the Statutory Construction Act directs and what this court's cases have held is that both a specific statutory provision prevails over a general one and that a later enacted statutory provision prevails over an earlier enacted one
Does
in the
that
event of a
specific,
conflict.
I'm sorry to interrupt you, does that specific provision actually survive after the 180 days and after the Act 77 is just now part of the election code?
Oh, yes, it does. There was nothing about the non-severability provision that limited it to the 180-day period or said that it would go away during the merger, after a merger or amendment into the election code.
But after the merger, doesn't that provision conflict with the prevailing provision on non-severability?
I don't believe that it does, Your Honor, because it only applies to the Act 77. So the general severability approach in the election code survives for everything else. And then we have a specific later enacted provision that governs the Act 77 provisions. And so those two can actually be read in harmony with each other. But to the extent there were any conflict
It's
between
hard
the
for
two.
me to see how they can be read in harmony when they say opposite things, but maybe you can explain that to me.
Well, they can be read side by side because the general provision, as I mentioned, can apply to the rest of the election code as the default rule. And the General Assembly adopted a specific rule for just those provisions within Act 77. If that weren't the case, then the General Assembly could never adopt an amendment-specific non-severability provision, which of course is exactly what it wanted to do and needed to do in Act 77 as part of the political compromise that led to universal mail voting here in Pennsylvania.
Let me ask another question about severability. Whose decision is it ultimately as to whether a provision is severable or non-severable? I mean, the legislature has said in Act 77 one thing. Does that compel the court to construe it that way, or is this the court's decision as to whether severability applies or not?
Well, obviously, we're here before the court asking the court to make a ruling on that. We believe that the non-severability provision is binding and enforceable on the court, that the court should enforce it.
Based on what do you believe a provision of the legislature regarding severability or non-severability is binding on the court?
I think this court said in Stilp that as a general matter, non-severability provisions are enforceable. It's consistent with the Statutory Construction Act to enforce the non-severability provision here because the General Assembly's intent was clear from the language. There's no ambiguity as to what the General Assembly was trying to accomplish. And that's consistent with this court's case law, including in Stilp, where the court pointed out that non-severability provisions can be informed by political compromises, and that's exactly what we had here in Act 77. The non-severability provision, as we've shown, was integral to the political compromise that was brokered in the General Assembly and that gave Pennsylvanians the convenience of universal mail voting.
Okay, can you distinguish for us the difference that the Appellees are relying on, the difference between the severability, the provision that you're seeking, the provision you're arguing about in terms of it being severed by its language being severed, or just the remedy or penalty? Is that still the same issue, or are those two issues separate? That wasn't a very clear question. I'm sorry, but do you know what I'm asking?
Let me do my best, Your Honor,
Okay.
and I'm
If
sure
not,
you'll correct me. The relief that they seek here does trigger the non-severability provision. They've said they're not seeking to strike the word date
They're
from
okay
the statute.
leaving the language, not severing the language, but attacking the penalty.
The enforcement of it, right. But the non-severability provision covers that because it says if any application to any person or circumstance is held invalid, then the remaining provisions and applications of the Act are void. And that's exactly what we'd have here. An injunction against enforcement of the date requirement is an injunction against its application to a particular ballot or circumstance or voter.
Is that different, though, than applying a penalty? I mean, you can perhaps say the provision exists, and yes, we recognize it's enforceable, but we're not going to penalize the voter. Is there a way to distinguish those two things?
I don't believe that there is, Your Honor, and I think in Ball, this court already held that as a matter of the statute, the date requirement is mandatory. So to now come in and preclude or order or enjoin enforcement of that requirement is enjoining an application of Act 77 that triggers the non-severability
I guess it comes down
clause.
to the question of can it be mandatory and yet the penalty not be enforceable?
I don't believe that it can. I think mandatory means mandatory and that there's an enforceable consequence for
But
noncompliance.
does mandatory always have an enforceable consequence?
As far as I understand this court's jurisprudence in the election code, yes, that's correct. They make a couple of other arguments on the non-severability provision as well that I'd like to briefly address. They argue that enforcement of the date requirement doesn't happen through Act 77, but instead happens through the declaration sufficiency provision in Section 3146.8. But this court already rejected a similar argument when the Secretary advanced it in Ball, and it should do so again here. 3146.8 directs election officials to determine whether a declaration is sufficient, but it does not say what makes the declaration sufficient. That comes from Act 77. So determining that a declaration is sufficient, even though it doesn't comply with the date requirement, is again holding void the application of the date requirement to a particular ballot or circumstance. Moreover, their reading of 3146.8 simply proves too much. Under that reading, election officials making a sufficiency determination could ignore other of the General Assembly's requirements for declarations, like the signature requirement or the requirement that the declaration be filled out. And appellees are also incorrect when they say that the declaration sufficiency provision is outside of Act 77's non-severability clause. Act 77 specifically amended the declaration sufficiency provision to bring mail-in ballots within its ambit. It had to, because those ballots hadn't existed prior to 2019. I've addressed already their amendment and merger argument. They pointed to the Stilt case, as I've mentioned. That case actually bolsters our position because it holds that non-severability provisions are enforceable as a general matter. The reason the court did not enforce the non-severability provision in Stilt is that it was basically a poison pill. It eroded the independence of the judiciary and its institutional interests by tying judicial compensation to unconstitutional expense reimbursements sought by the General Assembly.
Doesn't your interpretation do the same thing? I mean, we have judicial elections in Pennsylvania and retention elections.
Certainly, but if that were the case, then the court would be facing that all the time in these election cases. And it's not the same kind of interim effect here because it's not the institutional independence of the judiciary. The judiciary still maintains its independence even under Act 77. That was not the case in Stilt. It was a poison pill in an attempt to force the judiciary to approve an unconstitutional statute.
How do we maintain our independence in terms of our exclusive authority to interpret the Constitution if the legislature can tell us how to do that?
I don't think the legislature is telling the court how to interpret the Constitution. I think the court has made clear how it should interpret the Constitution, so we agree the court shouldn't even have to reach the non-severability provision because it's said clearly in Winston through Walsh that rules like these are constitutional. But what the General Assembly has said is that if there is a determination that something is invalid, there's a consequence for that. This is the remedy. The remedy is if the entire act goes, and that was part of the political compromise the General Assembly reached. If there's any interim effect here, it would be from not enforcing that non-severability provision. The General Assembly would be chilled from adopting new election innovations, and it would be chilled from entering into political compromises and using these non-severability provisions to do so. They also claim that it would be messy to invalidate Act 77 and to take away the convenience of mail voting. We certainly agree that it could be. There were later amendments to the Act. The General Assembly could have addressed what it wanted to happen with those things. It was aware of Act 77's non-severability provision at the time. It did so. But we agree that the court should not trigger the non-severability provision because the court should uphold the date requirement as constitutional under the Free and Equal Elections Clause following its unbroken line of cases from Winston through Walsh. I'm happy to answer any further questions the court may have.
Any other questions for Mr. Gore? Well argued. Thank you. We'll hear from, let's see who is next. Mr. Graham.
We ask the court to reverse.
We inferred that. Thank you.
We figured it.
Good morning. Madam Chief Justice, and may it please the Court, my name is Brett Graham. I serve as a Deputy Attorney General, and I represent the Commonwealth in this appeal. I want to be very mindful of this Court's instruction about not repeating argument made by Mr. Gore, but if I may, I'll offer a brief framing of the argument. There are slight differences between the way in which Mr. Gore and I have argued this case. Chiefly, We rely less upon the quote-unquote Winston standard, and we ground our interpretation in the text and history of the Free and Equal Elections Clause. Act 77 requires a de minimis, neutral, dating, handwritten date of an outer return envelope, and as a result, elections are no less free and no less equal in Pennsylvania. We look to the text of the Free and Equal Clause and this court's history with it. This court has offered a very robust interpretation of the clause, but it has been equally steadfast in recognizing that the task of effectuating the clause's mandate lies with the legislature. And specifically over the course of the past several years, this court has reminded us the so-called technicalities of the election code must be strictly enforced. When there is no ambiguous text within the election code, the interpretive canon offered by the Free and Equal Clause has no relevance. That was this court's holding in Walsh. My friends on the other side sort of bypass in Ray Scroggin and the provisional ballots case in 2024 Walsh, because their view of how to treat this unambiguous mandatory election code language cannot be squared with those instructions. Indeed, in case after case, this court has been satisfied for free and equal purposes that the legislature is putting every voter in the same position, that each voter has the same opportunity to cast a ballot, and that they must satisfy the same conditions. That's this court's holding in Auten, in Winston, in Shanky, and it continues on. Even in League of Women Voters, the crux of the matter was the opportunity to cast a ballot. Again, I would emphasize that the Commonwealth takes a bit of a broader view than the RNC in this case, because the way that we run elections is constantly changing. As this court has recently noted, the Australian ballot did not appear in Pennsylvania until 1892. The method by which everyone in this room is familiar with voting was foreign to Pennsylvanians at the time the Free and Equal Clause was adopted. As a result, this is a much broader and much more foundational guarantee. I'd also like to briefly address the facts of this case, in which one of the voters, Kinnery, specifically was afforded an opportunity to cure a defect on her ballot, but did not do so, as the Commonwealth Court recognized, in reliance on a now vacated Commonwealth Court decision. Elections and the application of the election code, I'm sure this court would agree, benefits from very clear rules. And to the extent there has been confusion over the last several years, as Mr. Gore stated, that confusion has largely been ameliorated by clear directives from courts and by a redesign of the declaration form and the declaration requirement. The Commonwealth Court erred by not only looking to these statutory construction cases, which are an apposite, but also by allowing the materiality provision question that this court addressed in Ball to sort of drive its analysis of government interests and burdens. I would reiterate what Mr. Gore said. I know I said that I would avoid that. But the Commonwealth has sought a petition, has filed a petition for rehearing en banc in Aiken, and we believe that panel decision to be contrary to a whole host of applications of the Anderson-Burdick standard.
Counsel, is it your position that the Free and Equal Election Clause does not generally protect the franchise?
Not at all, Your Honor.
Then why are the cases involving statutory interpretation irrelevant for our consideration? Because those cases are driven by protection of the franchise.
They are driven by that, Your Honor, but then they arrive at an ambiguity in the election code. There are two.
Not necessarily. I mean, those canons that we've applied for well over 100 years are often have been used in unambiguous statute situations, because the purpose of the construction is to determine whether the franchise is being infringed upon.
Your Honor, I'm not aware of cases, at least not those cited by the Commonwealth Court or by my friends on the other side, where the interpretive canon that stems from the Free and Equal Clause has been applied to unambiguous language. And as we go through it,
How about the statute that required the use of a specific color pen in filling out a ballot? That was unambiguous.
It was unambiguous. Well, one thing I would point out, Your Honor, is that that postdated the enactment of the Statutory Construction Act, which at least...
Yeah, that's sort of an interesting point. The Statutory Construction Act has always started with the proposition that we're driven by the text of the legislation. That nothing new happened in the revision to the Statutory Construction Act to change that basic precept.
No, but at least conceivably, Your Honor, the Statutory Construction Act should change how this court approaches those questions rather than looking to the intent, the purpose, or whether or not something could be dismissed as a minor technicality.
Even when the constitutional overlay is intended to protect the franchise for the citizens of Pennsylvania.
Correct, Your Honor, because that constitutional overlay, if you go back to its origins and the way that it's been treated, has been about access and proportionality. It has been about, is the General Assembly, when carrying out its constitutional prerogative to regulate the franchise, is it interfering with the ability of any particular group, any particular subsection of society to participate, or is it counting votes? Is it not giving the same return to the same political activity? We do not have that in this case. Indeed, if the Commonwealth Court is to be believed, the real class of people at issue here is just people who are capable of forgetting things, which is quite a large class. In both Aiken and in this case, there have been suggestions that the burden of the date requirement falls on certain populations more so than others, and statistically that has not been borne out. Indeed, any voter can comply with the date component, and I think it's relevant here. Another way in which the Commonwealth Court erred is that we don't generally look at statutes or instructions in isolation. And so I think it is erroneous here to look at the specific command date as if it is independent and freestanding, when this court's guidance in Ball was clear. There is a phrase there, fill out, date, and sign. It is a comprehensive process. The election code instructs voters to do it in secret.
Counsel, isn't your argument premised on the proposition that the date services some reason, that there's a purpose for it? If we conclude otherwise, how can we then hold that the counties must enforce that provision by way of its sufficiency review when we also conclude it serves no purpose? How does that protect the franchise?
I'll take your question in two parts, if I may, Justice Donahue. First, the date component of the declaration requirement does serve state interests. It signals to voters when they have completed all necessary steps.
Just assume for the sake of my question that we conclude otherwise. I have no idea if that will be the case, but assume it is.
Okay.
Then what?
Fair enough, Your Honor. Assuming that the date component serves no purpose, I don't believe that's the end of this case, largely because the Free and Equal Elections Clause has never been understood to immediately skip to interest balancing. As I mentioned at the beginning of my presentation, this court has taken a very robust view of this clause, and if you read through free and equal jurisprudence, at no point has the court said it's okay that elections are slightly less free or slightly less equal in service of some government interest. The tiers of scrutiny, interest balancing, equal protection paradigm that goes back to Caroline Products footnote 4 is really sort of out of place when you talk about the Free and Equal Elections Clause, which is a narrow promise. In terms of whether or not it serves a purpose, again, I would point to the overarching function of the Free and Equal Clause, which is who decides? Who decides what is mandatory? Who decides what is a technicality? And time and again, this court has said this is the legislature's doing. I would point to, as I do in one of the articles cited in my brief, James Wilson, who authored this clause, at least arguably authored the clause, in a long and discursive essay on the Pennsylvania Constitution of 1790, where he inserted this clause, and on the U.S. Constitution. He comments on the unsuspicious disposition of the new federal government towards state legislatures, and says that this is a generous and wise decision, that they have given such extensive power to the states to regulate their own franchise, because in regulating their own franchise, they regulate their own sovereignty. Here, I'm not sure what lesson the General Assembly could take if the Commonwealth Court and its disposition is affirmed, because...
Counsel, if there's no purpose to the requirement, I struggle with how an election can be free if the legislature can insert a trick that later ends up in a ballot not being counted.
Your Honor, I would push back on two elements. Once again, I will remind the Court of our position that the state component serves a purpose.
I understand that. And as I said, I have no idea what the consensus of the Court is on that. I'm just asking you to pursue this on the assumption that there is no purpose.
Absolutely. And I would also separately push back, Justice Donahue, on the idea that it is a trick. It is a very simple instruction. It's today's date, something that every voter has access to. And indeed, one of the interesting parts of the Third Circuit panel's opinion in Aiken is that littered throughout Judge Smith's opinion is he says that it might be discounted. A ballot might be thrown out, possibly could be thrown out, because, as Chief Justice Todd noted in introducing the case, there is an outstanding question about notice and cure from this Court's pending disposition in Coalfield Justice. There are many other questions about how the Pennsylvania protects the franchise. I take your point, though, about...
Let me follow through with that. It's clear that someone whose ballot is at the moment that the sufficiency decision is made is voided because of failure to comply. Let's use a different example. Let's say there's no secrecy envelope.
Sure.
And if that voter knows that that has occurred, they can cast a provisional ballot.
Correct.
Genser. So where does Coalfield Justice take you from there?
Coalfield Justice, in terms of whether or not there is a procedural due process right or a Shore system automatic email or anything else that might provide the voter another opportunity to cure a defect, is certainly relevant in determining whether or not this is really a trick, as Your Honor sort of alluded to. The idea that this is, a stray pen mark, an accidental slip of the hand could result in a ballot not being counted. That at least factors into the analysis I would submit to this Court. But
and you would say Genser plus a decision that you've alluded to in Coalfield Justice would indicate that there is no deprivation of the franchise? I
would argue that it colors this case, and it makes even more clear that the date requirement is neutral, generally applicable, and that it refocuses the inquiry, as this Court had it in League of Women Voters, on the concept of opportunity. I referenced a little earlier the introduction of the Australian ballot, but it bears mention that beforehand, elections in this Commonwealth were run very differently. And our view of the Free and Equal Elections Clause is that it is good for all eras, it is good for all systems. And so pinning it to a particular analysis under the federal materiality provision or understandings of how rational basis review or strict scrutiny apply is sort of odd in our view it would be an outlier, let me put it that way. It would be an outlier in terms of this Court's jurisprudence.
But this would be a case of first impression, would it not, under the Free and Equal Elections Clause?
We agree that this would be a case of first impression, and we do not suggest, as the RNC does, that this question was already, on all fours answered in Bookvar.
That was a good answer.
Yes.
Thanks very much.
Candor.
We don't necessarily think that the Court has answered this question, but really there's sort of window dressing and puffery around it that make it fairly easy. Scroggin, Walsh, these are cases in which the Court has clarified the relevance of the free and equal clause to statutory interpretation cases. And I'd like to comment briefly, if I may, on the burden analysis.
Could you go back, and I'm sorry to,
Yes.
I don't want to get you off track on your argument, but when Justice Donahue asked you some questions, she asked you to presume, for purposes of her questioning, that there was no purpose to the date clause. You seemed to indicate earlier that you thought there was some purpose. Now, we know that Pennsylvania has a system whereby the county election offices date stamp the ballot as it's received by mail. They date stamp the date it's received. We also know we have a statewide computerized system called SURE, S-U-R-E, which records the date and preserves that date. What is the purpose of an individual inserting a date? And you know from looking at the examples, sometimes people make mistakes. They put the date and they put their birth date, or they have the wrong date, or they forget the date. They don't put any date. I mean, there are reasons why people do forget, and it's human nature. People forget or people misunderstand and put the wrong date. And it's pretty common for someone, when asked for a date beside their name, apparently to put the birth date instead of the date. So given that we have those two procedures to determine the actual date that it was received, what purpose can it possibly achieve for the voter to insert that date?
Thank you for that question, Chief Justice Todd, and I'll begin where you did with the SURE system. I could have worn a belt and suspenders today to sort of give the court a demonstration of my next point, but I elected with just the belt. The SURE system is this Commonwealth's electoral scheme. It's the first line of defense. As a Third Circuit judge acknowledged when the materiality provision question was up there, it could fail or freeze. Many a lawyer prefers a belt and suspenders approach, and
It's not the only approach, though. We have the date stamping by the County Board of Elections as well.
sure, perhaps belt and suspenders and then another pair of suspenders. But that is one of the government interests. As I alluded to previously, signing and dating something, Your Honor, is a very commonly understood act of finality. It has sort of a ceremonial importance. And to the extent the election code instructs voters to comply with several steps, one after the other, signing and dating is sort of an act of finality that tells them, okay, I have completed all necessary steps and I can put this ballot in the mail. It is ready to go to the county board. Finally,
This is something that this court has recognized and the Commonwealth Court has recognized with regard to the dating.
correct, and that's the sort of legislative judgment, Your Honor, that it's sort of hard to attack because it's based on.
I guess my point is it's a hard question for you to answer because you didn't vote on the legislation and you weren't the governor that signed it. So it's kind of difficult to put ourselves in the minds of the General Assembly and why they put something in, given there's a presumption of constitutionality that attaches up front. But I'm curious, in response to your question from the Chief Justice, this idea that somehow the date requirement relates to the timeliness of the ballot. I'm not sure that's true. I know that's a big debate that has happened in these cases as they've wound through the federal system, but we're not dating the ballot. This is not about establishing the date of receipt of the ballot. This is a verification. It's a verification, like we all sign verifications, affidavits, what have you, where someone is attesting to certain facts, right?
Correct.
This is an outside, it's on the outside envelope. It could have easily been a separate piece of paper, but it's on the outside envelope, and it's saying, I verify A, B, C, and D, I forget how many paragraphs there are, signed, blank, dated, this date. So what does that have to do with whether the ballot is timely received or not?
Your Honor, my point in bringing that up to this court is twofold. First, this is not the materiality provision question, and we are not limited to considering government interests in terms of timeliness, qualification, and receipt. That was sort of the narrow focus of the federal statutory question in Ball. We can look beyond that to beyond the do we count this vote on this particular day, we can look to the hypothetical possibility that Plan A doesn't occur, and that...
I guess my point is the question, I think, is what is the purpose of dating a verification? That's the question. And it would seem to me that again, trying to hypothesize what possibly was in the governor's mind and the legislature's mind when they did this, one purpose would be, which I think is consistent with how we do affidavits, is because I am attesting to certain facts, I need to put the date down to show that it's as of that date that I am attesting to these facts, because those facts could change. They could change in the future, something could happen, but on that date, I am attesting that these facts are correct.
Correct. That is a perfectly succinct explanation, Justice Brobson. That I would merge a little over with the fraud interest, the interest in protecting against and prosecuting fraud, and I was trying to, cabin my answer to this question about timely receipt of ballots. But let me take this segue and talk a little bit about fraud. My friends on the other side sort of have a refrain that the date component serves no purpose. But if you then read later on in the brief, what they usually mean is it serves no purpose for the timely reception of ballots, the counting of ballots on Election Day.
You have to agree to that extent, they're correct.
To the extent that the Shore system is functioning properly and there are no other emergencies, statewide emergencies that would displace county boards, et cetera, yes, I would agree with that representation from my friends on the other side. The point being, though, that the Commonwealth's interest in protecting the election scheme extends beyond Election Day. And the Mahaliot case demonstrates that the handwritten date could be relevant to a fraud prosecution.
How many fraud prosecutions have we had on voting in Pennsylvania?
Not many, Your Honor, but the United States Supreme Court has been very clear in this guidance, in terms of this guidance in Crawford, where it upheld a voter ID statute from the state of Indiana, absent any evidence of any voter fraud at any time in Indiana history. Because what the court said was the state does not have to wait for there to be injury to its electoral scheme in order for it to act to preemptively protect its scheme. And so where some may quibble with the Mahaliot example to suggest, well, how helpful was it really to the prosecution? Could it be these are all sort of hypotheticals, and going back to Justice Brobson's point, sort of beyond our purview as lawyers and judges, because we're now getting into the judgment of what could happen and what might happen. And again, another theme in this court's free and equal case law is that you do not dismiss a legislative judgment because it is unwise or of doubtful expedience.
Is the purpose to prevent fraud or prosecute fraud?
Prosecute is probably the better word there, Justice Donahue. I would not use the word detect, but prevent, there is sort of a deterrent nature to prevention.
Because the Shore system prevented fraud.
The Shore system prevented a fraudulent ballot from being counted.
Right.
It did not, the Shore system does not have any prosecutorial authority to go after the person who committed the fraud. That rests with the sovereign. And in that case, without a handwritten date, or without any evidence whatsoever, for instance, if this court were to say, you don't have to date it, those prosecutions become, at least conceivably, more difficult for the Commonwealth. Because
and again, we're not aware really of any of those prosecutions. To go back in recent election years, I can't recall all the specific cases, but we certainly have had a lot of cases where this issue was raised and this potential for fraud in Pennsylvania elections was argued, and I don't recall there ever being any evidence that fraud was a problem or a significant issue in Pennsylvania elections.
Well, I would
That
submit.
wasn't a question. I'm sorry, that was more of a statement.
No, that's okay,
Do
Justice
you
Todd.
agree? Question mark.
Do I agree? Chief Justice Todd, I'm not aware of any cases in which the government interest in fraud was presented to this court and the law at issue was a neutral, de minimis, non-discriminatory ballot casting
You
rule.
just rephrased my question, though. My question was, do you recall there ever being any evidence presented to this court where we opined that there was indeed a problem with fraud in elections in Pennsylvania? Because I don't recall that.
I don't recall that, Your Honor, but what I'm suggesting is if this court arrives at the conclusion that this case turns on whether or not fraud is a legitimate interest absent evidence, that question has been answered. And this court has essentially answered it by repeating over and over again that the task of devising an electoral scheme falls with the legislature. In summation,
Counsel, before you sum up, can I
Sure.
just ask, assuming for the sake of argument that this court finds the dating requirement to be a burden, a minor burden, what standard of review do you think is applicable to a free and equal election clause violation or claim? I mean, do you think the Commonwealth got it right when it applied strict scrutiny, or should it be some kind of lesser standard?
I don't think that the Commonwealth Court got it right in applying strict scrutiny, Justice McCaffrey, because as this court recognized in Berg and again in Banfield versus Cortez, there is always this, push to get every election rule subject to strict scrutiny, and courts have recognized over and over again to do so would tie the hands of the legislature, would tie the hands of the General Assembly. And I think drilling down on the theory of injury in a given case is essential. Because in this case, what we're dealing with is not really the entitlement to vote or the qualification to vote. It is compliance with the election rule and the manner of voting, which is another theme from this court's case law. So to the extent tiers of scrutiny apply at all, I think we would have to begin from the premise that 99.77% of individuals regularly comply with this requirement, and that the burden on the voter, the effort required of the voter is really quite minimal. Again, there's a series of steps going on here, and the nub, as Justice Brobson would say, the nub of this case,
Catch on.
I listened yesterday.
Catch on quickly.
The Brobson doctrine.
You said that once. You said it once.
I heard nub a couple of times yesterday, respectfully. More than once.
We got our first Brobsonianism.
Yeah. But the nub of the case is really about the simple effort required of the voter to move the pen over to the date field. And just to color a bit your question earlier, Chief Justice Todd, about putting down your birthday or anything like that, again, in the record here, evidence from the state that they have redesigned it. It now starts with a year 20, two spots for the year. But to finish my answer to you, Justice McCaffrey, when you're dealing with a non-discriminatory regulation that poses such a small amount of effort for the voter to comply, rational basis seems like it would be the most appropriate because there's no evidence or indication that a particular group is being disadvantaged, and thus there is no interference with our electoral process.
All right.
Unless there are any other questions, I will thank the court for its time and urge you to reverse.
Thank you. Good argument.
Thank you.
Thank you.
Thanks.
Very well done. We'll now turn to the appellee's argument. I'm surprised that Mr. Levine isn't jumping from his seat, but apparently,
I think he wants to.
apparently for a change, we don't have Mr. King or Mr. Levine, so we will go with Mr. Loney. Welcome.
Apologies for that, then. Good morning, Chief Justice, and may it please the court. Stephen Loney of the ACLU of Pennsylvania. I represent the voters in this case, Susan Kinnery and Brian Baxter. And if I may, just a couple of quick notes before I begin. One is I would like to acknowledge Ms. Kinnery's presence in the courtroom, front and center in the gallery, and also note that Mr. Baxter had planned to be here today, but unfortunately passed away before the hearing. Another quick bit of housekeeping, just to let you know how we've split up the argument on this side of the room for efficiency's sake. Each one of us is going to address a different part of the merits of this case, and I will address the second question presented on severability. So I will first focus on the nature of the fundamental right and the standard to be applied where there's an infringement on the right to vote. Mr. Volchak, on behalf of the intervener appellees, will address the application, specifically the question of whether the enforcement of the date requirement furthers any legitimate government interest. He'll also address the question of whether this case is indeed on all fours with any prior case of this court. And then counsel for the Philadelphia Board of Elections, Mr. Fabens-Lassen, is going to provide the board's perspective on the process for administering elections and how mail ballots are processed with envelope dating errors. So I'll address my part of the merits and then severability before handing off to anybody else. This case, the nub of this case, is interference with voters' exercise of the right of suffrage. Two of those voters, Ms. Kinnery and Mr. Baxter, were eligible lifelong voters whose most fundamental rights as Pennsylvania citizens are at stake here. Our Constitution protects those rights. It provides that no power shall at any time interfere with or interfere to prevent the free exercise of the right of suffrage. And however you try to slice it, a practice of disqualifying votes for noncompliance with a meaningless handwritten date requirement interferes with, it diminishes the right of suffrage. And it's untied to any government interest, as you hear from Mr. Volchak. On that simple basis, we ask that this court affirm the Commonwealth Court's ruling, which would not invalidate any provision of Act 77 and therefore doesn't implicate severability. As this court acknowledged in League of Women Voters, which is the definitive case on free and equal elections clause, which we've heard far too little about today, the right of suffrage is among the Article I Declaration of Rights. Article I enumerating fundamental rights that are, quote, specifically exempted from the powers of the government to diminish. Again, we're here talking about a diminishment of the right. Now, it's undisputed that the voters here were eligible, registered voters who timely submitted their ballots. They signed the declaration. There's no suggestion of fraud. The only issue here is that they and thousands like them also did not handwrite the date next to their signature, or they wrote some date that somebody deemed to be incorrect. As a result, their votes were effectively screened out based on what has become a disenfranchisement trap, disenfranchising people, thousands of people, in every statewide election for the past 5 years. Now, given this court's mandate in League of Women Voters that the Free and Equal Elections Clause be given the broadest interpretation, of course, a rule that routinely disenfranchises people is subject to constitutional review.
Counsel, how is it, well, clearly, all legislation is subject to, all government action is subject to constitutional review. That's why we're here. But how does this case map onto League of Women Voters? League of Women Voters was a case where a outrageously gerrymandered map blatantly violated the Free and Equal Elections Clause. Here, how can you argue that a neutral statute is anything but free and equal? And how, if this interferes with the right to vote, how can you say that any provision of the election code can stand? Because by definition, under your argument, it would seem that having an election code necessarily interferes with this right to vote, which I take it you would maintain cannot be subject to any government regulation whatsoever. And how is that consistent with Winston?
Sure. I've heard a few questions in there, and I'll try to address them in turn. So first of which is that we're not arguing in any way that League of Women Voters is on all fours with the facts of this case. Certainly not. But the broad pronouncement of this court is instructive and controlling in that this court held the clause, the Free and Equal Elections Clause, not just the equal part, but the free part, shall be given the broadest interpretation, one which governs all aspects of the electoral process. And that's what I think the appellants are missing in their arguments, that there's a suggestion here that there's no constitutional standard to be applied if, under Winston, or at least their interpretation of Winston, if the restriction isn't so extreme as to make it impossible to comply with. And it's just
Impossible. There's less than 1% of the people who date their ballot or date it correctly, and their ballot's not counted. Does that mean that it was impossible? They messed up. It's like somebody showing up at the polls at 8:01 and they blew it. How is it any different?
No, Your Honor, I was not suggesting that this requirement is impossible. What I'm saying is that the suggestion that there be no constitutional review, that the Free and Equal Elections Clause does not apply at all unless the legislature imposes an insurmountable burden, cannot be squared with legal women voters. It can't be squared with the text of the Free and Equal Elections Clause or its intent to be radically democratic at the time.
Are you suggesting legal women voters overruled Winston?
No, Your Honor. In fact, legal women voters directly relied on and quoted Winston, and it provided the full quote, not just the part about requirements that are so difficult as to amount to a denial of the franchise. Both Winston and League of Women Voters, the full quote, stated that the Free and Equal Elections Clause applies to any regulations that deny the franchise itself or make it so difficult to amount to a denial or subvert or deny the franchise. We're dealing here with an outright denial of the vote, disqualification of votes, which this court has never allowed without compelling reasons. And Justice Weck, to go back to your question, I believe it was your opinion in Ball that for the purposes of the materiality provision, acknowledged that this very rule is a denial of the right to vote. Now, this court's precedents have always been clear that denial of a fundamental Article I right triggers strict scrutiny. And I'd like to engage with that debate about strict scrutiny.
Counsel, before you get into that, just as your opposing counsel's argument was based upon the assumption that there was a purpose for the dating clause, your argument has to be based upon the assumption that there is no purpose. I mean, we're not here arguing about secrecy envelopes.
Correct, Your Honor.
Okay, I mean, the purpose is clear, it's driven, there's a reason for it that's bound within various aspects of the election code. That's not what we're talking about. Your argument has to be based upon an underlying view that there's no purpose to this.
That is the argument in this case, Your Honor, and this particular requirement, as you'll hear more from Mr. Volchok, is uniquely without purpose. I mean, we're not here arguing about the signature requirement or the envelope requirement.
I'm just trying to channel your argument because there are certainly many requirements that have a clear and important and articulable reason under the election code. Your argument has to be skinny down to a situation where there is none of that.
Correct. There is no purpose. And to put a finer point on it, because I do want to address the standard to be applied in reaching that conclusion, our view is that there has to be a heightened level of scrutiny under the Free and Equal Elections Clause, that legal women voters, and this gets back to Justice Weck's first question, how this maps onto legal women voters. The court did the work in that case, did the Edmonds analysis, and concluded that in Pennsylvania, the Free and Equal Elections Clause provides greater protection over the fundamental right to vote than does the federal Constitution. So the suggestion that Eakin somehow cuts in favor of overturning the Commonwealth Court here is a little hard to fathom. The argument, as I understand it, is that because the Third Circuit and Eakin deemed this a minimal burden, then under Winston, that's not enough to say that it's impossible to meet, and so there is no constitutional review. Legal women voters stands for exactly the opposite, which is...
You're confusing something, though. None of us are up here saying there is no constitutional review.
Well, there's one person here who is.
What's that?
There is one person here who
No, there
is.
isn't. No,
Okay.
no, I disagree with you. I think what they're simply saying is we have the power to conduct constitutional review of a statute. You're disagreeing as the standard we apply and whether it's been met. But nobody's saying this isn't subject to constitution. We wouldn't be here if this was not subject to constitutional review.
Well, as I understand the appellant's argument, it's that Winston provides a sort of binary question, right? Either the requirement is impossible to comply with, and therefore invalid, or it's not, and therefore you don't have to engage in any other analysis. And
Their point is that is the constitutional review. They're saying Winston is the test of passing constitutional review. It's a neutral ballot measure.
And that's what I'm disagreeing with, Your Honor, is that is...
I understand, but I'm responding to your statement that somebody here is taking the position that there's no constitutional review. I mean, we put our best robes on. I mean, we're, you know...
I don't think anybody on this bench has
That's the nub of the problem.
I certainly, fair enough, Your Honor. I don't think anybody on this bench has suggested otherwise, but...
I don't think anybody in the courtroom is either. We have an argument, a good faith argument between the two sides on constitutionality. I don't think anybody said it's, well, why fight about that? Didn't Winston set forth the court's understanding of what the Free and Equal Elections Clause meant?
It did, Your Honor, and...
It also went on to talk about the plenary authority of the General Assembly in this area, which we've subsequently recognized time and time again. Is that correct?
Absolutely, Your Honor. And I'm just asking the court to look at the full scope of what the court said 100 years ago in Winston and then reapplied in League of Women Voters, which was it's not just a binary decision about whether a requirement is so difficult to comply with as to make it impossible or not, and that's period, full stop, end of analysis. That's no standard at all. What is required by this court's precedents is a means-ends analysis anytime a fundamental Article I right is being infringed, diminished.
If I may, just not to belabor it, but I just, on this League of Women Voters, this attempt to map, perhaps the reason we haven't heard much about League of Women Voters is that it's an imperfect mapping, because League of Women Voters, with which Ms. Gallagher is quite familiar, involve the opportunity of each citizen equally to have his or her vote heard, and to have the same meaning, the same voting power as other citizens, which was unconstitutionally diluted in that case. How does that have any bearing on the application of a neutral, non-discriminatory statute such as the one at issue here?
It's the broad pronouncements, Your Honor. Again, we're not suggesting here that the case is on all fours and has already been resolved by the League of Women Voters. What I'm relying on here is the broad pronouncements from League of Women Voters about what the Free and Equal Elections Clause requires, and also addressing the point that Your Honor pointed me to, which is the plenary power of the legislature to impose sort of neutral process rules around voting, which nobody is questioning here. But what we're questioning is when those rules result in the denial of the vote, then they must be analyzed under a means-ends test. That's
what is the General Assembly supposed to do when they craft neutral ballot casting rules? Are they supposed to put a footnote in there that says the reason why we're putting this in is X and Y and all this other stuff? Is that what they're supposed to do this? If this is how we're going to apply this Free and Equal Elections Clause to every neutral ballot casting measure, I'll take, for example, the requirement that not only the verification on the outside envelope be dated, but that it also be signed. This court has ruled that there is no signature matching requirement, which begs the question about why the signature is even required. Is that the next challenge, is because there's no signature matching that goes on, the signature serves no real purpose, and people forget to sign, and therefore it's a meaningless clause? Is that the next step here?
To answer your second question first, no, Your Honor, that is not the next step. I mean, we are not here challenging.
But why don't your argument hold water in the same thing? The court has said that, clearly it says fill out, date, and sign, right? So we're talking about the date part of the verification. This court has ruled that there is no signature matching requirement when they go to do the canvass, right?
Correct, Your Honor.
What purpose does a signature serve if there's no signature matching requirement to ensure that the ballot that is electronically connected to a particular voter matches the signature? If it serves no purpose, then we should strike it as unconstitutional under your means-ends analysis.
Well, just to zoom out for a second, if I may, Your Honor, I just want to note that I'm not in the position of the proponent of restriction on voting rights. But to answer your question about why we're not filing cases about the signature requirement is because it's meaningfully different in terms of its ability to be tied to a government purpose. And just to take one of the purposes being argued here about the date requirement, solemnity, even without just for the sake of argument, I will accept that that is a valid government interest, but our issue here is with connection to that interest. Whatever interest the government has in ensuring solemnity and that people contemplate what they're doing when they're filling out that declaration, that interest is served by the signature. I mean, the appellants cite to vote.org for the solemnity point, and that is a signature case. And so the date requirement adds nothing in that respect. And no court...
Solemnity is satisfied by any signature?
Asking people to sign the declaration is meaningful for the reasons that Your Honor has pointed out. But again, I'm here talking about what standard is applied, and when we're talking...
You agree that under our precedent it could be any signature. It doesn't have to be the signature, because there's no way to match the signature.
This court has ruled that signature matching is not part of the sufficiency determination.
What's the meaningful solemnity of a scribble that doesn't match the signature of the voter? What's the meaningful solemnity?
Again, Your Honor, I'm not the AG's office, I'm not the Department of State, but
you're asking us to adopt this sort of means-ends test. You're asking us to basically, if we can, hypothesize some reason why the General Assembly might choose to put this neutral ballot casting measure in, why the governor might agree to it. I'm asking you, if we do everything that you ask us to do, I'm concerned about what the next neutral ballot casting measure is in the election code that's going to be subject to whatever test we adopt that you're advocating for.
Respectfully, Your Honor, I think that concern is present all of the time when we're dealing with rules that impact a fundamental right.
This court has never invalidated a neutral ballot casting measure.
A neutral ballot, first of all, there are examples of this court invalidating what the appellants have coined as ballot casting rules. But before I get to those examples.
What about the color of the ink? Wasn't that a neutral ballot?
Yes, the color of the ink, check marks instead of X's, the deadline in PA Dems. In Applewhite, it was voter ID, and I understand that the ultimate conclusion in that case came from the Commonwealth Court, but they were following directions from this court to enjoin voter ID unless it could be shown that there was no voter disenfranchisement. These are all examples, but I am compelled to point out that ballot casting rules, that phrase is brand new, it's made up, it's not in the election code, it's not in the Constitution, it's not in the 300 years of jurisprudence from this court. So I'll also note that the appellants have, for their part, not pointed to any cases involving neutral ballot casting rules.
Counsel, could we go back to a little bit of a different issue that appellants have raised concerning the efforts on behalf of the Board of Elections to make the ballots more mistake-proof by trying to instruct people how to insert the dates, reminding them that it's important to put the date and putting, the first two numbers of the date on to try to avoid them putting of the year, to try to keep people from putting their birth dates on. There are efforts that have been made, and as pointed out by appellants, those efforts in recent years have resulted in fewer mistakes, okay? Maybe, 5% down to 4% or down to 3%, whatever it is.
Under 1%.
It had been around 1%, and in the last election it was under 1%, to be fair.
Say that again?
In the last election, 2024, it was under 1%. It was still about 4,500 votes just on the date requirement alone.
So that's my point. If you get down to even 1% of the vote, that is still enough, 4,500 votes, 4,000 votes, 2,000 votes, 1,000 votes. That is still enough to turn an election. I know of a statewide election where a candidate lost by 60 votes, not 60,000 votes, 60 votes. So to me, it's great that there are efforts being made to, reduce the possibility of error, but that doesn't get us to the ultimate answer here, in my view, and I'd like you to opine on that, because what we're talking about is people's votes, people's right to be heard, people's right to influence the election through their vote.
Absolutely agree, Your Honor. The efforts that the Department of State has made to redesign the envelope has definitely limited the bleeding, but it has not stopped the bleeding. It was still several thousand votes in 2024.
Well, could he finish answering this question, if you don't mind? Go ahead.
It's still several thousand votes in 2024, and you know, the cases around this very requirement have changed outcomes of elections. And so the Toa-Minson Township Commissioner race that the appellants point to was separated by just a couple of votes. And then after counting votes in light of the NAACP decision in the district court, the candidates ended up drawing lots, and the one who flipped the result. And so, you know, I'm reminded of Justice Weck's reference to constitutionally intolerable ratio of votes, right? And in that opinion and otherwise, we haven't seen a case that has really identified like what the numerator denominator would be for that ratio. And we would suggest that that's not the relevant inquiry for what the ratio would be. If anything, it is sufficient number of votes to impact the outcome of a race, because it's really in those instances where the right to vote is most pointedly at issue, where if somebody's ballot is thrown out, discarded because of the slip of a pen, and in some of these cases it is a slip of a pen. It's not just that somebody wrote the wrong date. They wrote it in the wrong little block, right? And if that's the basis for disqualifying somebody's vote, and the person they voted for doesn't win by one vote or because of the drawing of lots, we've now just directly denied somebody's right to vote. And this court, I mean, we're not asking for anything new. Respectfully, in Nixon, this court clarified that the way to determine whether or not a legislative or government action violates the Constitution is through a means-ends test. This court has never, I'm sorry, Your Honor, I see you wanting to interrupt.
You go with Nixon and Gambone, I'm smiling. Please walk right into it. Go ahead.
Sure. Well, and I understand there's a debate following Nixon and Gambone and some of Your Honor's opinions, Justice Wecht, about whether rational basis is something different in Pennsylvania. But our point is you don't even need to get there, because this court has already held that the Pennsylvania Free and Equal Elections Clause provides more protection over the fundamental right to vote than does the federal Constitution.
In a great opinion, if I recall.
Agreed. My compliments to the author. But we now have multiple examples of federal courts finding that this very requirement violates the federal Constitution under a minimal scrutiny standard. That's not even the floor in Pennsylvania. Whatever the federal court is applying in terms of its means-ends test is the basement. League of Women Voters stands for the fact that under an Edmunds analysis, the floor has to be higher than whatever the federal court is doing, not lower, right? So whatever means-ends test this court adopts in this case, and it has to be a means-ends test. It can't just be a binary, is the requirement so hard to comply with that it's essentially impossible. It's an infringement. It's a diminishment. Whatever synonym you want to pick from the long line of cases from this court talking about when a constitutional analysis is triggered, one must be triggered, and it must be a higher level of scrutiny than what the federal court is applying. That's how we square, that's sort of where the mapping is on League of Women Voters, Your Honor. And I think I made you lose an opportunity to ask a question.
I think it's very well put. By hypothesis, you're always going to have some votes falling out. I mean, I'm sure you would concede perfection is elusive and of course impossible. There are going to be some people who are going to, unless it's, you know, like Katie barred the door and you know, you just open voting at some day and hour and then close it on some other day and hour, and anybody who walked in just cast the vote, assuming some system of regulation, right? There are going to be some humans on the other side of that regulation, right? And therefore their votes are not counted. So there's sort of an endless regression here where any standard for which you argue is going to contain some arbitrariness. So, you know, when you import this argument for tiered scrutiny or even a balancing test, it starts to look a lot like, you want us to tell the General Assembly, start putting a statement of purpose into every one of your statutes. Otherwise, you know, you're going to have a constitutional problem, because I think you'll agree, wouldn't you, that the statute books are full of laws that put some restrictions on a number of important constitutional rights. Is that correct?
Absolutely, Your Honor. And anytime that happens, it's subject to a challenge that when my rights are denied, when my fundamental Article I rights are denied based on a rule imposed by the legislature or a practice imposed by a board of elections, I have the ability to challenge that under the Constitution, and I may lose if the proponent of that rule can demonstrate that there's a legitimate government interest to be served. And that's why I answered Justice Brobson's question earlier to say that this is always a danger. Whenever we're dealing with Article I rights, it's not even a danger. It is baked into the system. It is why we're all here, that whenever there is a rule that infringes on a fundamental Article I right, the person whose right has been denied has the ability to challenge that and have a means-ends test applied. It's not just a binary, is it impossible to comply with or not? You know, and I want to get back to one of Justice Donahue's earlier comments about a trap or a trick. You know, even if this date requirement was not intended as a disenfranchisement trap, we now know that that's what it has become. And if we follow the road that the appellants want you to go down in terms of what the standard is, or I would say it's not a standard, but whatever their standard is, it would not protect against any other thing that is intended as a disenfranchisement trap. I mean, there would be no difference in terms of what standard to apply and how it applies between this rule and one that requires every mail ballot voter to write the alphabet backwards with no mistakes in order for their vote to be counted. Under the appellant's view of constitutional analysis, Free and Equal Elections Clause has nothing to say about that kind of rule, but that can't be the law under this clause in this Commonwealth. In fact, it's not. And this court has never allowed a vote to be discarded. And in several cases, Gallagher, the rest. In several cases, this court has said that whether it's the loss of one vote or a group of votes, they should not be disqualified except for compelling reasons. Now, whether you call that a statutory analysis or constitutional analysis, this court is well versed in looking at so-called ballot casting rules when they've been applied to deny the franchise and asking the question, is there a compelling interest driving that?
Well, I guess the question, though, is it denying the franchise, or is it and there's going to be a debate about this, is it actually denying the franchise because they exercise their franchise, it's just that they did it imperfectly. But I want to go back to my question. There's another provision in the canvassing that discards a ballot if a secrecy envelope has a stray mark. And I was focusing on your slip of a pen point that you raised. Is under your new test, would that fail? Because it's just a slip of the pen, it's a little stray mark, but the statute expressly requires that ballot not be counted.
Just to be clear, Your Honor, this is not my new test. This is the test that this court said in Nader applies anytime the precious freedom such as voting is involved. A compelling state interest must be demonstrated. So I just have to push back on that respectfully, sorry. And if my client's vote is disqualified based on a stray mark on the secrecy envelope, I would think they have a claim. And it's under an existing standard that this court has applied time and time again. And so, you know, we can debate whether one provision or one requirement is more tied to a more compelling government interest. This one, as you'll hear more from Mr. Volchak, just isn't. And so
I'm interested in hearing, this is several times, I'm interested in hearing Mr. Volchak because there is no record here of testimony about that would support the view of the Board of Elections on what it does and how it does ballots and things like that. So it'll be interesting to see if his argument's going to be truly a legal argument or if he's going to be offering testimony.
Well, Your Honor, I'll let Mr. Volchak and Mr. Fabens-Lassen address their parts of the argument, but just very quickly, I mean, I was in the courtroom with the two voters at the 3157 hearing, and their testimony was submitted by declaration, and the Philadelphia board agreed that everything pled in the petition for review was correct. And so that is all the record I would submit you need to make the legal determination. There is no dispute here that the Philadelphia Board of Elections does not use the envelope date for any reason except for to disenfranchise. And there's no other party or intervener who can legitimately dispute that, especially given the record in all of the other cases where all of the same amici and the same interveners were party to that case, participated in full lengthy discovery, had the opportunity to ask interrogatories, to participate in depositions of every Board of Elections.
Did the interveners here have an opportunity to have a hearing and conduct discovery?
They were represented at the 3157 hearing in this case. So there was counsel for the interveners in the room. They had filed a motion to intervene. It had not been granted yet.
So they didn't have the opportunity to participate in evidentiary proceedings?
Judge Crumlish did turn to them and ask them if they had anything to add. We're talking about a 3157 hearing, and I'm sure this court is very familiar with how cases percolate up from 3157, right? They are challenges to computation and canvassing decisions that have to be filed within 2 days of the decision being made, right? This is a rocket docket like no other. And so we're in court immediately. We were in court with our clients, and then the RNC's counsel was there, appeared on the record, said we filed a motion for intervention. Judge Crumlish hadn't ruled on it, but he said, while we're here, in the context of this fast-moving rocket docket case, while we're here, do you have anything to add? After having observed the stipulations on the record made, and the interveners counsel did not add anything. Since then, I'll note that they've tried to make an issue of the absence of the record, but that issue is not granted as one of the questions presented today. But while
Is it a matter that we could take judicial notice of, given all the cases and all the evidence that we've had to date?
Yes, Your Honor, especially given the fact that the parties were also party in those other cases where the evidence was developed. We have decisions made based on those records by the federal courts.
We can take judicial notice of a record in another proceeding, as a record in this case?
Yes, Your Honor, where the defendant or the appellant was also a party in that case and had the same issues, and they had the same exact motivation to question. And I'll note that in all of the argument about whether or not the interveners should have had an opportunity to develop a record, they haven't pointed to anything that would actually change the result here, right? They want to, I think, what they noted as the things they wanted to explore if they had the opportunity was the reasons why the petitioners didn't put a date on their ballot, but that's a matter of record. That's in their declaration. They thought they did. They were surprised to learn that they didn't. And that wouldn't change the outcome of this case anyway. And then the other thing they would like to explore is the thing that was the subject of multiple cases over a period of years, including a fully developed discovery record, which is what, if any, purpose does the date requirement serve? This is a 3157 appeal of the Philadelphia Board of Elections decision. The Philadelphia Board of Elections is here and is told Judge Crumlish and can answer questions today that it has no purpose for the date provision.
That's the interesting procedural posture of this case. The Philadelphia Board of Elections made the decision and made based on our precedent and then took a knee when it went in front of Judge Crumlish.
Well, if it has no purpose, Your Honor, I wouldn't say that's taking a knee. It's
But
just
they
being
cited
truthful.
it. There was no adversarial party when you were in front of Judge Crumlish.
Again, interveners counsel was there and declined to say anything on the record, but
They
also
weren't a party yet. You agree that we're not a party yet.
they were not a party yet. They were granted
There was
intervention
no
after that.
adversarial party at the hearing in front of Judge Crumlish.
There was an adversarial party who had not been granted intervention yet at the hearing. But the underlying thrust of your question, as I hear it, Your Honor, is that the Philadelphia Board of Elections somehow took a knee by siding with us. But they confirmed what they had said in full discovery with the opportunity to cross-examine and pose interrogatories from the interveners here.
I want to apologize. I'm not using taking a knee as some sort of a pejorative term. They sided with you. You have to agree there was no adversarial party.
They were on the other side of the V, and if they disagreed with anything we had to say, they could have done it. But the truth of the matter was they have no use for the date, and that's consistent with what they've said every time they've been a defendant in any one of these cases.
Well, Well, and in fact, no Board of Elections, no government entity has said there was a use for the date.
In this case, that's correct, Your Honor. In NAACP and EACN, there were, I think, 2 or 3 boards of election that opposed the relief sought. They were cross-examined. Their witnesses were deposed. They submitted documentary and interrogatory evidence, and the conclusion of the district court, which was upheld by the Third Circuit, is that they also, despite their initial protests, had no use for the envelope date.
That's my recollection.
And now that we're here, among all of the amici and the interveners, none of them includes a Board of Elections, none of that is taking the side of the interveners here. We have...
Tell us, counsel, are you going to have more to say, or your colleagues have more to say on what you think should happen when you or a Board of Election or some other group of people, quote, have no use, unquote, for something the General Assembly passed into law and the governor signed? Because I'd be interested in knowing how far that standard reaches and in what circumstances. I suppose you're going to tell us that strict scrutiny has to apply. I want to know, I guess, what the basis for that is, because I'd like to know how far your have no use standard goes, because ultimately it also bears on how many disputes and in what context we're going to be asked to referee disputes around voting rights or around any rights people believe they have under our Constitution.
Understood, Your Honor. And I should note that me saying have no use is being a little colloquial, right?
Serves no purpose.
That's not this, right. It serves no purpose, serves no government purpose, is not narrowly tailored to a compelling government interest, or is unrelated to an important government interest. Those are the well-heeled, familiar standards that this court said in the William Penn School District case are familiar, identifiable, and manageable. Right? That's all we're asking for, is to apply the same kind of analysis that's always applied when the denial of right is involved. And I intentionally said or, as between compelling government interest or important government interest, because sensing some pushback on the notion that strict scrutiny should be applied every time there is a procedural neutral requirement. And our position is that's what the standard is and what it's always been. But if this court is inclined to adopt a standard that has more of a limiting principle, again, I think that would be new law. It would be contrary to Nader. It would be contrary to all of the cases involving fundamental rights. But there's a way to do this, and Eakin kind of, it would more closely adhere to what the court did in Eakin, except, again, with a floor that's higher than what Eakin did, and also, you know, would have more of a limiting principle without doing the type of violence to the Free and Equal Elections Clause that the appellant's position would do. What some courts in other states that have free and equal elections provisions, following form to the original clause in Pennsylvania, what some of those other courts have done is to apply an analysis that's more balancing, more sliding scale, similar to what the Third Circuit just applied in Eakin, but landing on more of an intermediate scrutiny for the same reasons I've articulated, that however you cut it, a free and equal elections clause provides more protection than what is provided under the Anderson-Burdick standard.
Would James Wilson choose to adopt the standard that fell on the wall back there? Chief Justice Stern came up with in Gambone, the, quote, heightened rational basis, unquote, standard?
No, Your Honor, because as this court has said, including in interpreting the Anderson-Burdick standard, so in PA Dems, this court did describe its understanding of the Anderson-Burdick standard, and in so doing said that rational basis is reserved for those cases that do not involve a fundamental right. Because we have a fundamental Article I right here, rational basis has no place in the court's analysis, whether it's more exacting, heightened rational basis, however some of your colleagues and predecessors might have termed it. I understand that that's not your favorite standard, Justice Wecht. But I don't even think you need to go there. It's heightened scrutiny, it's intermediate or better. We would say strict scrutiny under this court's precedents involving fundamental rights. But again, if this court is troubled by sort of the implications of that and the scope of that, I think that ground has already been plowed. But if the court is inclined to articulate a more limiting standard, it can do so without doing the kind of violence to the Free and Equal Elections Clause that the binary standard kind of gleaned out of a partial quote from Winston would do.
Counsel, can I, two questions, one not substantive, but just for my information. When we talk about the percentage of votes that are not counted as a result of this failure, has anyone taken into account the number of votes that have been cured as a result of the notice and cure process when the defect is the date or lack thereof?
Has anybody, there's definitely been analysis of the effectiveness of curing, and there's a cure
I'm
case.
just trying to determine if we know what the actual scope of the problem is with the misdates or undating.
We do. It's knowable in every election, although we can't know it ahead of time, right? So the trend is that there are fewer and fewer votes lost to this rule.
I'm not talking about lost, because some of them are cured.
Right, and the final, okay, I now understand your question, Your Honor. So the final count that I quoted for the 2024 general election, 4,500, that's post-curing.
Okay.
And that accounts, or that's after accounting for the fact that different counties have different cure procedures. Philadelphia does make a very big effort to allow people.
Some counties have no cure procedure.
Some counties have no cure procedures, and some counties.
That's a post-cure number.
That is the post-cure number. That is, I believe, also the post-provisional ballot number. So for those.
That brings me to my next question. Does the ability of voters, a voter, to use a provisional ballot in a situation where they know that their vote has been set aside, does that change your argument at all? Keeping in mind, we look at the election code as a whole. So if the election code taketh away but then giveth, how does that impact your argument?
It doesn't really impact the argument, Your Honor, because we're still left with the question of whether it's a single vote or a group of votes being disqualified without a compelling reason. And there's no amount of curing.
But the franchise is not lost in that circumstance if they can cast a provisional ballot.
Well, it's diminished, Your Honor, and that's what this court held shall not happen in League of Women Voters. It's a diminishment of the right.
How is it diminished?
By requiring additional steps, right? So for Mr. Baxter, who was in his 80s at the time, to have gone through the effort of requesting the mail-in ballot, which, well, I won't.
The convenience.
I won't assume, right. I can only assume it was more convenient for him, but requesting the mail-in ballot, verifying his eligibility to vote by mail, filling it out, signing the declaration, sending it in on time. He's done all of these things to exercise his right of franchise, and then to have to save the constitutionality of the date provision by going down to the elections office and either curing or voting a provisional on election day is that just adding these hoops, adding this amount of friction for no government purpose is the nub of this case. The other reason why the availability.
You're saying a voter can't be inconvenienced.
No, Your Honor. We're saying that a rule can't be used to disenfranchise voters unless it's tied to a compelling government interest. The other reason that curing or provisional ballot options do not change our argument is because no amount of curing or provisional ballot options.
Well, they're two different things.
Understood, but the sort of net result of the CCJ case in Genzer in some counties may mean that people at least get notice that there's been an error and that their ballot has been set aside so that they can either cure or go vote the provisional ballot on election day. No amount of rules along those lines is going to eliminate the issue here, Your Honor, and bring that 4,500 number down to something approaching zero or something that's tolerable given the closeness of races in Pennsylvania. And the reason for that is the deadline for receipt of the mail ballot package is still on election day. There will always be people who mail in their ballot thinking they've done everything right, they've missed the date, or maybe they put the date in one box instead of separating it into two, as we saw in some of these examples. And the election office receives it on election day and isn't even able to notify them. And the method of notification is email, by the way. So the email doesn't even get sent until late in the day on election day, when it's too late to cure the problem. And so in those circumstances, you're still left with voters who are being disenfranchised solely by application of a rule that has no government interest driving it.
You want to wrap up, Mr. Loney? I think we understand your
Chief,
argument.
could I just
Oh,
follow up
sure.
one brief?
Sure.
Counsel, you just referred to something that's come up repeatedly, and that's the historical or the recent, perhaps, closeness of some statewide elections. I think clearly the case. Can a constitutional analysis turn on anecdotal closeness of elections in a particular period, given how ephemeral that can be and how changeable it can be? Trends can evolve. I mean, can a constitutional adjudication by this court be premised even in part on either anecdote or evidence of election margins?
Yeah, it wouldn't ever be anecdotal, would it? We'd always have evidence.
Well, if it's in the record, we have evidence or we can find it. If that's immaterial, but you see my point?
Yeah, and the direct answer to your question, Your Honor, is that is immaterial to the constitutional analysis.
It's material or immaterial?
Immaterial. And I'll note that this is case in point. We're representing 2 voters who are among 69 who lost their vote in a September 2024 special election. Those 69 ballots could not have changed the outcome of the election, but the right to vote must be vindicated nonetheless. And so the relief that we're asking for here, which the Commonwealth Court granted, is that those 69 voters' votes be counted and added to the final count. But the results of that election have been certified, but that doesn't make the fundamental right to exercise the franchise any less weighty under our Constitution. It may be a relevant fact to consider in thinking about whether or not a particular rule, not this one, but whether or not a particular rule is indeed a burden on the franchise, is indeed infringing on the franchise. So if you have a rule that only caught one person in a 10-year period, I could imagine that is an argument that one could use to say that, well, this really isn't denying the franchise. We know that this rule is denying the franchise to thousands of people in every statewide election. I know I've been asked to conclude, but I'm also assigned to the severability piece. So you'll hear...
Let's begin anew.
Yeah. You'll hear from Mr. Volchok more about the purported purposes of the date rule, but I'll say just one thing about legislative purpose that does tie in with the RNC's severability analysis, which is all indications here are that the General Assembly didn't give much, if any, credence to the importance of the word date when it carried that language over from an old version of the election code into Act 77.
From the absentee ballot legislation.
Correct, Your Honor. This phrase, shall fill out date and sign, is a relic from a 1963 absentee ballot provision. And the legislative leaders who submitted an amicus brief here and in every other case, in their amicus brief in BPEP, actually acknowledged that language was ported over, was copied and pasted, quote, for the simplicity of legislative drafting. That's at 71B of our record. So not because anybody in the legislature made a considered decision that the handwritten date is needed, but it was for the simplicity of legislative drafting. So from the perspective of a severability analysis, I think it's safe to say that the word date is not integral to, is not inseparable from that grand compromise that was reached in Act 77.
I mean, I didn't know we're going to severability already, but that's a real thin read, isn't it? Because now we're going an extra step and being asked to parse and interpolate which words in a provision the General Assembly enacted which are sufficiently integral or meaningful. How is that a standard upon which this court can adjudicate severability questions?
I think that is the standard, or part of it, under the Statutory Construction Act, Section 1925, and under this court's opinion in Stilp. I do.
Pick apart the Act 77 and determine that the sign part is integral, but the date part is not?
No, Your Honor. The analysis that this court engages in, whether or not there's a severability or a non-severability clause in the statute, is whether the valid provisions are so essentially and inseparably connected with and depend upon the invalidated provisions.
Where do you get that from?
That is a quote from Section 1925 of the Statutory Construction Act. It was also applied in Stilp.
No, but you added a different qualifier. Your qualifier was whether or not there's a severability clause, we apply the Statutory Construction Act. Why is that true?
That's true under this court's precedent in Stilp, and the reason is, I think, and I do want to get to our primary argument that this doesn't actually invalidate any provision of the code, but since we're here.
Well, you agree that you don't go to the Statutory Construction Act unless the act is ambiguous.
No, Your Honor. When it comes to severability and the separation of powers concerns that are necessarily implicated when there's a severability provision.
Again, you're throwing these out. What separation power of concerns are necessarily implicated by any non-severability provision?
I'm drawing this directly from this court's opinion in Stilp, Your Honor.
Okay, so Stilp again was a different animal. Stilp was a situation involving a pay statute applicable to judges, that they put a non-severability clause in because in this court's view, they were trying to tie the court's hands or influence how the court would decide the constitutional question, meaning the judges had a stake in the outcome. We have no stake in the outcome of this case. There's nothing about the Act 77 that is particular to the judiciary, how we do our jobs, anything like that. That's why Stilp is kind of on its own. But Stilp doesn't say, as a general rule, in fact, I think it says the opposite, that when the General Assembly expressly provides a non-severability clause in the statute, it's just like any other provision of an unambiguous statute. We apply it. We affect the intent of the General Assembly.
Respectfully, I disagree, Your Honor. I do recognize that Stilp was a unique set of circumstances. As Justice McCaffrey pointed out earlier, however, the voting rules do impact elected officials on the bench, but that's not the crux of our argument. Stilp did actually say—
I disagree that there's any ambiguity. Let's agree with this. Is there any ambiguity in the General Assembly's non-severability language here?
No, there isn't.
Okay.
And there wasn't in Stilp either.
Intended it to be non-severable.
There wasn't in Stilp either. It's the exact same language that this court—
I understand you're going to Stilp, but you agree that it is clear that the General Assembly intended the statute to be the act to be non-severable.
They wrote language that is unambiguous on its face.
Okay. So how do we then apply statutory construction principles?
So I'll quote from Stilp here, Your Honor. The issue of enforceability of the non-severability provision is not a question of legislative intent. The provision itself makes clear the legislative desire that no court invalidate a single provision of the Act. That is the reasoning this court applied in Stilp, and that reasoning was not dependent on the unique factual situations. In fact, in Stilp, this court went through a historical examination of the common law around severability provisions and articulated the separation of powers issues that maybe I'm doing less of a good job articulating today. But the separation of powers issues being that a severability provision, ambiguous or not, purports to limit the court's role in determining the constitutionality of a statute. And so
that's the crux, or the nub, if you will, of the separation of powers analysis here. It's not tied to Stilp's focus on the facts involving a pay raise to legislators and judges. It's about the duty of the court, our bailiwick, to construe the Constitution. That's the separation of powers problem.
But
wait, let me get an answer if I could. Is that correct?
That is correct, Your Honor. I mean, you could do a Control F within the Stilp opinion for the phrase separation of powers. It's there, but the separation of powers concern that's articulated by the appellants is not the reason the case came out the way it did. The separation of powers concern that drove the result in the case was that the legislature can't usurp this court's ability to call balls and strikes on constitutionality.
Can I just follow up that? Isn't that a red herring? I mean, how does the General Assembly usurp our authority by passing a law. Basically, they tell you in this context, look, we made this side of the aisle and this side of the aisle, we for once came to an agreement, we made a deal, and we've got this package, and so we're going to give up slate voting, and we'll give up our opposition to mail-in voting, and here you got Act 77. So because we made this deal, and it's a quid pro quo, we're having non-severability. Now, how does that tie this court's hands when the General Assembly could come back tomorrow and strike out Act 77? It could be gone today. And we can come in and find a part of it unconstitutional today or not, or we can find more than one part unconstitutional or not. And the consequences of our action can be for the General Assembly. How do they usurp our authority by saying, as a matter of law, what a consequence of their statute our adjudication might have? Is that unclear? Do you want me to rephrase it?
I think I get it, Your Honor, and if I don't, that's on me, not you. The issue is putting in this kind of poison pill provision that discourages meaningful judicial review. And actually, the petition for en banc review in Eakin filed yesterday kind of demonstrates the point. In the RNC's petition filed yesterday, which I think has been sent to the court as supplemental authority, they make the point to the Third Circuit that if you uphold this result, it's going to have catastrophic implications because of severability. It's tying this court's hand, and that's my understanding of the opinion still. But it's not just still.
I don't know how that. I'm not discouraged. I mean, I don't know. My job is to determine whether a statute is constitutional or a statute is unconstitutional. There's plenty of times where we rule statutes unconstitutional, and the entire statute falls.
Absolutely.
So the consequence doesn't really matter to me. What matters, that's not going to drive my constitutional assessment. The reason why Stilp was so different was because the non-severability clause, at least as this court in Stilp felt was, dealt with pay for judges, in that somehow, some way, that was going to implicate the inability to reduce the salary of judges during their term and things like that. There were a lot of other things particularly tied to judges that was impacting, and the idea that would influence or somehow prevent us from giving a fair review of the constitutional question. How does this non-severability clause prevent us from providing a fair review of the constitutional question in front of us?
Yeah, I think you're absolutely right, Your Honor. This court is very familiar with the task of calling balls and strikes on constitutionality and then figuring out whether that has an impact, whether the thing that's been invalidated is severable from the greater act. But what Stilp stands for, and I think it's not just Stilp, it's Commonwealth versus Hawkins, right? It's the premise being that in conducting that review, this court will do an analysis of whether the thing being invalidated is so inextricably intertwined with the rest of the act that the whole act has to go away. And what Stilp said is that the presence of a boilerplate non-severability clause, which tracks word for word to the non-severability clause here, is not conclusive as to that analysis. And that's our only point. But I think before we even get there, I might have led you down this road of debating Stilp and application where there's an invalidated provision. But in this case, there is no invalidated provision from Act 77. This case boils down to a canvassing decision made about the sufficiency of the declaration under Section 3146.8. 3146.8 predates Act 77 by decades. And just for context, I'll go back again to where we started as a 3157 appeal. Under Section 3157, by definition, the petitioner can challenge an order or decision of any county board regarding computation or canvassing of returns. That's what this case is. By the very nature of this proceeding, the relief granted, the relief sought, and the relief granted below was for the Philadelphia Board of Elections to make a different sufficiency determination than the one it felt compelled to make in the moment.
But that is belied by everything that's come before up to this point, in which you've made this grand constitutional argument, and you want to make that argument, and you make it well, and if you convince a majority of this court that this dating requirement in the statute violates the free and equal elections clause, and you win that round, then you want to turn around and say, for purposes of the severability analysis, no, it's really not a grand constitutional adjudication. It's just sort of a sufficiency housekeeping thing by the Philadelphia Board of Elections. So we're not really implicating the severability question entirely. Isn't that a disconnect?
No, Your Honor, and my apologies for smirking. It was just you were doing a really good impression of me.
No, I wasn't.
My wife does the same impression. So, no, Your Honor, these aren't inconsistent at all. Our grand constitutional argument is not about trying to take the word date out of Act 77 or trying to take the word date out of Section 3150.16. This is all about, when the rubber meets the road, what decision a county board of election makes as to whether or not to count a vote. And not counting the votes because of the reading of the word date as mandatory, that consequence is the thing that's unconstitutional, right?
It doesn't require removing that provision from Act 77.
Correct. And in fact, it hasn't. Thank you, Your Honor. Correct. We totally agree. And it hasn't required invalidating the word date from Section 3150.16. In fact, the Eakin decision we've been talking about as a very recent development, that's the Third Circuit development. The district court decision happened before the primary. And in the primary, everybody who voted by mail got an envelope that had a date line in it. They were instructed to fill in that date line. They were required to fill in that date line. And then when they didn't, because of the result in Eakin, because of the direction to county boards to count the votes, not a direction to the Secretary of State to change the envelope and take the date requirement out of it, but a direction to the county boards, those votes counted and did not require overturning of Act 77, did not require even invalidation of the rest of Section 8 of Act 77. So Section 8 is what is now 3150.16. Section 8 is the provision that includes shall fill out, date, and sign as applied to mail-in ballots. By the way, that section also includes the blue or black ink language that hasn't been enforced since 1972.
And if we accept your analysis there, then severability is not even an issue.
It's not even a question you have to engage with, which is why I apologize for taking us down the Stilp road in the beginning. But I think we went under either analysis, right? Primarily, what's happening here is a new application of old language, not new language that came with Act 77. And because of that, there's nothing that needs to be severed out of Act 77. The instructions to the boards of election can stand.
Could I inquire on that? Because I find it incomprehensible. The legislature wrote in Act 77 that you'd get wholesale invalidation in the event that, quote, any provision of this act or its application to any person or circumstance is held invalid, unquote. And I don't know how we can, in some hyper-lawyerly fashion, avoid that in a way that does not do violence to what the legislature told us it wanted. And they make the laws, we don't.
And as opposed to the nub of it, therein lies the rub of it.
That's an improvement on the Brobsonian formulation. You'll never.
I haven't been on this court long enough to take this abuse.
Yes, you have.
Nor have I. Your Honor, one thing I'll point out is that that boilerplate provision, again, same provision that was not followed in Stilp, would actually require invalidation of that boilerplate provision if it were applied literally. And so I hate to be hyper-lawyerly here, but again, I think that's our job. It's certainly my job as an advocate to point out when the statutory construction being advanced, it both creates separation of powers problems and doesn't make sense by its own terms. And by the way, we don't even have to get there because the application is not happening under Section 8 of Act 77. It's not happening in the invalidation of the date provision. It is happening at the canvassing stage, at the computation stage under 3146.8, which again predates Act 77. So,
Counsel, could you, how is the discretion of the board directed under 3146.8? I mean, doesn't that provision enumerate the issues that would render a ballot insufficient?
It does, Your Honor, and it says, this is under subsection G3, that if the county board has verified the proof of identification as required under this act and is satisfied that the declaration is sufficient and the information contained in the voter file matches the list, right? That's the task at hand. And after Ball, something got added to that task, which is checking for compliance with the date requirement. That's the part that creates the constitutional problem, and it's at that canvassing stage where the application happens, not in the requirement that that the Secretary of State ask for a date on the envelope. And I do think it's instructive here how things played out a year ago. A year ago, this court denied or vacated the result in BPEP on the theory that the Secretary vacated the, sorry, Your Honor, I'm a little parched. Vacated.
Get a drink? You've been arguing for hours.
So I have.
And we're not in any hurry. We're here all day.
Appreciate that, Your Honor. A year ago, this court vacated the result in the BPEP case, the Black Political Empowerment Project case, on the theory that the Secretary was not a necessary party, but all 67 county boards were. So if this were about what is required under 3150.16 for the Secretary to ask voters to do, the Secretary would be a necessary party. The natural outgrowth of how BPEP played out is that where the rubber meets the road, where the constitutional violation is happening, is at the board level. So too, this matches with how the case arose. Again, we, as representatives of the voters whose votes were being discarded at the board level, under 3157, had to sue the board within 2 days. That's what we did. That's whose decision is being challenged here. And that is not an Act 77 decision. By the way, this is something, not just the provisions of 3146.8 predates Act 77. The entire kind of structure and process that we're advocating for predates Act 77. The exist. Correct. That was the one and only amendment to 3146.8 in Act 77, was to add the word mail-in ballots. But the phrase that I read into...
Additionally, the non-severability portions of Act 77 included Section 7, which again amended Section 3146.8 as one of its non-severability sections.
But the amendments contained in Section 7 are not among those that we're challenging here, right? The language that obligates the county boards to make a sufficiency determination, that language predates Act 77. That is not part of Section 7 from Act 77. And by the way, this parsing of what is and what is not part of Act 77 gets to another problem with the RNC's non-severability argument, which is what happened in Act 77, as Chief Justice Todd pointed out, after 180 days, the amendatory provisions became baked into the broader election code. Then, in 2020, there's Act 12, which further amends some of those provisions. So now this thing's got tentacles all throughout the election code.
But aren't we to assume that the legislature, since they wrote it, is aware of these tentacles? In other words, they were aware of the deal they made. And at any point, by majority, they could undo the whole kit and caboodle. So this idea, I guess this is the dead hand argument you're making now. You know, the subsequent enactments and you don't want it to carry forward. Doesn't that ignore the fact that it's always a creature of the legislative will?
Right, but what the appellants are asking this court to do is to do the work of the legislature in repealing words and bits and pieces of what are now baked into the election code, leaving kind of orphan amendatory provisions from 2020 in there, even though the word date does not seem to have been part of the grander deal that's been reached. Look, we'd be having a different conversation if McClinko came out a different way, right? If the challenge to all of mail ballot voting had been successful, now we're talking about something that is inextricably intertwined with the whole act. And
Well, it's inextricably intertwined, and yet tomorrow or today, the General Assembly could change the whole thing, assuming the governor concurs. So this inextricable entwinement tentacle argument, I think, do you agree, fails to fully account for the legislative will factor here?
I don't agree with that, Your Honor, and in large part it's because the result of enforcing the non-severability provision in this case without any kind of evidence that the legislature saw the word date as critical to the deal would actually put more work on the legislature. It would be the judiciary putting more work on the legislature because we'd only be invalidating Act 77. We'd only be pulling out those tentacles or trying to find them and pull them out from the election code as to Act 77, leaving later amendatory provisions that don't make any sense and requiring the legislature to fix the mess.
Pulling out an act that is no longer out there as a separate act. It is now baked into the election code.
Correct, Your Honor. It's baked into what was before and what's come after. So what was before, it was a code that starts off in Article 1 of the election code with a severability provision, which was not amended at all by Act 77. The legislature was presumably aware of that provision. The legislature was presumably aware of STILP and its progeny, and still inserted a boilerplate non-severability provision of the type that this court has already declined to enforce. By the way, this court has also declined to enforce it in the PA Dems case when it at least temporarily invalidated an application of something in Act 77, the mail ballot deadline. But that didn't result in severability, and I think 3 justices on this court specifically noted in concurrence that following STILP, this very non-severability provision should not apply.
Are you telling this court that either the court or the General Assembly is incapable of identifying what was in Act 77 at this point in time?
No, Your Honor. What I'm saying is that once you identify those things and extract them, then it leaves a code that doesn't make as much sense anymore. And then it does put the work back on the legislature to fix what it had subsequently amended to make it make sense.
Well, it's not a bad thing if they do some work, is it?
An overhaul to the election code is something that I think many people in this room would be okay with, depending on how it comes out.
Counsel, in PA Democratic Party, the naked ballot case, we actually applied 3146.8, correct?
Correct, Your Honor.
And, I mean, we didn't consider it as part of Act 77. We said it had to be read in para materia with.
Correct, Your Honor. So it was not part of Act 77, just like the result that the Commonwealth Court issued here. And the footnote conclusion from the concurrences in PA Dems, noting that severability was not, this same severability provision was not triggered, should carry over here. And again, we don't think you even need to get there.
But what we said in the PA Democratic Party case is that the county boards had to reject naked ballots. They could not count them. That was a direction to the county boards.
Correct, Your Honor. And that was something they carried out at the canvassing phase. Right, so I'm sorry, I was kind of conflating that result and the result on the deadline.
Yeah, right.
Yes. We've covered a lot of ground. So I'm just going to wrap up going back to the first question presented before handing off to,
We may need to issue CLE credits to the attorneys.
does that mean I get preparation credits for presenting?
No. Done this, you have to have some new subject.
assuming you're being
You've done
paid
this
for today.
before.
Fair enough, Your Honor. So before handing back to Mr. Volchok to talk again about the first question presented, I just want to return to the touchstone of this court's analysis confirming that the protections under the Free and Equal Elections Clause are over and above what is provided in federal courts under the federal Constitution. And on that basis alone, we ask that you affirm the Commonwealth Court's decision and vindicate the voting rights of our clients. Thank you.
Thank you, Mr. Looney. Well said. Let's hear from Mr. Volchek. Now, if you want to say simply what he said, we're okay with that.
I certainly endorse everything that Mr. Loney said, but Chief Justice Todd, and may it please the court, Daniel Volchok for the Pennsylvania Democratic Party, joined by co-counsel Clifford Levine here in the courtroom. Your Honors, as Mr. Loney indicated, I plan to principally address two issues. That is, our argument that it violates the Free and Equal Elections Clause to disqualify ballots for noncompliance with the date requirement because such disqualifications further no legitimate government interest. And second, addressing Appellant's argument that this court in P.A. Dems, Ball versus Chapman, has already rejected our constitutional challenge. But if I could first quickly close the loop, as it were, on what was discussed earlier with counsel, the so-called Winston standard. And the point I want to make there simply is that what appellants are referring to as the Winston standard is one of 5 requirements that this court in Winston articulated in a single sentence for free and equal elections. And appellants are saying implicitly, they don't come right out and say it, but they are saying that only one of those 5 by itself sets the constitutional standard for facially neutral election regulations, and that the rest should be discarded. And the reason I submit they are doing that is that 2 of the other 4 are inconsistent with their position. So this court, in the same sentence in Winston, which was quoted in full in League of Women Voters, said that for free and equal elections, it also has to be the case that every voter has the right to cast a ballot and have it honestly counted, and that no constitutional right of a qualified elector shall be subverted. So whereas they are saying that facially neutral election regulations are valid under the clause unless they essentially deny the franchise, that's the so difficult standard, this court made clear, I submit, that lesser infringements, such as mere subversions, will also violate the clause.
About the subversion, because you read it faithfully, is it suggestive that over 99% of the people are clearing this not so high hurdle, and that fewer than 1% are blowing it, that this is perhaps not a subversion of the right, but simple human error, which we all can make from time to time? How is that subversion?
So, Justice Weck, my submission is that in determining whether this is sufficiently serious to constitute a subversion, and of course that's a capacious term that could be subject to all manner of interpretation, and I'll get to why in just a moment. I think League of Women Voters gave a very useful gloss on it. But to answer your question, it was discussed with some of the earlier counsel, what we know is that in the 2022 election, 10,000 Pennsylvanians lost their right to vote, 4,500 in 2024. You heard the numbers. And as Eakin pointed out in footnote 29, so Third Circuit 2 weeks ago, the RNC told the Third Circuit earlier this year that 3 Republican candidates have lost their elections since just 2020 solely because undated ballots were counted. So we are talking about a requirement, the enforcement of a requirement, that actually has actually affected numerous elections. And that would Justice Wecht, I submit, yes, is a subversion of the right to vote. Now, I mentioned the gloss that League of Women Voters put on it. This is language that's in our brief, and I think it's very important. The court said the text of the Free and Equal Elections Clause indicates the framers' intent that all aspects of the electoral process will, to the greatest degree possible, remain open and unrestricted to the voter. Now, that, in our view, is entirely inconsistent with, first of all, the notion that somehow the Free and Equal Elections Clause is only limited to neutral ballot regulations, but also the notion that there's any level of minimal judicial scrutiny here. Because if you're saying that all aspects of the electoral process have to be unrestricted, I read that to mean that restrictions are permissible only when they are necessary. And that is certainly not the language of rational basis review. We heard some suggestion that if there is judicial scrutiny at all under the Free and Equal Elections Clause of what they call a neutral ballot casting regulation, it would have to be rational basis review. I submit that's inconsistent with League of Women Voters. I'm also not aware of any case in which this court has applied rational basis review to a fundamental Article I right. And if we were even looking to federal case law, I submit Crawford itself, the case Crawford versus Marion County that the appellants rely on repeatedly, is inconsistent with the notion of rational basis review, even for infringements of the federal right to vote, as Mr. Loney articulated. That is not as robust as the Pennsylvania right to vote. But Crawford said, however minimal the burdens on the right to vote, they must be justified by sufficient state interest. That is not rational basis review. If you're talking about rational basis review, is there a state interest? There's a disconnect between saying however minimal the burdens, they have to be justified by sufficiently weighty state interest, and the extremely forgiving rational basis review. So I submit rational basis could not possibly be the correct level of review here. But with that,
Can I just jump for a second? So I think people who look at this can reasonably say, really, we're dating something. How hard is it to date something? And would look at it and say, because dating something is ubiquitous to common society, we have verifications we sign all the time, licensing applications, bank thing applications, we date everything. That by that nature, there's no burden here. There's zero burden here. How do you respond to that? That asking for it, this is not like voter ID, where people would have to literally go out and get something new. They'd have to get it. If they didn't have a driver's license, they'd have to get an ID. And that would impose, they'd have to apply for something, and that would impose a burden. The voter is not required to take anything with them, wear anything, purchase anything. They simply have to, as they have a pen in their hand, date something that they presumably have already signed. How does that even rise to a burden at all?
so a couple of responses, Justice Robson. First of all, just let's bear in mind it has to be a correct date. It has to be a date that is could potentially be when you actually filled out the ballot. So we know, for example, as was alluded to earlier, a significant number of people write down their birthday by mistake. We also know the figures that I've already alluded to, suggesting that thousands of people get this wrong.
Those are mistakes. So those are mistakes, and people make mistakes, as I think Justice Weck said. I'm asking you, is the election code have to be written in such a way to ameliorate the possibility of human mistake?
No.
Okay. So at what point in time is there accountability for the mistake on the voter versus telling the legislature this is just a burden because these voters are making mistakes?
So the relevant burden is not simply writing down a date in our view. The proper analysis of the burden, and Ekin agreed with us 2 weeks ago, said that part of the burden is analyzing the consequence. And here, of course, the consequence is losing your Article I fundamental right to vote. That, to our mind, is a key part of the analysis.
It's not really a burden issue then. The question is, if you make a mistake and the consequence means of that mistake is the statute says your vote is going to get not counted in the canvass, that in your mind is something that triggers a constitutional infirmity with the structure of the election that the General Assembly has put forth.
Well, to be clear, essentially yes, Justice Robson is the short answer, but the longer answer, we are talking about a burden on the right to vote. And so the burden here, it is manifested in the requirement to write down a date, now just a month and a year, but the consequence, which should be part of the analysis, is losing your right to vote. And if there is a sufficient
Counsel, it's not a loss of the right to vote. It's a loss of the right to have your vote counted, and that arises from this court's decision, if I may, because I didn't sit here at the time, in the Ball versus Chapman case. Because we've talked about this before, and this is a disqualification issue, not a denial. Because we keep coming back to it and we're dancing around the issue. You keep using the word burden. Justice Brobson and other justices are going to say, well, it's really not a burden to date something. the constitutional infirmity arises because this court determined in Vol versus Chapman that shall means shall, it's mandatory, and therefore if you don't date it, it's disqualified.
I agree with you, Justice McCaffrey. We are using burden on the right, the right to vote as something of a shorthand, but I agree with you. The right in question, and Justice Wecht, you made this clear in one of your concurring opinions, the Supreme Court has repeatedly made it clear, Westbury versus Sanders and elsewhere, and Winston versus Moore made the same point. I quoted it a few minutes ago. But the right to vote includes the right to have your vote counted. We are talking about having a role in our participatory democracy. Nobody fills out a ballot just because they like filling out a ballot. They want to have a role in selecting those who will represent him, or the process of choosing to elect those who will represent him. Similarly, we use the shorthand for, does the date requirement serve any purpose? That's not actually, I submit, the proper question. The question is, does the disqualification of your ballot for failure to comply with the date requirement actually serve any purpose? And it's a very important distinction, because all of the purposes that appellants have put forward so far as justifying the date requirement or the disqualification of ballots for noncompliance with their date requirement, to whatever extent the date requirement and the handwritten date furthers those purposes, and I will go through them one by one with the court's indulgence, they will likewise and can likewise be furthered, even if this court were to affirm and say you cannot disqualify ballots for failure to fill out the date requirement. Now that leads directly into the question of, well, how many people are still going to write down the date if this court were to affirm, to which I have two answers.
Can you disqualify a ballot for failing to complete the verification?
If disqualifying those ballots furthers a legitimate government interest, and that is not an argument that we have briefed, so I'm not sure the PDP has.
Well, but we keep talking about dating, and we're talking about a verification. We're not talking about dating the ballot. We're talking about a verification that attests to certain facts, requires a signature, requires a date, and the question is, I guess that's my point is, does that serve a particular purpose, requiring people to verify those facts when they send their ballot in?
I am not aware of the government interest that is furthered by disqualifying a ballot for failure to put a date alongside that verification. Now, what appellants have argued, of course, there are three different state interests.
What about the signature?
Justice Robson, again, the PDP has not taken a position in this litigation on the validity of the signature requirement. If that were to be challenged under the standards that we are proposing, the framework that we are advancing, the question would be the same one here, and I don't have the answer to it because we have not briefed it, but the question...
We've taken a position on that, haven't we?
Justice Wecht, I hate to put questions to the court, but are we talking about the Walsh case?
We're talking about the court. This court has taken a position on signature, right?
So in the Walsh case, this court rejected a challenge to the signature requirement for provisional ballots. Now, I want to be very clear about that because the vast majority of that opinion was about statutory interpretation, the continuation of discussion the court has had within itself, and about directory and shall mean shall, et cetera, et cetera. But there was one paragraph at the end of the court's analysis in which the court noted that it did not agree with the constitutional challenge that was presented there. Now, it made clear the constitutional challenge that was presented there was only the so difficult standard. Essentially, the board said, Winston held that it violates the free and equal election clause to make a requirement that is so difficult. And this court said the challenger has pointed to that standard but has not shown how that standard is met. So the challenger there was not remotely making the same argument that we are making here. Now, Justice Wecht, by saying all of that, I am certainly not in any way asking this court to revisit its decision in Walsh. That issue is not presented here. It's not implicated by this case. All I am suggesting is, in terms of the concern about a floodgate of challenges, our submission is disqualifying ballots for failure to comply with a requirement that does not advance a government interest violates the free and equal elections clause. We think that comes from League of Women Voters as well as Winston and...
Well, and I'll go back to my question about the verification. Does having an executed verification on the outside of an envelope purportedly by the voter to whom that ballot was sent serve a governmental interest?
I don't know, Justice Robson. I am not here to defend the verification requirement.
The problem is you're taking the date part and you're extracting it from the verification. The verification is multiple paragraphs with signature and date.
But the issue before us is the date.
But the date is part of a verification. It's not. In other words, I think it's interesting how a lot of the other cases that have looked at this have talked about a dated or undated mail-in ballot. The ballots are not being dated. What is being dated is a verification attesting to facts, an affidavit under penalty of perjury. That's what we're talking about. And so I'm trying to figure out, you're saying that it's the date component of that verification that is unconstitutional, but the verification otherwise is okay?
I am taking this case, Justice Brobson, as it was litigated from the Court of Common Pleas with the petition initially filed by the voters, and I am taking that the arguments that the appellants have put forward in challenging the Commonwealth's court's decision as to why the disqualifying ballots for noncompliance with the date requirement.
You say date requirement, it's a verification requirement.
I don't mean to get hung up on terminology. The parties have briefed the case using the term date requirement. I'm happy to get more specific and say we are talking about the language in the election code that says a mail or absentee ballot voter, after completing all of the preceding steps, shall sign and date the verification. Absolutely. That is the requirement that we are talking about. But what we are specifically challenging in this litigation is the requirement to add a date, not to sign the ballot, not to do anything else, include the secrecy envelope, or anything along those lines. Now,
Mr. Volchek, I'm sorry to interrupt you, but you don't breathe between sentences, so it's hard to get in there.
My apologies, Justice
No,
Todd.
you're
Chief
just
Justice
saying
Todd.
a lot. It's good. But since you answered Justice McCaffrey's question, you have said a great deal, but you confused me with one thing you said in response to his question. And I'm asking, are you conflating burden with consequence when you were defining what is a burden in this context?
So I would not use the word conflating to define my own argument. I would say that we view the consequence of not complying with the date requirement as part of the proper burden analysis. So a court...
How do you get there?
Well, the Third Circuit did the same thing 2 weeks ago, and it said, look at prior Supreme Court decisions. Of course, it was looking at it through federal law, but the Supreme Court, for example, in Anderson itself, the case from which the Anderson part of Anderson verdict takes its name, the court there was looking at a requirement that independent presidential candidates had to declare sufficiently early in the season. And the Supreme Court, in analyzing the constitutionality of that requirement, looked in part to the consequences for independent voters and the fact that they might not make their decision early enough and would lose the right to vote for the candidate of their choice. So the Third Circuit was suggesting, and I think it's certainly correct, under federal law it is certainly proper to look at the consequence. It also used the...
I know it's proper to look at the consequence, but what you're confusing me with is that you're including that in the analysis of the burden, and I'm not sure I looked at it that way.
Well, our overall submission is that any a requirement or disqualification of cast ballots because of the failure to comply with the requirement is all part and parcel of the burden, and that is what needs to be justified by sufficiently strong state interest. And what the appellants here have pointed to, they've pointed to three different possible state interests. They started with the timeliness of ballots, preventing voter fraud, and promoting solemnity in voting. Now, none of those three is an interest that is actually or adequately furthered by disqualifying ballots for failure to comply with the date requirement. And let me go through them quickly with the court's permission. Starting with timeliness, as a matter of Pennsylvania law, it is not permissible to the handwritten date on the outer envelope of a mail ballot cannot be used to determine a ballot's timeliness, and that's because under the election code, mail ballot's timely if and only if it is received by 8 p.m. on election day, and the handwritten date cannot tell you when the ballot was received, and that's because two steps have to follow. What the correct handwritten date tells you, assuming it's correct, it tells you the date on which the voter wrote down the handwritten date. Two more things have to happen after that in order for the ballot to be received. The voter has to put the ballot in the mail, and the Postal Service has to transport it to the Board of Elections. Handwritten date doesn't tell you how long it took for either of those two steps to be completed, let alone both of them. So it simply does not give any insight into when a ballot was received, which is all that matters for timeliness. Now, what appellants have said, and the AG addressed it again earlier this morning, the scenario in which the Shore system breaks down and in which election officials violate their statutory obligation to keep a record of when every mail or absentee ballot is received. And they say in that circumstance, if both of those things occurred, the handwritten date could be used to help evaluate timeliness. Well, number one, I do want to underscore how implausible I view that scenario as being, in part because, as I just said, it requires assuming that election officials will violate, ignore, disregard, whatever verb you want to use, their statutory obligation to keep a record of when every mail ballot is received. But even putting that aside, the argument just ignores everything that I said about how under the code it simply is not permissible to use the handwritten date because it doesn't give you information on the only thing that matters in terms of timeliness. And you have the briefing from the Philadelphia County Board of Elections here confirming that it does not use and does not believe it can use the handwritten date in order to determine timeliness. And to the extent this court deems it appropriate to look beyond the record in this case, there are similar representations from the other county boards of elections in the two recent federal lawsuits, NAACP and Eakins, similarly saying that the handwritten date simply is not used to determine a ballot's timeliness. Now, my last point on timeliness, I submit it's a little, with respect, hard to credit appellants' assertion that they would have no concerns, no objections, if after a certain election, a number of boards of elections took the position, we've got this room full of mail and absentee ballots. We don't know when they were received. Shore system broke down. We didn't record when they came in. We just don't know. But we're going to take a look at the handwritten date on those ballots, and if they're early enough before the election, far enough before the election, we're just going to go ahead and count that room full of ballots. I submit it's difficult to credit that the appellants would have no concerns with that, but the basic point, again, under the election code, handwritten date simply plays no role in determining the timeliness of ballots.
There's been some discussion about burdens and also purpose, as you just were marking. At least one of the amici referenced are quite onerous petition requirements. Both with respect to burden, and these petition requirements are something we're all familiar with, of course, since we're an elected judiciary. Both with respect to burden and purpose, assuming that your side prevails in this case, couldn't one foresee that the entire onerous petition rubric has to come crashing down?
And Justice White, again, with apologies for directing a question back at the court, are we talking about requirements to petition this court for review of a...
I'm very sorry, I meant petition to be a candidate on the ballot.
Yes, so there have been a number of cases about that, and often, for example, there was the, well, it doesn't matter what the case, there have been a number of cases about that, and the court has been clear, I think, in a number of cases in distinguishing between infringements of the right to cast a ballot that will be counted and infringements of the right of candidates. I mean, this was the case in Winston versus Moore, having just the top two vote getters from the primary appear on the ballot, and the result in the analysis was that those are different than restrictions on actually counting a ballot and casting a ballot. So the analysis, I submit, would likely be different, although it would be different in the sense of the standard of scrutiny applied. But of course, I think the analysis would be the same in terms of, is there a legitimate burden? Because this is typically how it works with all constitutional analysis.
I think that's a very good response. The upshot of that perspective, or that holding, I suppose, would be that in the panoply of Article 1 rights, the associative right, or call it what you will, the right to stand as a candidate to participate in the government as a putative elected official would be inferior in the constellation of rights to the right to cast the vote.
So, Justice White, when I was answering your last question, perhaps I apologize for any confusion, I was thinking of a challenge brought by a voter, not by the candidate, him or herself. The answer may well be that in terms of the associational right, to the extent that's a similar fundamental Article 1 right, the level of scrutiny would not be significantly lower. Because again, this court, to my knowledge, has never applied rational basis review, and I don't mean to be just ignoring the distinctions between various forms of heightened scrutiny, but this court has never applied rational basis review to an Article 1 fundamental right, and I certainly don't think it should do so here with what this court has called the most preservative of all rights. I do want to, if I can, turn to the second interest that the appellants have put forward, which is voter fraud. They say the state's interest in detecting, prosecuting voter fraud suffices to justify disqualifying ballots. Now, as you heard, the argument rests largely on the Mahaliak case, the one case they have been able to find in which the date requirement, or the handwritten date rather, was used in connection with voter fraud. I want to address why Mahaliak doesn't provide as much support as appellants submit, but our fundamental submission is that a single case across the entire Commonwealth and through all the years in which the date requirement has been on the ballot, on the books, and enforced, a single case in which the handwritten date played some role in furthering the state's interest in preventing voting fraud is not remotely sufficient to justify disqualifying thousands of ballots, denying thousands of Pennsylvanians in every election their Article I fundamental right to vote. And that the Eakin Court made the same point 2 weeks ago. Commonwealth Court has made it previously in Burke County decision. And Eakin made the further point that it's particularly true what I just said, given that even if this court were to affirm, and I alluded to this point earlier, even if this court were to affirm or to agree with us, whatever role the date requirement, the handwritten date, plays in furthering combating voting fraud and the other interests we've discussed, it could continue to play that role. Now, that gets into why I submit the Mahaliak case does not provide as much support, so let me give the details there. Appellants agree in their reply brief, Mr. Gore said it again this morning, that even in that one case, the handwritten date did not play a role in preventing the ballot in question from being counted. So it has concededly never been the case, or at least no one has found a case, that the date requirement has actually prevented anyone from affecting the outcome of an election or even the count of an election. And that goes to my fundamental point that I made just a minute ago about one case not being enough to disenfranchise thousands of voters every election. It's also consistent with the representations of the boards of elections in the federal cases and of the Philadelphia County Board of Elections here that it doesn't use the date requirement to detect, prevent, et cetera, voter fraud. Now, they made the point in the one case, in Mahaliak, it was used to prosecute the defendant. And they say at the bottom of page 21 of their reply brief, Appellant's reply brief, and Mr. Gore said it again this morning, that in Mahaliak, the handwritten date was the only evidence of voter fraud. Okay, that is not correct. What they call the charging document in their reply brief, it's the affidavit of probable cause, and it's page R220 in the reproduced appendix. In the affidavit, the detective, in fact, points to 5 other pieces of evidence of voter fraud. So the ballot arrived, the ballot of the deceased voter, so the voter whose ballot was miscast, their ballot arrived 2 weeks after the voter had died. So that gap in time is number one. The ballot was received on the same day as the defendant's ballot. So that coincidence, also noted in the affidavit of probable cause. The defendant requested the ballot for the other voter who was her mother. That's number 3. The 2 ballots, the defendant's and the mother's, were requested on the same day. Number 4, this is all on R220, all in the affidavit of probable cause. And number 5, also on R220, the defendant confessed. So at most what we have is a single case across the Commonwealth, across the years, in which the handwritten date was at best one of 6 pieces of evidence that could have been used to prosecute the defendant. Again, that is simply insufficient to justify denying people their Article I fundamental right to vote, particularly given that it could still do that, as I said earlier. If this court were to affirm, people would still have to write down the handwritten date as a matter of statute under Ball, and I submit they would continue to do so, and it's not just my submission. In the Bonner case that we cited from the Commonwealth Court noted that after Migliore had invalidated the date requirement, temporarily as it turned out, and after the Commonwealth Court itself had invalidated the date requirement in Berks County, temporarily as it turned out, Bonner said that after both of those, a majority of voters continued to write down the handwritten date. And I submit that makes perfect sense because it is still going to say on the envelope, required, date. And perhaps they should, but people may not keep up with all of the constitutional decisions of this court, may not understand everything that this court has said. What they will understand is what they see in front of them on the mail ballot, date required.
But it's not required if you win.
It would be required as a statutory matter. What would not be permitted would be not to count their ballot. So it may be something of an existential debate, is something required if there is no consequence,
right.
But it's meaningful here because what we know is the question would be, I mean, this part of my argument is that the date requirement could continue to serve its purpose to whatever extent it does serve those purposes. That's not even an essential part of my argument, but that part of the argument, the existential difference, does matter because people will still see required. I doubt very much that the Secretary of State will start to write required except under Baxter, your ballot cannot be counted.
Arguably, it's a misrepresentation of question of whether it's required if you're notifying voters that something is required when something isn't.
I don't think the fact that, this goes back to the discussion Chief Justice Todd was having several hours ago with Mr. Gore, but I don't think the fact that there's not a particular consequence permissible means the requirement does not exist. The language would still be in the election code, and it would still, as a matter of statute, under Ball versus Chapman, be required. It is true that the particular consequence could not be enforced. Could the legislature put other consequences in? Could it say, if you don't date it, next time you have to vote in person? You know, I don't know. Those are all sorts of hypotheticals.
Do you agree that something's either required or not required? To use Mr. Loney's term, isn't that binary? Either something is required or it's not required. Are you going to try to back into the whole directory thing now?
I'm certainly not going to do that with you, Justice Weck, but I am going to agree that something is either required or not required, but that is a different question from whether particular consequences are permissible.
Whether there's a penalty to violating the requirement.
Exactly. The question is just, the question here, certainly, as the entire way we have framed the case, is the particular consequence permissible? And our submission is the answer is no. I want to touch very quickly, unless there are further questions on fraud.
Well, just one thing on that. Would you agree that, I mean, speaking of solemnity, would you agree that at some point approaching something that is required by law as inconsequential makes a mockery of the law?
I'm sorry, Justice Weck, could I ask you to, with apologies, could I ask you to repeat
Well,
that?
if we're all required to obey the crosswalk sign, but we all blow it off and there are no consequences for anybody, eventually it becomes a mockery, right?
I don't know if that's true or not, Justice Weck, but I would say that is not the solemnity argument that appellants have put forward. I mean, the solemnity argument, of course, that they are putting forward is that writing down the date, now it's just a month and a year, makes people take the act of voting more seriously. Now, there is no case that has embraced that argument. The Fifth Circuit case that they point to was, number one, about a signature requirement, and number two, didn't even endorse solemnity in its federal constitutional
Let's forget
analysis.
solemnity for a moment.
Happy to forget solemnity.
Mr. Volchok, and do you have a problem, do you see any problem that we should note as the Supreme Court of Pennsylvania with some ruling which would tell people that something is required, but you know, it's not really required?
I would not urge the court to rule in those terms, and those are certainly not the terms that we are presenting this case. What we are saying is the court should say, we have previously held that it is required as a statutory matter under the election code, and that remains true. However, disqualifying a ballot for failure to comply with that requirement is not a permissible consequence because it violates the free and equal elections clause. I do not think
that's basically a constitutional invalidation. I would think that it would be less absurd to just strike it as unconstitutional rather than to say it's required, but never mind.
so. I want to stay with the arguments that we have presented to this court. We have not presented to this court the argument that the date requirement itself is invalid, and this court brought up only the question of whether enforcing the date requirement violates the free and equal elections clause. Our answer is no. And again, it goes back to the somewhat existential, what I called existential debate or difference that I was discussing with Justice Brobson about, can something be required if there's no consequence for it? Again, in theory, the legislature could impose other consequences. To me, it is not correct to say that it is not required at all because one particular consequence that the legislature has put in place, even if for now that is the only consequence, cannot be enforced because of constitutional mandates.
Just one follow-up on that. You're saying then that if I take your point that the General Assembly could impose consequences, including something of a penalty nature for failing to comply with this statutory requirement, but the one thing they can't do by reason of the free and equal elections clause is not count the vote.
Correct. Now, other penalties that the legislature might put in place would, in theory, be subject to constitutional challenge. I don't know what they are, so I'm not in a position.
Yeah, I don't know what they are either.
Well,
Can I
sure.
ask you, are you in the alternative asking us to overrule our prior case law holding this to be mandatory?
So, Chief Justice Todd, the Pennsylvania Democratic Party included that in its request that this court take up the case. This court declined to take that up. There was a dissent from that part of it to justices. Obviously, it will not surprise anyone to hear. We agree the court should have taken up the question that we put in front of the court. But no, we are not given the questions, the two limited questions on which this court
accepted for review.
That is our understanding of how this court has brought the case to it for decision. Another way the court has brought the case to it for decision was after rejecting Appellant's request to reverse solely on the ground that factual development had not been required. So back to the earlier colloquy about what the record shows and doesn't show, our understanding is that this court has brought the case to itself based on the record that exists. And again, to the extent the court deems it appropriate to look beyond the case in light of the two federal cases. Unless there are further questions, I would turn very quickly to my second overarching issue, which is this point about whether the court has already decided rejected our constitutional challenge in either Pennsylvania Democratic Party versus Bookfar or Ball versus Chapman. Our answer, of course, is no. The appellants have cited no case suggesting that either case did so. The Genser case, which was actually the Attorney General's petition for rehearing to the Third Circuit yesterday, quoted the language from Genser that rejected a similar overreading of PDP by appellants. And it's very difficult to understand given that no one in PDP made the argument that we are making here. Mr. Gore suggested it's the same argument. It is not the same argument. The argument that was made in PDP was that the government has to affirmatively help you comply with the date requirement. Not that the date requirement is invalid. There is a meaningful difference. If relief had been given in PDP, people's ballots could have still not been counted for failing to comply with the date requirement if they were given notice and an opportunity to cure and didn't take advantage of it. So Mr. Gore said we're seeking the same relief here. We are not. No case has held that either PDP or Ball previously rejected our constitutional challenge. I ask this court to affirm.
Okay, thank you very much, Mr. Volchuk. Let's hear from Mr. Fabens-Lassen.
Good afternoon, Your Honor, and may it please the court.
Up, please.
Good afternoon, Your Honors, and may it please the court. I'm Ben Fabens-Lassen here on behalf of the Philadelphia County Board of Elections, which is the only election administrator that's a party to this case.
You're going to have to pull the mic up further, please. Thank you.
Is this better if you...
Speak into the mic.
Thank you, Chief Justice Todd. The Philadelphia County Board is the only election administrator in this case. The board does not rely on the handwritten date on a mail ballot declaration, period. It does not and cannot use the date for purposes of verifying a voter's eligibility, assessing the timeliness of a ballot, or detecting fraud in the electoral process. And that's because the date on a declaration simply reflects the date on which the declaration was signed. That date is not relevant to the question of timeliness or eligibility. Eligibility is determined before a voter ever receives a mail ballot, and timeliness is based on when the board receives the ballot, not when it's filled out by the voter. Instead of using the date on a declaration, the board relies on time stamping of mail ballots and separation of untimely ballots from timely ballots to ensure that only timely ballots are counted. Even though the completion date of a ballot declaration is not relevant to the process, the board can know with certainty that all ballots received by 8 p.m. on Election Day have been completed during the proper time frame.
Counsel, I'm curious though, why, is there any dispute in this case that the Board of Election doesn't use the date on the verification?
I don't think so, Your Honor, although there does seem to be a view that it serves some functional purpose.
Well, that's a different question. I mean, I don't think anybody's arguing that the board does anything with the date. I think the question is whether the General Assembly intended that the date serve some purpose. Now, that purpose could exclude any use by the board.
That's certainly true, Your Honor, and our position is that the board does not use it for any purpose. The governmental interest...
I'm not sure that's in dispute.
It may not be in dispute, Your Honor, but I do think it's an important factual component of this case, and it's important for the court to understand insofar as it affects the government's interest analysis and even the severability argument insofar as that's important to...
You also don't use the signature for anything, right? You don't have a signature expert, right?
We do not, Your Honor.
So do you use the secrecy envelope for anything?
Well, Your Honor, the board complies with the election code, so it does.
Or do you just open it?
We open it and we ensure that the secrecy code is not, or sorry, the secrecy envelope has not been marked and has, any of the things that are required under the election code as part of the canvassing process.
If a ballot doesn't have a signature, if verification doesn't have a signature at all, what do you do?
If the ballot declaration does not have a signature, we will set that aside and not count it, and that's consistent with the law. And that ties back to a broader point of this case, that the board's interest here is complying with the law and understanding the certainty of its obligations.
But isn't it also consistent with the very same law and the very same provision that if it's missing a date, you should set it aside?
That's correct, Your Honor. So
You'll set it aside for a lack of a signature, but you won't set it aside. You don't want to set it aside for a lack of a date because you don't use it. You don't use the signature and you don't use the date, but you will follow the law, set aside something with a lacking signature, but you want us to rule differently on a lacking date.
I would respectfully push back on the idea that the board does or doesn't want to do anything in this case. What the board wants to do is comply with its statutory and constitutional obligations here. And so, with respect to the signature, with respect to the date, if this court orders as a constitutional or statutory matter for us to count those ballots or not to count those ballots, that's what we're going to do. The point is that on the constitutional question, both the state and federal constitutional question, there's been a tremendous amount of uncertainty and change in law over the course of the last 4 years. And so I don't mean to be disrespectful at all to push back on the premise, but it's not that we are asking this court not to enforce the date requirement or to impose a particular remedy. There's a reason we didn't take a position on the constitutional question. Balancing the governmental interests and understanding how to take the fundamental right to vote and the inherent necessity in voting regulations and how those interplay in the context of the Constitution is a challenging question that's left for this court. We will comply with the court's guidance on those questions. The point here is that we think that it is important for the court to understand, however, that from a functional matter, the date serves no purpose, and it imposes significant administrative burdens on the board to comply with.
Does the signature serve any purpose?
The signature does serve as an attestation of whether the voter is qualified to vote and whether they've whether they previously voted in the election. So by signing that, they're verifying that.
The person who signed it is the person to whom the ballot was sent.
Well, so we do make sure that there is a signature on each of the ballots. So it does serve that functional purpose. Once you know there is a signature on the ballot, you know the voter has declared that they are someone.
Someone declared. You don't know it's the voter.
Well, right, and that's the challenge with respect to all of this, Your Honor. For example, with respect to the dates, the board has no way of verifying whether the date that's listed on a declaration is actually the date on which it was completed. It's part of why it doesn't have a flawed.
I think from a factual perspective, your point makes sense. You don't use the date and you don't use the signature.
I think that's true, Your Honor, and insofar as it is part of the constitutional analysis, we do think that is an important perspective for this board to understand. Again, we don't take a position on how you balance that interest, but certainly the fact that the board has set aside thousands of votes based on a requirement of this court that we don't use for any functional, administrative, or security purpose is something that the board has an interest in understanding whether that is constitutional and consistent with its constitutional obligations. And
We should focus not only on burdens on the voter, but burdens on the Philadelphia Board of Elections?
no, Your Honor. We don't believe that that's part of the constitutional analysis, or at least we don't understand the parties who are taking a position on that constitutional claim to be doing that. And again, regardless of how this court rules, we will comply with the election code, full stop. But we do think it is helpful for this court to understand that the process, particularly in a county like Philadelphia that receives hundreds of thousands of mail ballots, is at times an onerous one of reviewing manually each ballot to check a correct handwritten date on it. And again, whether that has any bearing on the constitutional analysis is for this court and this court alone to decide. But we
It's clear that you don't want our job and we don't want yours.
I think that's fair to say, very fair to say. But it is a process of manually reviewing. And so since Ball was decided, or after Ball was decided, at least up until the Eakin injunction was issued in March of this year, the board has implemented procedures to manually review every ballot and ensure they have the correct handwritten date. That is a time-consuming process, but it is one where when we see an undated ballot declaration or one that doesn't have the correct date, we set that aside and deem it insufficient under Section 3146.8G of the Code. That is the law under, at least until Eakin declared that that was a federal constitutional problem. That's what we did, and that's what we will continue to do if the law changes. I do want to point out two things about, I do want to come back to the point that as a purely factual matter that stems from the code, the board can be certain that even undated ballots were completed during their proper time period under the election code. The board knows when it sends every ballot out to voters, and it knows when it receives each ballot from voters. Those are essentially the bookends of the mail voting process. And so regardless of whether a ballot is in fact dated, it's not possible for a timely ballot that comes in before 8 p.m. on election day to have been filled out outside of that time frame. I do want to briefly turn to 2 points that came up earlier. To Chief Justice Todd's point about stamping and the Sure system, they're certainly correct. But I do want to flag one other part that sometimes gets lost in the briefing and discussion on this issue, and that's separation of timely and untimely ballots. That is a part of our process. That is in some ways the best way of ensuring that no untimely ballot gets inadvertently counted. We ensure that all of them are segregated. Any ballot that comes in after 8 p.m. is separated from those that are otherwise. And we lock all the lock boxes at 8 p.m. And so part of why that's relevant is to understanding the process, but it also goes back to my friend from the Attorney General's office backdating point. What's interesting is the Sure system actually is the backstop. We're framing this as if the Sure system fails, the date is the backstop. No, the Sure system is the backstop for what is an actual separate process of stamping and segregating all ballots. And if the Sure system were to fail, we would still do what we're doing. We would be able to look at whether the stamp reflects a timely ballot was received. We could look at the barcode to match the date, the voter's name, and the barcode at least is based on information that gets uploaded to the Sure system. And then what we couldn't do is look at the date on the handwritten ballot, or the declaration, and make any determination of timeliness. The election code simply does not allow the board to use the date a ballot was completed as a proxy for when it was received. So in that unlikely instance of a Sure system failure, there simply is no way that the date would be used. We would still use what we always use in the first instance, segregation and time stamping. And I think that kind of ties back to the metaphor that was used about belt and suspenders. The idea is that the belt and suspenders are what hold up the pants. But the handwritten date doesn't do that. In some ways, it's more like this tie. It has no functional purpose, and it serves no purpose in holding up my pants at all. It does nothing. And so I don't think the concern about backstops or double voting, all of that comes back to the fact that when you look at a date on a mail ballot, it simply is the date that a voter represented when they completed that. And there is really no factual scenario in which that date is used or serves any purpose in the election code. Understood, and I understand that there's a separate question of whether the legislature wants to use that or has some other interest. I do think that there's the arguments that if it's not being used by the actual administrators of the election code, that it's not fulfilling any other governmental interest is a question for this court to decide. But as a factual and procedural matter in terms of how we comply with the election code, it certainly does not include any aspect of that. And so I do want to come back to the fact that from our perspective and from the board's perspective, and at least based on the record in other cases, from all county boards' perspective, the date on a ballot declaration does not serve any purpose, and it doesn't solve any hypothetical or actual problem in Pennsylvania's mail voting system. That system has worked with resounding success since Act 77 has worked. It works very well. It's a secure system, it's an effective system, and it's one that's been carried out with integrity and has led to accurate vote tallies. Since Act 77 was enacted, the board has worked in good faith to implement those processes to ensure that universal mail ballots are available to hundreds of thousands of Philadelphians and to carry out the election code and elections with integrity. What I'd say is that although we believe that enforcing that date requirement creates burdens on that process, we will certainly continue to carry out our statutory obligations in good faith, no matter how this court rules in this case. But we would respectfully urge this court to resolve this case in a way that protects universal mail voting in the Commonwealth.
Well said. Thank you very much. And I would point out, Mr. Fabian's lesson, that in our 3-hour plus arguments here, you're the only counsel who made us laugh.
No, that's not true. When you referred to his wife, that was sort of funny.
Okay, all right. That's true.
That's quite the distinction.
Thank you all.
Thank you, Chief Justice.
Tremendous arguments on all sides here, and I'm sorry we didn't get to hear from Mr. Levine or Attorney Gallagher, but I want to compliment all of you. You can tell your clients that you did the very best job possible. They were tremendous arguments, and we thank you. Mr. Minner, would you adjourn for lunch? We will resume at 1:45. Pennsylvania Constitution rights were coterminous with its federal counterpart. The issues in this appeal are whether Article 1, Section 8 of the Pennsylvania Constitution provides greater rights to the people by barring reliance on the high crime character of an area as a factor for finding reasonable suspicion for law enforcement to pursue and detain an individual, and whether appellant properly preserved this issue for our court's review. Good afternoon.
Good afternoon. May it please the court. Leonard Sosnow from Mr. Shivers. So this argument, like the one this morning, also involves a fundamental right under Article 1 under the Pennsylvania
You're
Constitution.
not going to take 3.5 hours like the one this morning, are you?
I was going to say that's the first distinction. There's there are two more that I think actually have some importance as I sat there listening for 3 hours. One is there is no statute here. There's no deference of any kind. There's no presumption of constitutionality. So no separation of powers concerns. This just involves a core function of this court in interpreting Article 1, Section 8 of the Pennsylvania Constitution. The other important distinction, I heard over and over again this morning, putting the date on the envelope, that requirement is neutral, non-discriminatory, doesn't hurt any subsection of society. This case is the polar opposite. The issue here is whether Article 1, Section 8 permits people to have less rights than other people based solely on where they live. Because this case, this court recognized way before the United States Supreme Court that flight is not enough to establish reasonable suspicion. It falls far short by itself because there's so many innocent explanations. This court did it in 1973 in Jeffries, 1979 in Barrett. The United States Supreme Court didn't get to this issue until 2000 in the Wardlow case. The Wardlow case came to the same conclusion as this court did in Jeffries and Barnett, that flight in a high crime area, flight in general is susceptible of so many possible innocent explanations. It doesn't establish reasonable suspicion. It means if you live in a low crime area, you live in a middle crime area, you live in a mid-high crime area, you can run away from the police and they cannot stop you. They can't tackle you like Mr. Shivers. They can't stop you at all. Except they carved out a constitutional exception under the Fourth Amendment. People that are in high crime areas, oh, that's reasonable suspicion. And there are a couple things, before I get to general problems with high crime, there are a couple of things about the United States Supreme Court relying on high crime area in this context with flight that are unique and different than any other cases where high crime area is involved. So sometimes courts consider high crime area as a factor among many. Here, only in this context, where the person lives, where he flees, is all defining as to the rights. If not in a high crime area, no reasonable suspicion, police can't do anything. If you are in a high crime area, per se it is reasonable suspicion, and you can stop somebody. So that's unique. And it is, my opponent argues, oh, totality of the circumstances. There's no totality. It's high crime area. It's all defining. In fact, the judge a couple of years ago, a lower court judge, hearing testimony from the officer who stopped the individual, said, okay, I heard he ran away, high crime area. I didn't hear anything else that was suspicious about what he did. There was no radio call. There was no report of a disturbance. There was nothing. And you didn't know who the defendant was. And he granted a motion to suppress. The Commonwealth appealed in the Barnes case, which is on page 12 of my brief. In the Barnes case, the Superior Court reversed. They said it's been well established ever since Jefferson in the Superior Court in 2004. If there's flight in a high crime area, it equals reasonable suspicion. Judge can't.
Could I ask you if you found agreement in this court about the fallacy of the general presumption on a high crime area. How would you feel about a more narrow observation? How about a building that was known for high crime, or a particular gas station parking lot that was known for high crime? So instead of an area or community, you're talking about a particular high crime location. Would you have any problem with that?
Yes, I would. I think high crime area shouldn't be considered at all. It's not exactly the same thing as on the street, and it's certainly different from this issue.
I know, but I'm trying to narrow it. I'm trying to understand, is there some degree that we could go to that you would be comfortable with?
No.
What about
The court does not have to reach that issue, though, whether I'm comfortable or not. The narrow question here is high crime area with flight.
what
If
about,
the court,
what about
It
instead,
wasn't
what
an
about
issue
instead of a,
stated whether you're
What?
comfortable.
Pardon me?
What I meant was, how do you feel about that argument? Do you think that's a legitimate narrowing of the high crime exception?
no, and I'll answer that first rather than get back to why high crime area plus flight shouldn't equal.
what if it's not a high crime area? What if we're in Rittenhouse Square in Center City, Philadelphia, and you see a bunch of known gang members who are a violent gang, and there's a person standing with them who may or may not be part of the individual. He sees a uniformed police officer approach. He starts backing away, and then he starts running down the street, holding on to something in front of him, consistent with holding a heavy object, which police have seen before. Is that reasonable to assume
I
that
still
maybe that
think high
guy
crime area,
has
I'll
something?
give the reasons why high crime area shouldn't be added to the
I didn't say high
analysis.
crime area.
Pardon me?
I didn't say high crime area. I'm
Oh.
a police officer, and I'm in Rittenhouse Square, not a high crime area. It's beautiful. Or Chestnut Hill. How about Tony Chestnut Hill?
That's
Leafy.
a different question, though. Could I get an answer to my question first about, can you narrow it down?
I thought he said no.
Did you say no?
I said, no, it should never be a factor, but the narrow issue in this case is flight in a high crime area. But so I'll answer now, explain why I think it should never be a factor.
All right, but then I do need you to
There-
answer Justice McCaffrey's question.
There are a lot of deficiencies in considering high crime area that are pretty serious. And one is, it has nothing to do with the defendant. The standard is well established. Pardon me? That was a nub of Hicks, which I'm going to talk about. This court's decision in Hicks. It has nothing to do with the individual. It's some other people in the past. It has nothing to do with the present and this defendant.
You would buy that no matter
Pardon me?
whether you're talking about the community or whether you're talking about a building or a street corner or a gas station parking lot, you think the argument's the same?
As far as high crime area, not to be considered as a factor. There might be specific things from the officer's experience, possibly, that could be taken into account, but not the high crime area.
Okay, well,
Would have to tie.
Justice McCaffrey's question then?
I kind of forget what it was at this point.
Some real suspicious conduct in Rittenhouse Square. Well, if you have enough suspicious conduct, it can add up to reasonable suspicion.
Yeah, I was thinking to the facts of this case. I mean, we're talking about a high crime area, but the defendant was also seen standing with a known gang members, the Ozone Gang. Police officer's uniform approach, he starts backing away, and then he starts running down the street holding something in front of him like he's holding a gun. The police officer sees that and chases him.
The facts are a little different, though, in our case. The facts are that he was definitely not a member of the Ozone Gang.
He didn't say that. They said he didn't recognize it. He wasn't one of the individuals recognized as a member of the gang, backed away, starts running down the street, and he's holding on to something in front of him as if he's holding on to a heavy object.
Not exactly. I have to disagree about the facts. So first of all, there were no facts establishing that he was a member of the Ozone Gang. In fact, the opposite, because the officer saw five guys together.
Let me break it down, because I'm a simple guy. What facts do you think would prove or show he is a known member of the Ozone Gang member?
Well, one could be that he was recognized. You can't assume that every single person, somebody sitting near somebody who's a member of the gang, is a member of the gang. I mean, you have a right to go where you want in your neighborhood. There are gangs. This officer testified there are a number of gangs in the area. Just because you're sitting near somebody, because the officer said there are five guys sitting there, I recognized two of them as members of the Ozone Gang. Mr. Shivers was sitting with Mr. Burry, not with those guys, and he said, I don't know Mr. Shivers from anywhere. I never saw him before, I don't know anything about him. So you can't infer that he's a member of the Ozone Gang, and in fact, the lower court did not, nor did the Superior Court. And the business about his hands in front of him, I'll just say the testimony was twice. His hands were in front of him, and I could not see anything other than his hands were in front of him. And that indicates to me, from my experience, either he had a firearm or he's trying to hold up his pants. A lot of young men wear baggy pants, and that's in his experience. So he didn't say, from my experience or anything else. So, and the lower court did not rely on that testimony at all. In other words, the DA, and I'll back up a little bit, at the end of the suppression hearing, the DA argued, Judge, the defense counsel argued, they didn't establish reasonable suspicion, blah, 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 blah. District attorney, very short argument. Judge, unprovoked flight in a high crime area, reasonable suspicion. The judge's ruling, and in her opinion, said, you lose unprovoked flight in a high crime area. In other words, she didn't find any suspicious facts about him possibly being a member of the Ozone Gang or possibly, holding a weapon.
Aren't all these factors in the totality of the circumstances analysis? I mean, you're trying to isolate all of these particular issues, saying he could have been holding his pants up or he could have been holding a gun. He could have been a gang member or he could have been just hanging out on the corner near the gang members. It may or may not have been a high crime area, but aren't what we're looking at here in the law a totality of circumstances that leads to a reasonable conclusion of reasonable suspicion? I mean, you're a prominent Philadelphia defense attorney. If you're driving at 52nd Market Street and you see a guy look in your direction standing there and he's standing with a bunch of your former clients who are gang members, is it reasonable to assume maybe he's a gang member? Maybe, maybe not. But if you parked your car and then he started backing away and started running down the street holding on to something, what would you think?
So if it's a high crime area, you're giving a hypo where it's a high crime area because, we'll say, the Ozone Gang is committing a lot of crimes in this area, and he's a member of the Ozone Gang.
It's a violent area. It's a violent gang, West Philadelphia, right?
So is it completely irrelevant, high crime area in that context? No. But is it minimal relevance, high crime area, in analyzing whether that should be used by this court in general?
Sorry, why would it even have minimal significance? What's the difference if he's in Rittenhouse Square with 3 known gang members and then he runs? What does being in a high crime area add to that equation?
It has a very minimal relevance statistically. In other words, if you're in an area where there's a whole lot of crime, and I'm going to explain why statistically it's pretty meaningless, but if there's 10 times more in general likelihood of crime in that area, statistically, it's not completely irrelevant. That's my only concession. It's not completely irrelevant.
Why would it be irrelevant?
We would just say it's highly relevant for patrol, for police staffing decisions, for all manner of command priorities and decisions by the police department. Certainly very important for that. But for purposes of building individualized suspicion in court, it's not. Why don't we just say it that way?
That's exactly my position, and I think Hicks is the most relevant case. In Hicks, the Superior Court had found before if police have information that's reliable that a person may have a gun, they can stop the person. That was the Superior Court's holding for a number of years. This court overturned Superior Court and said there are some major problems with that because many people carry guns lawfully.
Counsel, let me ask you this. The incident is at Kensington and Allegheny. Commonwealth asks me as a trial judge to take judicial notice that Kensington and Allegheny is a known agree? Can I accept judicial notice, an uncontested fact?
You can take judicial notice of a fact that should not be considered in your evaluation of whether there's reasonable suspicion.
Why not?
Well, okay, I'm about to give two more reasons besides the fact it's not conduct. So Hicks, the main thing was that Hicks, over and over again, the court said the standard is individualized, ever since Terry.
So let's
Individual.
say we're at Kensington and Allegheny. I'm a white male in a Lexus. I'm parked at Allegheny, and I see an individual leaning in. I'm the officer. I see an individual leaning in my car window. And there's allegations of a brief exchange of some green object or something.
And then he runs. Okay, so the difference between that and what we're dealing with here and with Hicks is that you have two instances of conduct. You have the flight and you have the hand-to-hand transaction with the officer from knowing the area and knowing the location knows that there's a good chance.
I have an individual, let's use it, I'm a white, middle-aged male, and you see me under the L. I'm standing in a group of people, 3 are nodding, the other 4 are just walking around. It's obviously, there's needles on the ground. I turn around, I'm wearing a tracksuit, I see a police officer, and I run away into my Mercedes and I drive away. What's your position?
My position is there's no reasonable suspicion. But
No reasonable suspicion based upon the fact it's a high crime area where it's notorious that individuals not from Philadelphia come purchase drugs from drug addicts down there?
I'm not arguing factually. We know it's flight. Let's start from the starting point. Flight. And it's far short of it, this court has said. Far short. So you're starting with the only conduct, in my case, the only conduct is far short of reasonable suspicion. High crime area and a situation where the conduct, the only conduct, is far short of reasonable suspicion. High crime area cannot bolster it to the point of reasonable suspicion. Hicks, if I get back to Hicks. In Hicks, this court said you can't make individualized determinations of reasonable suspicion as the Constitution requires based on generalities. And a lot of people who have guns have them legally with a license. And therefore, it does not add up to reasonable suspicion, even though the Commonwealth argued this was 3 a.m. in a high crime area. Undisputed facts, 3 a.m. in a high crime area. This court held high crime area doesn't matter. If you've only got one instance of conduct, like flight, high crime area can't bolster it to reasonable suspicion. And I'll cite Barr, which also it ended up following the rationale of Hicks. In Barr, they smelled marijuana in a car. Maybe the driver was smoking marijuana or whatever after that lawful traffic stop. And the issue was whether they had probable cause, reasonable suspicion to do anything with the driver.
How do you distinguish this from our second decision in DM?
Well, DM, first of all, it's very distinguishable because high crime area was not a fact in DM. No, it wasn't. Sorry, I disagree.
We had to follow Wardlow, right?
So,
We had to apply Wardlow to the review of DM.
but the reason,
Wardlow was high crime area. Are you going to tell me that wasn't in essence of Wardlow?
no, I'm asking this court under Article 1.
I'm asking you a direct question, sir.
Yes,
Was high crime area an issue in Wardlow?
yes,
Were we required, this court required to review the facts of DM
right,
based upon Wardlow
yes.
with the consideration of a high crime area? Yes.
No, because there was no high crime area. If DM, there's no facts of the high crime area.
I understand your credibility or your position.
I'm just factually telling Your Honor, I'm factually telling.
Your version of the facts, but that's okay.
Okay, I invite the court to look at that. But if DM, in fact, held that, it should be overruled. The question as presented was, if somebody flees and there was a report, an anonymous report of that person being engaged in criminal activity, does that add up to reasonable suspicion? That was a question considered by the court and decided by the court.
Justice Brobson has a question for you.
I think I fully grasp your argument. You are definitely advocating for a departure claim under our Pennsylvania Constitution from the Wardlow decision, correct?
Yes, so we should not follow Wardlow.
But if we applied Wardlow, game over.
Correct.
Okay.
The holding in Wardlow is high crime area plus flight equals reasonable suspicion.
So on your departure claim, what I'm trying to understand is, I know that we have historically, or we have departed, historically or not, on sort of the idea of what areas are given greater privacy interests than other areas. Alexander comes to mind with the vehicle and us not recognizing a vehicle exception. Have we ever used a departure claim or ruled on a departure claim under an Edmunds analysis with regard to what constitutes probable cause, what constitutes reasonable suspicion, sort of the standard to avoid an unreasonable search, not whether something is a piece of property is protected? And this is my concern on a very long question. Law enforcement already have to be pseudo lawyers to understand what meets reasonable suspicion and what doesn't. And I'm a little concerned about the idea that there are going to be two types of reasonable suspicion, two levels, two types of probable cause if we sort of go down this path. I may be wrong. We may have already done this. But if you have an example, I'd love to hear it.
So a couple of things. I mean, one is the standard has always been the same. The standard that this court uses for reasonable suspicion and probable cause is the same, the standard.
Same as the federal standard.
Yes, the standard. In other words, how you evaluate it. But then when you have a set of facts and you're applying the standard, and it might be a common set of facts, this court may come to the conclusion that's not probable cause, that's not reasonable suspicion. This court did that in Hicks.
But let me ask you about the departure claim, sir. Commonwealth versus Bishop, can you share with us where the Edmunds factors were raised and discussed in the trial court such that it was preserved? Because it appears this departure claim is arising here in violation of Bishop, which would mean this case may be IG because the issue's not before us.
Bishop is an opposite. The case that's controlling here, and it was preserved. There was no Edmunds argument in the lower court. I'll explain that. Alexander was decided after Edmunds. Alexander was decided after Bishop. And in Alexander, what the lawyer did was identify the issue involved in the case. Filed a form that said Article 1, Section 8 was violated because there was a search without a warrant of the car. The lawyer, pardon me? Well, I'm
Share with me. You have to preserve the concept of the departure claim is to permit the trial court some opportunity to distinguish or decide that it's not coterminous with the U.S.
I'm well aware of that. And this is not a situation where you can argue to a lower court. It's unlike Bishop and like Alexander.
Motion to suppress, was it not?
Yes,
Why would you not argue in a motion to suppress?
because you'd be wasting the judge's time, and I'll explain why. It's a total waste of time. In Bishop, it was an issue of first impression under the Pennsylvania Constitution. Therefore, a common pleas court judge, Superior Court, they could rule, I think, it was a violation of the Pennsylvania Constitution, Article 1, Section 9. In Bishop, issue of first impression. The court has an obligation to decide issues. In Alexander, the lower court, one of the main reasons there's no waiver in Alexander is because Gary was directly on point at the time. The lawyer can do Edmunds, he can do law review articles, the lawyer can do whatever he wants, the defense lawyer, in the lower court, and at the end, and I've had this experience, maybe you have, Judge says, denied. I'm bound by Gary. I have no power to overrule the Pennsylvania Supreme Court. This case is like Alexander. For 20 years, the Pennsylvania Superior Court has held if you flee in a high crime area, reasonable suspicion under the Fourth Amendment and under Article 1, Section 8. Yes, Rule 302 is to permit the judge to correct errors and to make decisions. There is no error by the judge to correct. There is no open issue that the judge can decide. In this case, like Alexander, you would only be, as has happened to be sometimes in lower courts, aggravating the judge if you start arguing something that you can't possibly win. You couldn't win it in common pleas court. The court was bound by 20 years of Jefferson and other progeny. So that's the key difference, I think. Like Alexander, but not like Bishop. And there was a case earlier this year, Foster. Yes, so Foster early this year. The defense raised a novel issue of first impression under, again, it's Article 1, Section 9, that under the Pennsylvania Constitution, unlike the federal Constitution, if police lie to an individual during interrogation, it should be held to be involuntary. Okay, that's a novel issue of first impression. If that issue had been raised in the lower court and the Superior Court, they could have ruled in the defense's favor. There was no contrary binding authority from the higher court. And the lawyer in Foster, like in Bishop, didn't develop any argument in the lower court, not even the Superior Court. And this court said significantly, not even in the Alicotter petition, here the argument has been squarely raised and decided on the merits. Superior Court decided squarely on the merits. The lower common pleas court decided squarely on the merits. It's in statement of errors. So it's very different than Bishop and Foster. And there's more done in this case than Alexander, much more.
Yeah, counsel, in this case, you actually made your Edmunds argument in the Superior Court, and they said, we can't help you. We can't.
We're bound.
We're bound.
We're bound.
Mr. Salazar.
And not only that, I said in my brief, I said, I know you're bound unless en banc, where the Pennsylvania Supreme Court changes the panel ruling in Jefferson and the other panel rulings, which require you to, one panel has to follow another one.
They also thought they were bound by DM. The Superior Court also believed they were bound by DM.
I know, but
which they could not. They were bound, if that's what they believed, that we did in DM.
They believe they're bound by DM, and definitely there's dictum in DM. I'm not saying it's not dictum.
I understand.
It wasn't a high crime area case. And also one reason, if this court's going to decide whether it needs to overrule DM, the Pennsylvania constitutional issue was squarely raised in DM, and it was dismissed in footnote 2 with no analysis at all.
Mr. Salazar, can I go back to my question? Because I'm not sure you answered it. I think you did answer it. You referred to Hicks. I was asking for a case where we have departed under the Pennsylvania Constitution from the federal cases on what is sufficient reasonable suspicion and what is sufficient probable cause. You remember that? I asked that?
Yes.
Okay. And you cited Hicks. Hicks was not a departure case. Hicks was a Fourth Amendment case. So I'm saying here you concede that for Fourth Amendment purposes, at least according to the United States Supreme Court, the police officers had reasonable suspicion here.
And concedes the person.
Yeah, right.
And
yeah. Now I'm asking you, have we ever recognized a departure claim that says, oh yes, that's reasonable suspicion under the United States Constitution, but it's not reasonable suspicion under the Pennsylvania Constitution? Because Hicks didn't do that. So is there a case where we have done that?
the closest case is Mattes, where this court didn't change the seizure standard. The United States Supreme Court in Hidari said police can chase people without any suspicion at all. Chase is not a seizure. Go chase them. This court in Hidari D said, under the Pennsylvania Constitution, chasing somebody is a seizure. And Because our Constitution protects privacy and being free of coercive activity by the police more than the Fourth Amendment. Inferentially,
So which case is that?
Matos, M-A-T-O-S.
Okay. But that is the difference between what is a seizure and what is a search.
Correct.
So the question, though, is there's no question that this would be a seizure this would happen to your client was a seizure under the Fourth Amendment and the Pennsylvania Constitution. Nobody's disputing that.
Right, but except the chase part first would be analyzed differently under our Constitution because the chase itself has to have reasonable suspicion.
So is it fair to say then this is a case of first impression where we would be setting a different test for reasonable suspicion than the feds have?
It's not a different test. It's the same test. Reasonable suspicion, particularized as to a
Well, it's
particular...
not the same test because it will be reaching two different results.
Yes, on the same fact.
Same facts,
Same facts.
same title, different result is not same test. I mean, I was really bad at algebra.
Well, whether it's a matter of words, it's the same test as to reasonable suspicion, but they are applying it to a set of facts, fleeing in a high crime area, and this court should not apply it to that set of facts.
Presumably, if you're applying the same test to the same facts, one would reach the same conclusion. Presumably.
Except that this court has countless cases, Matos, and I can just reel off a whole lot of cases. The Pennsylvania Constitution is independent of federal Constitution.
I'm not arguing with you about that. I'm making a more nuanced point. And I think you're conceding without conceding is, no, we've never done a departure claim in the context of these facts would be reasonable suspicion under the national Constitution, but they wouldn't be reasonable suspicion under the Pennsylvania Constitution. You can't cite a case where we've ever done that. So this is the case of first impression. There's nothing wrong with that. I just want to make sure.
Offhand, but I'd say that, no, I cannot cite a case. But the general principles this court has applied over and over again as to what's a search, when you need a warrant, instance of probable cause. It's not novel in the sense that this court having a departure. And there's one thing in this case, I mean, there's two very important reasons about the narrow issue in this case, why this court should not go the way of Wardlow. As I said before, it is the defining factor. There is no additional conduct. Hicks was the exact same thing. The man had a gun. That could be dangerous if he's a criminal. But the court did not consider 3 a.m. high crime area because it's not enough to bolster individualized reasonable suspicion. In Barr, this court followed Hicks and said many people have a license to possess marijuana. And therefore, like Hicks, the idea of possession of marijuana in itself doesn't provide reasonable suspicion and probable cause. And this court also discussed another reason why, if I could talk a little bit about it, another reason why it's a very bad idea to consider a high crime area as a defining factor. So in each of the cases, Barr and Hicks, exactly like this case, you have one instance of conduct. I would submit that one instance of conduct of fleeing from the police is at least as non-dangerous or non-criminal as possessing marijuana or a gun. The point of all three situations is it has to be an individualized determination, and that's why there's no reasonable suspicion. Barr talked about another very important reason why this should not be recognized as high crime area as being the defining factor establishing reasonable suspicion. Barr quoted with approval the late Judge Strasburger's concurring opinion in the Superior Court in Barr, which the other two members of the Superior Court joined in. And Judge Strasburger said, basically, I don't understand how we can have two sets of rights. That people can have fewer rights because they live in a high crime area, and many of them are forced to live there, they have no choice. I don't understand how the Constitution could permit people to have less rights based on where they live. It's discriminatory. And it's discriminatory studies. When Wardlow came down in 2000, Wardlow said, we don't have any empirical evidence. Well, there was a little back then. It's 25 years since Wardlow. So looking again, the specific situation here, it's been recognized study after study and in cases that people in high crime areas are discriminated to some extent in the application of stops, frisks, and arrests. This court also discussed it in Bury last year when the court held that arrest can't count against a person at sentencing. The court cited a law review article in Third Circuit cases about the fact that that is a statistical fact. And because people, particularly young people, Shivers is 20 years old, because people are stopped more illegally by police and searched, and sometimes worse, they have a reason to flee, and they more often flee. As Justice Stevens suggested, for the 4 dissenters in Wardlow, the court arguably, he didn't use these words, I'll use them, the court arguably got it backwards. If the court was going to distinguish rights based on where somebody lives, because a person in a low crime area has much less reason to fear police interactions. Police aren't going around worried about guns and all, and sometimes arresting people and searching them when they shouldn't. So a person in a low crime area, if the United States Supreme Court was going to make a distinction based on where you are, they got it backwards. This is not more suspicious being in a high crime area and running. And that's borne out by common sense and the statistics. So this situation in general, using the high crime area as a factor, if the court goes beyond a narrow question in this case, it's always unreliable because the testimony is usually, almost always, it's subjective. You have an officer take the stand and he says, I made 5 arrests in this area for guns. And by the way, in this case, he's testifying 1.5 years after Mr. Shivers was stopped. So he said, in the last 5 months, I've had 5 cases, arrests for guns. Well, arrest itself, as I just pointed out, as this court pointed out in Bury, an arrest itself is a discriminatory factor. Just because you have arrests, what you have to know, if you want to really know about high crime area, you would at least have to know how many people were searched, how many people were arrested illegally. You'd have to have statistics that are ironclad. And so far, nobody has been able to come up with objective criteria for statistics that are meaningful. In this case, at the motion to suppress, not the motion to suppress hearing, a motion before the motion to suppress hearing, this was the interchange between the judge and the prosecutor. It's Exhibit D to my brief. The court, because it has, I think jokes have been made about high crime area. Everything is a high crime area. The district attorney responds, yes, Judge, the testimony usually is in Philadelphia that the area is a high crime area. We're a city of the first class. There are distinctions made, and unfortunately, in this city, everything seems to be high crime. Okay? What that means, and it has meant in Philadelphia, is that there's geographic discrimination. People in Philadelphia have less rights than everybody else in the state. And particularly those people, when the testimony comes in about this particular neighborhood, and I've made arrests there in the past, it's always discriminatory as a factor. And in addition, to some extent, the statistic, it's unreliable because it's subjective, as I've already said, it's discriminatory. It also leads to an illogical conclusion, I would submit. Let's say you're in one neighborhood where 1% of the people are committing crimes. Drug.
Right.
Pardon me?
If you define a neighborhood.
Oh, yeah, it's another problem. Right. That's why nobody can come up with objective criteria. What is the area, among other things? How do you objectively?
Well, let's stop. Maybe in Pittsburgh, but that doesn't exist in Philadelphia. There are distinct neighborhoods in Philadelphia, and we could go through them. And there are distinct areas in each section of Philadelphia that you can easily distinguish as areas that are just what that particular area is.
So objective,
I can tell you each part in all this city. I don't know whether it might be.
Justice Doherty, but the practical problem,
Yeah, let's stop with that nonsense.
well, the practical problem, as a common pleas court judge, is, and what the district attorney and the judge are talking about is, it's not just in those well-defined high-crime neighborhoods that they listen to high-crime testimony.
Crime can occur, as Ms. Justice McCaffrey said, in Rittenhouse Square. It's not going to be defined as a high crime area. But growing up in South Philadelphia, if I went to Fifth and Morris when I was a kid, that was a high crime area because everybody knew if you want to buy coke, weed, or any type of drugs, that's where you went. Everybody knew. That was a high crime area. The officers made all their arrests there. Not at 3rd and Jackson where I grew up. When they made a 3rd and Jackson arrest, it's still a crime. Wasn't described as a high crime area. It's only a factor based upon a police officer's experience being in that particular place, being an officer for so many years, and participating in his duty or her duty as a police officer, that there certain areas are definitely known. I could do it up at 22nd and Wallace or 13th. We could go, just for example, they used to say 13th and Wallace, high prostitution area. It's easy if you grew up in the city and you talk to your police officers and you have experience. It's only one factor. In it of itself, it's discriminatory if you say high crime area. Hands down, I agree with that. But the concept of high crime area is essential to police paperwork and police activity so that the judge can decide whether the evidence can prove that the crime occurred if the elements of the crime are charged beyond a reasonable doubt. It's as simple as that.
I don't think it's so simple. Your example is one block. We knew at Fifth and Morris or whatever. The testimony in the courts, there's no requirement that high crime area be about one block.
That's
It's just,
up to the Commonwealth to bring up. That's the burden on the Commonwealth. That's what this is about. Did the Commonwealth prove sufficiently that they can meet their facts?
and right now it's based on unreliable testimony, and it's just,
Yeah, but isn't that up to the trial judge to decide whether it's reliable or not? I mean,
no, judge has to allow it. Getting back to this case,
getting back to any case, a high crime area is a label. When you say a high crime area, what are you referring to? Justice Doherty is basically talking about the police officer has to basically be able to put on the record why he described it as a high crime area. We had a case a couple of weeks ago, 12th and Dolphin. The problem was you had two rookie police officers and a DA who didn't elicit information about why the officers believed it was a high crime area. So there was nothing on the record to justify their description of a high crime area. 12th and Dolphin, you know where it is?
yeah, I know where it is. I grew up in Philadelphia.
All right, would you say it's a high crime area?
No, I wouldn't say it's a high crime area. And if it is, let's put it this way. If that one block, we could agree, generically it's a high crime area, you did not get away from the problem. And Hicks, and in this case,
Hicks is a completely different issue.
not in my case.
But Hicks was a recognition that not all people who carry guns are criminals.
That's right. Not all people that flee are criminals. It's the same thing.
But in a case where we're talking about, again, we're going back to the totality of the circumstances. In Hicks, a police officer sees a guy with a gun on his hip, goes over, secures the guy, and arrests him because he believed the gun was reasonable suspicion or probable cause.
Right.
That doesn't necessarily mean anything. If I'm in an area with known drug members, gang members, I see a guy back away as I pull up and I'm in a uniform, he starts running down the street holding on to something in his waist, as I've seen as a police officer a couple hundred times. Why do people hold on to their waist, officer? Because I've made about 100 gun arrests, and about 98 of them, the person ran away and he was holding on to his waistband because that's where he was carrying the gun. He didn't want the gun to fall out.
So you've added, first of all, if I may, you've added conduct to the flight. You've added that he was holding his pants in a way that showed that he had a gun. So you're adding conduct to the flight. This case is like Hicks. Hicks, he had a gun, and it was in a high crime area. And in Barr, they smoked marijuana. This court said it's of no moment.
You're telling me the record here doesn't suggest that the police officer testified that the guy ran away when he was running and was holding on to the front of his pants?
I'm talking, there is no factor of added conduct with his pants, because he said, I can't see the hands, and it could have been he's just trying to hold up his pants, and the hearing judge and the Superior
Again, he
Court.
could have been doing anything. But
Pardon me?
he could have been doing anything.
That's the point.
If I'm a police-
Innocent conduct, that's the point. Just like having a gun is innocent conduct if you have a license. you can't find reasonable suspicion because it's in a high crime area. This case, flight, is different than when you use high crime area as one of 5 factors.
Counsel, Hicks, you were not running up against a United States Supreme Court decision on the same
right.
facts reaching a different result. Hicks
Right.
was a Fourth Amendment case. You're
Right.
asking us to depart, to say, Wardlow says what it was. Wardlow says what it says. Same facts, reasonable suspicion. They reached X. You want us to reach Y because there's something about the Constitution that says, Pennsylvania Constitution, that says we can reach a different conclusion than Wardlow.
Right.
But I'm not sure what that is because Hicks was not. Hold on, counsel. Hicks was not reaching a different conclusion on the same set of
I know
facts.
that.
Okay,
I know that.
that's what I'm trying to say is what is it that gives us the ability, other than the fact that we just don't like Wardlow, and I have issues with Wardlow.
That this court has held about 10 times that the Pennsylvania Constitution is an independent search and seizure right.
Don't disagree with you.
Okay, independent search and seizure rights, so that we, because we protect privacy more, and Matos talked about being free of coercive conduct and stopping somebody, Mr. Shivers was stopped, is coercive conduct. Matos said, we protect people's right to privacy, to be left alone, and be free of coercive conduct more than the Fourth Amendment. And in any case where this court goes further, it's citing the fundamental values. Alexander, this court decided not to follow Gary because Gary was inconsistent with our basic privacy protections in Pennsylvania.
Gary was a place.
Pardon me?
Gary was a place. It wasn't a reasonable suspicion, probable cause dynamic. But I understand you're sending me to Matos, right?
It's irrelevant.
You're sending me to Matos, right?
Sending you, it's in my brief. It's about 3 pages of my brief. Matos.
Counsel, does the right to privacy under the Pennsylvania Constitution protect flight? Does it protect flight more than the Fourth Amendment does because of the inherent recognition that a flight could be taken for any reason, and essentially Pennsylvania citizens have a right to be left alone under our right to privacy jurisprudence?
Yes. I would say it protects flight more. And if you look at what the court said way before Wardlow, what the court said in Barnett in 1979, way before Wardlow, and there was no hint in Jeffries or Barnett or in Matos, oh, wait, if this was in a high crime area, we would find reasonable suspicion.
But let me see if I could complete my thought process on this. Our right to privacy protects the conduct of flight because of the inherent right to be left alone from police interference.
Well, Wardlow protects it as well, but I believe the values of the Pennsylvania Constitution protect it more.
Well, you have to be saying that. You have to be relying on the right to privacy under our Constitution giving more rights than the federal Constitution.
In this context.
Correct.
And
that's Justice Brobson's point. What is it under our Constitution that would allow us to depart on this Supreme Court, United States Supreme Court characterization of flight as being flight in a high crime area being less protected than it is under our Constitution? It has to be based on the right to privacy, does it not?
Yes, and right to be left alone, as Matos discussed, right to be secure from coercive conduct.
Is it not also, counsel, in addition, is it not also that we can't imagine that whatever that quantum of privacy right is in one area would be less for a person who happens to find herself in area A as opposed to finding herself in area B. The constitutional right of privacy in Pennsylvania under Article 1, Section 9 can't vary according to which neighborhood you find yourself in at any given point in time. Is that correct or incorrect?
That is this case. That's one of the major points I'm making is that the only distinction between high crime area and people living in low crime, mid-high crime area is that Wardlow says you have different Fourth Amendment rights. This court shouldn't tolerate that. Under Article 1, Section 8, to discriminate based on where somebody lives. Excuse me.
No, I'm sorry. Go ahead, counsel. Excuse me.
No, to discriminate against people. And if it's going to be, a factor in the totality of the circumstances test, it should be considered a minimal factor when it's part of 6 factors or whatever, 5 factors, because you always have the problem. It's not conduct by the individual. It's not conduct at all. It's what other people have done in the past. And it's discriminatory. It's always discriminatory. And even though, Justice Doherty, you say it's easy to identify, the courts don't treat it that way day to day. I know Philadelphia, they don't treat it that way day to day. Crime area is described loosely. In this case, even the testimony was a year and a half after this defendant was seized by the police, and he starts talking about what happened 5 months earlier than his testimony. And then the district attorney says, well, was it the same back in 2019 when this incident happened? It's a little bit more now. The testimony's loose. It's often about, oh, I patrol this district or this area. You've got this subjective determination, and it's often based on, I had arrests in the past, whether they were good or bad. So I'd say, whatever weight in a run-of-the-mill case this court may decide can be permissible, minimal or a little more, it should not be, in this case, as in Hicks, it should not be the defining factor. There is no totality in this case. There's no totality.
Here's my concern, and maybe you can answer me this. Even as opposed to high crime area, we're going off on the definition. The question I have is, why is it that in a plain mere counter, our case law permits an individual to walk away from a police officer? That's what mere encounter is.
Right.
Yet now, because the word high crime area is interjected into a mere encounter, it rises to a level for arrest. Therein is the rub for me, that maybe the Commonwealth can answer. But we're going off on high crime area, and to me that's the red herring. The herring is, why do we distinguish our case law saying, hey, with, as I said, mere encounter, I don't have to stop if a police officer calls me. I have that freedom.
I can walk away, and the United States...
I was hoping you'd couch the reason I was trying to bait you was to get your argument there, because the issue is not high crime area. That's the red herring. It's why do we distinguish between mere encounter and a high crime area being interjected into a mere encounter to elevate it. That's the prejudicial discriminatory facts.
Yes, because it's coercive conduct. Shivers got tackled. And I'm saying under Article 1, Section 8, here's a guy who's sitting on a stoop. It's 25 after 7 on a summer evening. He's not doing anything. The officer has no report of the crime. The officer knows nothing about him. And he gets up, he sees these officers as they approach, and he runs. There's no additional conduct. We have elevated high crime area to a defining factor for constitutional rights, even though it's conduct by other people in the past. And that is the nub of it. Thank you.
Thank you very much. Let's hear from Mr. Greer, Commonwealth.
Yes, good afternoon, Your Honors. Andrew Greer for the Commonwealth. Defendant's departure claim is waived under Bishop. Even if it weren't, it was rejected in In re Diem, and even if this court were to depart from In re Diem 2 in any way, the facts here still support the seizure. I thought I read it during the lunch break, and it said that the unprovoked flight occurred as they were approaching a high crime area.
Yeah, I think that wasn't there wasn't the basis. I think the confusion arises because the remand came citing Wardlow. Wasn't that where the confusion arose?
Sorry, could you repeat that? The remand came, what?
The case came back.
Yes. After Wardlow and then changed the holding.
The court in DM did not speak of a high crime area.
No, but applied Wardlow, which did speak at length. Yes, that, which I will note that the dissent, which was in Wardlow, concurrence in part and dissent in part, and concurred on high crime area can be considered, and wrote separately to explain, really to define flight as opposed to like somebody's already just jogging through the neighborhood.
Certainly about flight. Maybe it's a needless quibble, but the flight was in play there, but it wasn't a discussion of facts about high crime area.
Then, again, because I would like...
I don't know whether this case turns on that, on DM, or is even informed by it.
But then that's where, if in re-DM overarching, then the argument the defense raised was, hey, under the PA Constitution, it's actually broader with regard to reasonable suspicion. It goes beyond Terry.
Can I ask you a question about that suspicion?
Yeah.
What crime was Shivers suspected of when he was stopped? What crime was he suspected of when the police rolled up?
At the time they captured him, which
Well, he was standing in the doorway of a convenience store or a gas station, and I guess the police rolled up.
Yes.
He takes off. At the point that the police observed him, what crime was he suspected of?
I don't think they testified to having already suspected him of a particular crime at that point.
There's the key.
There's a key.
I was not going to bring the word up at all for my part.
That's why we get to the case. That's why you need the high crime area bootstrap, because you've got flight and nothing more. Am I right or am I wrong?
Incorrect in this case, Your Honor, because there is a difference between mere presence in a high crime. I heard the words area and neighborhood come up, which first of all, this wasn't. It was a high crime location. Individual, almost a point in space. In addition, this person, Shivers, was not merely present as the teller inside was, as anyone who might have been pumping gas was, as anyone across the street walking outside their own residence was. He was sitting directly next to, this distance as I am to defense counsel, if not closer, a named known gang member. In addition to the reason there was some dispute over the record about who's a gang member, there was a group of other known gang members farther away in the parking lot, but that's different from him sitting next to the known gang member that was directly next to him. That is conduct and association in addition to the flight.
So you're saying this isn't Wardlow?
Correct. I'm saying Wardlow, serves as a basis, but this is in addition to Wardlow.
Association is sufficient?
That is a relevant additional factor for the reasonableness of the suspicion where, and again, in the full context, this starts with they're already on their way to that location because this officer, at the time of the stop, not the time between stop and testifying, at the time of the stop, 11 years of experience, conducting gang intelligence, knows the Ozone Gang specifically, defines their gang territory block by block, then zooms into this gas station out front is where that gang is known to sell drugs, in addition to their violent feuding with another neighborhood gang. But this is a known drug-selling location.
All of that is important information, which would seemingly inform patrol orders and the shift allocation, manpower, and surveillance. And I mean, a very obtrusive or unobtrusive, but heavy surveillance might have revealed all kinds of criminal conduct, hand-to-hand transactions or whatever, but none of that had been seen. So, given that there was no information about who Shivers was, other than the fact that these other known gang members were nearby, I don't know how our Constitution allows assumption of their criminal history attaching to him.
It's not guilt by association. It's a factor of the reasonableness of suspicion, which has never been understood to presume a crime is committed.
Okay, that's fair. Reasonable suspicion of what?
That he is engaged in criminal activity generally by the fact of, to just quote from Wardlow, informing, again, the conduct of flight, looking at what they observe, that it is the consummate act of evasion. So,
We're looking too at criminal activity afoot, not necessarily a specific crime, right?
right, which is, yes. So they were there based on previous information about this being a known drug dealing location that they went to investigate and attempted a mere encounter. But for reasonable suspicion, I don't think the rule can be that it's always reactionary to an established crime by at least probable cause. And then,
I'm not assuming there's proof beyond a reasonable doubt at this point. I'm simply focusing on Shivers and asking you what crime he was suspected of, and you have not been able to identify, and I don't fault you because it's not possible
and
to identify any crime for which he was suspected. So we can speak euphemistically about crimes others have committed in that area, or bad actors nearby, or, as the chief says, criminal activity afoot, whatever that means. But I still
I didn't make it up.
I'm still not getting an answer to what crime Mr. Shivers was suspected of when the police rolled up. And that's because all there is beyond that is then him running, like, I might do in courts over today.
And take into consideration with Justice Weck's question as to whether the jurisprudence of a suspicion is from a criminal activity afoot. Does that equal a distinct crime?
to answer your question first, no, but that's why, to answer your question directly, the record is devoid of the officer going, I suspected him of this particular crime at that moment. What it does show is that they were at this very specific location based on their experience as a drug dealing location for a gang, members of which were there. They go to approach one known gang member who's seated right next to Mr. Shivers, and that is when he turns around and takes off in headlong flight, the consummate act of evasion.
That's what Wardlow says. Justice Doherty raised a really great question earlier. How can it be that flight from a mere encounter is fine, but they can be turned around and used for reasonable suspicion that criminal activity is afoot?
Because I disagreed with the premise on that. Again, going by at least the Wardlow definition of flight, and I commend the concurrence and dissent for distinguishing between an individual's right to refuse police interaction and walk away from that's not flight.
Why is it? Okay, well, that's an interesting. What if they're an avid jogger and they just decided to run home? I mean, I'm not sure I can make a meaningful distinction between flight is the speed with which or abruptness with which you choose to avoid a mere encounter with a police officer is indicative of criminal activity.
I think it is, Your Honor. There's a difference between arriving in, and let's just, except for the purpose of the hypothetical, it is a high crime.
Your mother calling you and saying, get home real quick or I'm going to ground you for the rest of your life.
Or even indicative of, viewed alternatively, and thinking of our privacy right in Pennsylvania, how do you know, how can we know that Shivers says to the side, this is a bad scene, something's going to go down here. I want to get away from these people. I want to get away from the police. I want to get away from these bad guys who are sitting around me. Now, I know you're going to say that's not what happened, but how do we know that?
I wasn't even going to say that's not what happened. What I'll say is the legal standard has never been to disprove every possible innocent explanation for the conduct.
We don't need to know. We need to know what's reasonable under the circumstances.
Exactly, Your Honor.
Remember a case called Terry versus Ohio?
Yes.
Was that a high crime area?
So,
Was that a high crime area?
no, I don't believe so.
What was the guy doing?
But casing
Was he standing with a known gang area?
Your Honor, I'm sorry. I probably haven't read in full since law school, and I apologize.
The short answer is it's a police. Casing.
Casing the joint.
But if you said casing the joint now, you'd get objection, Your Honor. What does that mean? It's like high crime area. It's not casing the joint. It's looking inside. The police officer, based upon his training, education, experience, thought the guy may be looking to burglarize or to commit a robbery. So the police officer approaches him. He doesn't run. There's no flight, no high crime area, none of that. And the police officer pats him down for the officer's protection. And we found that, the United States Supreme Court found, that's reasonable under the circumstances, right?
Yes.
So we're not talking about what we know. We don't know he's a gang member, right?
Correct.
In other words, the Ozone Gang doesn't hand out little membership cards like the Elks Club, does it?
Correct. As far as I know. It's
Right,
not
so
an
we
evidence
didn't,
yet.
so there's nothing like that. All we know is he's standing with a bunch of gang members in that area that the police officer described as a high crime area. I don't know if that was justified on the record or not. He turned around, looked at the police officers, grabbed his waistband and started running. All of those individually, we know, could be innocent facts.
Yes.
Coupled together under the totality of the circumstances, what's the issue? Does a reasonable police officer under those circumstances think that the guy may be engaged in criminal activity?
Yes. And that there's a...
But that goes to my question to Mr. Sosna. And what is the nature of this departure claim? Because we have, I believe this court has basically said, we've adopted Terry. We basically said Terry is fine under our heightened privacy protections under Article 1, Section 8. Your opposing counsel seems to be suggesting, though, that we can have Terry adopt it, but somehow apply the same facts to the Terry test and reach a different conclusion on reasonable suspicion based on Article 1, Section 8. Am I not really doing well to articulate the difference between the types of departure claims I'm talking about?
I don't think you can do how Your Honor just phrased that. I myself am confused about the departure claim because I did want to go to waiver. I feel like the goalposts have moved back and forth, even as recent as this argument.
They're not arguing that we shouldn't have reasonable suspicion. They're not arguing that we shouldn't have reasonable suspicion under Article 1, Section 8. They're arguing we should have it. It should just be something different.
Yes. And my argument is that in INRI DM2, as a blanket overarching statement said, PA follows Terry for in assessing the constitutionality of investigative detentions, which is the question presented here. To the extent that defendant's trying to say, well, that's too general, and what I'm arguing is this more specific point, that's exactly what goes into waiver here, is that they never argued. I acknowledge we have the same overarching standard as the federal constitution, but I'm arguing that certain specific facts don't add up to that under the PA constitution.
You don't dispute that they cited the state constitution.
Correct. So here's where I will...
This was, one of the problems I had with Bishop, as I pointed out in my dissent. How much is enough? How much is enough?
I can tell you for the Commonwealth, the bottom line is not identifying it in the lower court before the record's closed. This allows it. I don't think it matters here on if this court were to get to the merits because of the specificity of the facts that I've gone over. But if the defense can if every pre-checkbox omnibus motion includes I'm bringing this under U.S. NPA Constitution without specifying any further reasoning, then the Commonwealth, any reasonably prudent prosecutor, is going to put forth the motion to suppress based on the then existing law, which is flight plus high crime area. They put that forth. Then records closed, 1925B statement, defendant says, actually I'm contesting those two factors as equaling reasonable suspicion. Our DA here could have put forth a lesser evidentiary record and still met the standard under current law, and then the defense can come in on appeal and say the record is deficient to meet this new standard I'm asking for.
I think that's well put, but given, it's not a lot, obviously, but the fact that they cited both, why doesn't that put you on notice that they're putting both in play, and then you respond with whatever law is available to you on both areas?
It's a form that just puts us on notice that all they're doing is raising it under federal NPA, And what they're asking for in this case is, after they've done so, saying, I'm moving the goalposts of what the PA Constitution, not what the law already is. They are not acknowledging what the law is and saying, I'm saying we should depart from that. That's the problem.
The defender would raise a motion to suppress that he's moving or she's moving to suppress under Article 1 section and blanketing of the United States Constitution. There is no indication on the record that they're asking you not only to raise those two issues, but to distinguish the Pennsylvania from therein is the issue. That's the boilerplate request that defense counsel make regularly doesn't include the distinguishing aspect, which would create
Yes, and in the Commonwealth's position, at least, like, set aside the timing of Edmunds' analysis, allowing us a fair opportunity to put forth relevant evidence of record. And
But I mean, and I understand the boilerplate point, but you litigate both aspects all the time. It's not like you're not, I don't mean you personally.
Yeah.
The Commonwealth is not unfamiliar with the jurisprudence, is required to keep current, obviously.
yes,
With the jurisprudence of both Pennsylvania and the United States. So, granted that the defense did not apparently flesh out distinguishing arguments, why isn't the Commonwealth able to brief the law of both areas?
because I can say in exactly what happened in this case. The defendant raised the general claim. I'm raising it under both constitutions. Checked off 5 different boxes for things, 4 of which didn't apply, but I won't take issue with that because one of them does. So that's the reasonableness of the stop and seizure. Based on then existing law, which we're looking at in re DM2, a prosecutor puts forth the evidence showing that there was unprovoked flight in a high crime area and did their best to substantiate the high crime area. The defendant did not identify, yes, I acknowledge that is the law, but I'm arguing we should depart from that law. That's...
You're saying the prosecutor would have done more had they known that this is a departure claim, would have maybe put, we disagree, but here's some additional testimony or here's some additional factors.
Yes, and not that any particular case needs to be verified by some assurance that they would, but it at least would have given the opportunity, and then we would be at fault for not putting forth that evidence when a specific claim is raised, whether it be the Pennsylvania Constitution requires more specificity for the modicum of evidence to establish high crime area like Lewis.
Historically, again, anecdotally, as a district attorney, I would ask, pursuant to rules, after counsel would raise a motion to articulate with specificity and particularity the basis of the motion and the grounds for which they base, which would at least open the door for the departure claim to be raised. But in this particular scenario, because the Commonwealth didn't do that, the departure claim was not preserved. It was you to argue your case pursuant to the existing precedent regarding Article 1, Section 8 or 9, and the 4th or whatever amendment is still being challenged. I mean, it's pretty straightforward in criminal law.
Correct. And even as Mr. Sosnoff seemed to acknowledge during argument, in closing argument is when the prosecutor mentioned, Your Honor, this is flight in a high crime area. And then there was still no rebuttal of, but that's exactly what I'm contesting. I mean, we're just looking for just enough to put us on notice of the evidence of the goalposts we need to get through to meet the claim, not just under the law, but under what they are, the claim they are preserving for appeal after the record is closed of what the law should be.
So, counsel, are you suggesting that there was other evidence or other considerations that the police officer had in mind when he pursued this defendant when he was leaving the scene?
No, Your Honor, because I believe again, this was well developed above and beyond what the then existing law already required.
That's sort of my point. And let me ask you this. I mean, what could the trial court have done if he had raised precisely this argument before the trial court? The trial court would have said, based upon your argument, DM. I can't overrule DM. It's what the Superior Court did. And they said, and by the way, we're bound by precedent. We can't do anything about this. I mean,
Which I understand.
isn't it futile, I think is a word that former Chief Justice Emeritus used on a number of occasions in explaining this context of where there are situations in which thoroughly pursuing the issue at the trial court level is futile.
No, Your Honor, because exactly what's happening here is the question is now before this, it's still before this court to decide on a closed record, and there are actual consequences for this particular, whichever case it's being brought under, there's still consequences for it. So that's why I'm saying there's the one question you brought as to the lower courts, what does it matter to them, but I'm saying as the Commonwealth and as an advocate and the party who has the burden to put forth evidence to meet whatever legal claims being raised, it does matter, because it would be enough for the trial court to say, well, under existing law, this, presumably lesser evidence than was presented here is enough, but the Commonwealth needs the opportunity to know defendants preserve a claim for later that the goalpost should be moved, so let's try and put forth evidence.
I was asking counsel, I'm not sure you mentioned this. Would your argument mean that we were wrong in Alexander to find the departure claim sufficiently preserved? It would seem that your argument's indistinguishable from the Commonwealth's waiver argument in Alexander.
Yeah, I struggle to find a way to reconcile the rule adopted in Bishop and applied in Bishop with Alexander, and I really tried to double-check what was stated, what wasn't, but Foster decided this year, 5-2 at least on waiver. Defense counsel already quoted the relevant portion, but although Foster cited the subsection of the PA Constitution in a suppression motion, he did not develop any argument before either lower court that it provided greater protection. This court did add, and significantly, he did not raise a departure claim in his petition for allowance of appeal, although that was here, but then went on and said, thus, while this issue appears worthy of our review in another case, Foster has waived the claim here. And this is far from the only case coming from, whether it's Philadelphia or anywhere else in this Commonwealth, where the actual question presented will have the opportunity to be before this court. And again, for the Commonwealth, it's less significant about whether they raise it in a petition for allowance of appeal. It's whether they raise it at an opportunity the Commonwealth, or at a time the Commonwealth has an opportunity to enter evidence that would meet wherever Mr. Sosnov is saying what would be enough. So that's the real issue that I would implore this court just to find this claim waived. Again, if it were to reach the merits, under In Re DM2, this is not an issue of first impression, and even wherever this court lands in Lewis, I would say the specificity of the officer's testimony here is going to would meet any departure between Lewis and here of whatever the standard is.
All right, thank you very much, Mr.
Thank you.
Thank you both. Call the next case, Mr. Minner.
Commonwealth of Pennsylvania versus Hawkins-Davenport. Representing Mr. Hawkins-Davenport, Mr. Michael Wood. Representing the Commonwealth, Mr. Michael.
In this discretionary appeal, Philadelphia police officers were conducting a valid traffic stop of a car when one of the officers observed a firearm on the passenger seat. To ensure the officer's safety during the stop, the officer reached through the open passenger window and recovered the weapon. We granted review to examine whether the presence of the firearm in plain view on the passenger seat in and of itself established that the driver of the vehicle was armed and presently dangerous, so as to justify a seizure of the weapon under the United States Supreme Court's seminal decision in Terry versus Ohio. Please proceed.
Good afternoon, Madam Chief Justice, and may it please the Court. My name is Michael Wood. I represent Devon Hawkins-Davenport in this case.
You're going to have to pull the microphone up.
Oh, yes, of course. How's this?
A little taller than the last person.
Police cannot frisk a person or seize a weapon without reasonable suspicion that they are both armed and dangerous. Here, Mr. Hawkins-Davenport was surely armed. But there was no evidence that he was dangerous. Quite the contrary. He was entirely cooperative, level-headed, and honest with police after they pulled him over. In fact, one is hard-pressed to imagine what else he could have done to communicate to the officers that he was not a threat. And yet the officer entered his car and seized his gun.
Well, the difference, though, is here, unlike in Hicks, for example, there was reasonable suspicion for the stop. That's an important distinction, isn't it, counsel?
It is, and certainly we're not contesting the validity of the traffic stop here. What we're contesting is having established that there was reasonable suspicion of, I suppose the label is criminal activity. In this case, it was a defective brake light. The next question becomes, is there evidence that this person is armed and dangerous? And
it's a wingspan thing, right? I mean, it's within his reach.
it is. But there's also no evidence that he reached for the weapon, that he was uncooperative in any way, that he was intoxicated, that he failed to pull over on signal. In other words, nothing about his conduct.
Counsel, let me stop you.
Sure.
You have children?
No, Your Honor.
I have children. I got three grandsons, 2 daughters. I carry a gun. You know what I don't do? I don't put my gun on the coffee table when my grandchildren are around. And do you know why?
Why do you
think that is?
What's that?
Why do you think that is?
I suspect you don't want your children to, or your grandchildren to, reach that gun.
Why?
Because as children and people who aren't either registered or trained to handle a firearm,
Because a gun is dangerous.
there are certainly a lot of situations in which a gun can be dangerous. Yes, Your Honor.
There's not any situation where a gun cannot be dangerous. A gun is a specifically employed tool to kill people or to shoot people or to defend yourself. It is an instrument of dangerousness almost by its very definition.
That's correct, Your Honor. The question under Terry, though, is whether the person who is armed is dangerous, and that depends on the totality of the circumstances. That's why I'm going into Mr. Hawkins-Davenport's conduct. Certainly, if he had reached for the gun
He
or...
didn't exhibit any outward hostility. The mere presence of a gun does not suggest criminality. But do you agree with me that it does, in fact, suggest dangerousness?
I agree that guns, in some general sense, are certainly dangerous. Where I disagree, I think, is that every person holding a gun, regardless of the context, is always dangerous, as opposed to only needing to become dangerous in the need of legitimate self-defense.
So when do we cross that threshold?
Well, I think the United
When he reaches
States...
for the gun, and points it at a police officer. At that point, does he become dangerous?
Certainly he would be dangerous at that point, but it doesn't even need to get that far. I think any amount of conduct from the person that shows that they are anything other than a cooperative motorist who's just been pulled over for a routine traffic stop could contribute to the dangerousness finding. That could be intoxication, that could be refusal to get out of the car upon an order, that could mean swerving in the lane in such a way that indicates that they're driving under the influence. It could be a wide variety of things, but it does have to be something.
Counsel, the gun was within your client's reach. Doesn't that make your client at that point in time presently dangerous? I mean, this isn't a situation where the gun is in the back seat and, there'd have to be all kinds of gyrations. I mean, why isn't he presently dangerous to that police officer at that moment when the gun is within his reach on the passenger side seat of the car?
That's our focus right now, the protection of the police officer, his safety, correct?
That's absolutely, yes. I think the language from Pennsylvania versus Mims is that officer safety is a legitimate and weighty interest. I'm certainly not contesting that here.
Why isn't he presently dangerous when the gun is within his reach, when he's now engaged in a forced stop with a police officer?
Well, because he's given the officers no indication that he wishes them any harm at all. He's certainly not.
Why does he have to? The police officer at that juncture has to make a decision. Is he presently dangerous because of the gun being in reach?
That's right. And even under the armed and dangerous prong of Terry, this has to be individualized suspicion. In other words, it has to be based on the conduct of the individual as opposed to whether guns are dangerous in some more general sense.
Let's explore that for a second.
Sure.
So we've established it's a lawful stop, and the Officer Torres sees the gun on the seat. Why why is the officer grabbing the gun not a reasonable extension of Terry? In other words, in Terry, you have the lawful frisk for officer safety, and here you have a lawful stop, and I'm not sure how we could distinguish taking the gun here for officer safety from Terry.
Sure. So in Terry, the reason the person was stopped was that there was reasonable suspicion he was about to commit an armed robbery. I mean, he's casing this, I think it was a jewelry store, and there was also indication that he had a gun on his hip. The officer, based on his training and experience, puts those two things together and says, this is a person who is not about to use a gun for self-defense or if somebody starts attacking them. This is a person contemplating a gunpoint robbery. And at that point, certainly that person is dangerous. And
Terry is limited to suspected criminal activity that involves a gun?
No, I don't think it's limited that narrowly, but I think that fact in Terry is what distinguished the basis for the stop from the basis from the frisk.
You have to now take Terry forward all these years to all the times Terry's been applied outside of the context of a suspected armed robber.
Sure. And in every one of those cases, there's some evidence of dangerousness beyond the mere presence of a weapon in plain view. Yes, Your Honor. So in Pennsylvania versus Mims, for example, the driver had committed what the 10th Circuit calls the clandestine act of concealing his weapon from the police officer. That could certainly play into the analysis. In Michigan versus Long, the driver was not only intoxicated but uncooperative, and certainly those factors play in as well. And I would also point out that this court has followed a similar logic in a case like Commonwealth versus Lagana, where again a person is standing outside in the rain, casing some kind of business, and there's an indication that they have a gun. Again, there's some indication that they are going to use that gun for purposes of unlawful violence as opposed to legitimate self-defense.
Mr. Woods, this was based upon a traffic infraction that ultimately led to the plain view of a firearm. Our case law would have permitted the officer to require that your client step out of the car, correct?
That's right.
Would have even permitted the police officer to put your client in his police car, correct?
I believe that's right, yes.
Instead, he just reached in and grabbed the gun. Why is it that your argument is that the police officer is not allowed to grab the gun, but he could grab the body?
What I would submit, Your Honor, is that this is a more significant intrusion than just asking someone to get out of the car. We're talking not just about the physical trespass into the space of the car, as this court recognized in Saunders. That is, while certainly not as intrusive as something like Alexander, where there's a full-on search of the car and closed containers and so forth, it is still a search subject to scrutiny and does violate the person's kind of right to be left alone in their private space. We then add to that the seizure of the property, which, as far as the officer knew at that time, was entirely lawfully owned. Whereas in Saunders, this was a case where the defendant had already told the officer, right, this is contraband, I don't have a license for this, and so the court concluded, with some disagreement, that there really is no legitimate interest in what the officer knows to be contraband.
But again, this is a stop on reasonable suspicion, if not probable cause, and so reasonableness kicks in. So if we look at the flip side, in this situation, this real-life situation, would it not be unreasonable for the officer to get that gun out of the wingspan of the actor?
I am a little confused because I think that ends up being the same question, right? If either it is reasonable or it's not, and I'm submitting that it's not without...
Yeah, I mean, whether a gun is legal or illegal, it's inherently dangerous, apropos of Justice McCaffrey's question. Would you agree?
Sure.
So, given that the stop is lawful, it's necessary that safety be preserved, right?
Sure.
So, given that, would anything other than seizing that gun at that moment have been reasonable?
Yes, Your Honor. I think it would have been reasonable to order Mr. Hawkins-Davenport out of the car. I think it would have been reasonable to order him to keep his hands on the driver's wheel or whatever it is that the officer normally orders. And frankly, it would have been probably reasonable to secure him outside of the car, as Justice Dougherty suggested, because that's already what's authorized by Mims. Here, what the Commonwealth is asking for is essentially, as I understand it, an attempt to get rid of context and ignore the totality of the circumstances in favor of just identifying a single fact and then basing everything based on that. As far as I can tell, would encourage police officers to treat even lawful gun owners as presumptive criminals, people who would be willing to use a gun against them without...
It's a temporary seizure for officer safety, and more importantly, probably 99% of the time, the defendant's safety or the driver's safety. I mean, what if the officer sees the, I mean, if we accept what you're suggesting, you can't temporarily seize the weapon. What if the guy goes to reach for it in his glove compartment and the officer thinks he's reaching for his gun, which is sitting 2 feet from him, or the center console, or he does anything else that the officer perceives to be him reaching for the gun or makes the officer nervous? We just had an officer involved shooting in Philadelphia where the person had a knife, the fellow downtown. The police officer heard somebody else say gun. The guy had a knife in his hand. The police officer shot him. If we accept what you're suggesting, which is there can't be any temporary seizure here, I think you're putting both officers and civilians in danger.
I understand that, Your Honor, and I certainly don't want to put anybody in danger here. All I'm suggesting is that the officer consider the totality of the circumstances, as Terry required, as this court has required, and that when there's no evidence that this person is anything other than a cooperative lawful gun owner, that the presence of the gun by itself, without anything else, is not enough.
Did your client have a license for a permit to carry?
They later found out that he did not.
So your client, I don't understand what you're suggesting. He wasn't a licensed and lawful gun owner.
Right. I mean, what I'm suggesting is based on the officer's information at the time they made the seizure.
But what's the remedy? Suppression?
Yes, Your Honor. If the seizure was unlawful, then the evidence is suppressed as a result. So I certainly don't want to denigrate the interest here, right? The officers have a legitimate and weighty interest in their own safety, and of course they're charged with protecting public safety. But we do have a circuit split to some degree on this question, and the Sixth Circuit, Seventh Circuit, as well as Arizona and Idaho, I should point out, actually, I thought as well that the Supreme Court of New Mexico had followed that line of reasoning. Mr. Ehrlich pointed out to me yesterday there was a case that I think he can tell you about a little bit more, where they've since departed from that rationale. There still remain several jurisdictions across the country that have accepted the argument that I'm making here, right, that there needs to be some evidence of dangerousness beyond the mere presence of a weapon. And there's no evidence that I've been able to find that either police officers or the public at large are more at risk, more in danger than those in those jurisdictions.
Mr. Wood, if he had placed him in his police car and he was able to contact to determine whether he was licensed and he found out that he was not licensed, he was then placed under arrest, would not have inevitable discovery or search incident to arrest have waived any injury by recovering that gun? And if so, why shouldn't we rule for any reason based upon inevitable discovery?
So inevitable discovery is an additional burden on the Commonwealth to show that notwithstanding the initial illegality, they inevitably would have found the evidence through other means. And as far as I know, none of that was developed on the record below. Now, it may be that a case on similar facts that develops that record, inevitable discovery might apply, but I don't believe the Commonwealth has made that out here.
So your argument is for this court, for the mere fact that Terry says armed and presently dangerous. Your position is because you don't believe presently dangerous was proven by the Commonwealth?
That's correct, Your Honor. And I would point out that if the Terry court meant that all armed people were automatically dangerous, as I think the Commonwealth is suggesting, they would have just said armed.
Hypothetically, if the Commonwealth at the motion asked the court, or at the hearing, asked the court to take judicial notice that firearms are inherently dangerous, would that have satisfied the second prong of, or the second factor of the Terry analysis, armed and presently dangerous?
Not by itself, Your Honor, because the question under Terry is whether the person is presently dangerous, not whether guns are dangerous in some general sense.
The concept is, as the evidence brought out, it was within the arm span of your client, and arguably under constructive possession.
Sure.
You have it. So why would that not have I'm just trying to tease out, so are you, what it appears to me is you're asking now the Commonwealth, in types of cases like this, their DA, all they have to do is ask for, if it's in the wingspan constructive possession, all they have to ask is for judicial notice that the firearm is inherently dangerous. Therefore, it's logical that he was armed and presently dangerous because he was within the arm span of a judicially noted object.
That's not what I'm asking for here, Your Honor. What I'm asking for is for the officer during the traffic stop to consider the totality of the circumstances. As I say, any number of factors could contribute to dangerousness beyond the mere presence of the weapon, but when all of those factors are absent, then all we have is armed instead of armed and dangerous.
Counsel, you seem to be, you seem to be minimizing the dangerousness of police traffic stops. Police traffic stops, wouldn't you agree, carry a certain amount of danger?
Yes.
When police are walking up to a vehicle not knowing what state the driver is in, what condition the driver is in, anything like that. Unlike just seeing a person walking down the street carrying an open sidearm, which is legal, a traffic stop comes with its own unique set of vulnerabilities for the law enforcement officer as well as risks to the people in the vehicle.
I think that's right, Your Honor. I think this Court has recognized that. Supreme Court of the United States has recognized that. The vast majority of traffic stops conclude without an incident. There are some small minority of them that do lead to violence, and officers should take precautions to prevent that when they need to. But the mere fact that it is a traffic stop doesn't automatically make whoever's in the car armed and dangerous. Otherwise, I suppose there'd be.
Well, no, but you can't ignore that. And here, number one, you're starting with an inherent risk of danger for the police officer to stop this vehicle and approach the vehicle blindly, right?
That's right.
That police officer is on guard now. Maybe they don't have their weapons drawn. That might be a little bit excessive, but they've been trained to park vehicles certain ways to have a place to retreat to. There's training that they receive for purposes of initiating a traffic stop, and they come up. Usually, if they have two officers, they might approach on both sides. There's a lot of reasons why they treat vehicle stops carefully because of the dangerousness of them. Combine that with the fact that, okay, you already have a heightened dangerous circumstance. Now, as the police officers approach, oh my gosh, within handshot of the driver is a weapon. So you keep going to all he had was a weapon, but don't we have to take that on top of the dangerousness inherent in the stop itself?
Sure. I mean, certainly this Court should consider the totality of the circumstances, including what it has found about traffic stops in general. But what Terry has always required is individualized suspicion. And so while the general...
Was there another individual in possession of the weapon?
No, he's the only person in the car.
Individualized, isn't it?
No, of course it's individualized as to him being armed. What I'm suggesting is the fact that other people at other times may have been dangerous during a traffic stop has very little to say about whether he individually was dangerous during this particular traffic stop.
Doesn't the reasonableness calculus here necessarily have to take into account the immediacy with which he could grab and use that weapon?
Yes, of course.
And that coupled with the fact that it's only a temporary seizure, in other words, absent some other facts developing that presumably upon confirming that the gun was legally possessed, which was not the case, but upon learning that it was legally possessed, the officer would have, again, absent something else, would have presumably been returning the gun, right?
That's right. I guess I should point out, I'm certainly not suggesting this is as invasive as Alexander, or even as invasive really as a frisk of the person, which really kind of involves quite an invasive, touching and so forth. What I am suggesting is that this level of intrusion was not nothing. It was not de minimis, as the Superior Court seemed to indicate, that having someone come into your car, trespass physically into the space, and then take your private property that, as far as they knew at the time, he possessed lawfully, is certainly something that is worthy of balancing on the other side of this Court's entirely legitimate concern for officer safety.
Well, an officer at a traffic stop can be killed by a licensed gun just as easily as an unlicensed gun, correct?
That's right, yes. And certainly this doesn't turn on the legality of the gun as it ultimately turns out to be, right? I mean, I think Adams v. Williams makes that point pretty clearly that, as you point out, Chief Justice Todd, that, you know, there are some situations in which lawfully owned guns can be used to harm people. But it's another step further to say we don't care about the rest of the totality of the circumstances. The individual's conduct, in other words, doesn't matter to the analysis.
Counsel, let me follow up on that.
Sure.
What's an officer to do? I mean, if you're correct, are they to wait for the circumstance to develop that the driver reaches for the gun? I mean, you know, these are momentary kinds of decisions and interactions. I mean, what you're suggesting is unrealistic in the real world.
What I'm suggesting is that the officer use the tools that are already available to them, ordering someone out of the car or those kinds of things.
Why is that less intrusive? I mean, getting back to Justice Doherty's earlier question, why is that less intrusive than momentarily seizing the gun?
Well, both because it involves a physical trespass into the car, and it also involves the seizure of private property, even though there's no indication that it's evidence of a crime. So I think the Mims court pointed out that the only difference between allowing someone to stay in their car during a traffic stop and getting out of the car during a traffic stop is where you're sitting while this investigation is going on. Here we're talking about not just the physical position of somebody's body, but we're talking about the disposition of their property and the sanctity of their private space.
Okay, Mr. Wood, nice job. Thank you. Let's hear from Mr. Ehrlich.
Thank you very much.
From the Commonwealth.
May it please the Court, Mike Ehrlich for the Commonwealth. Under Terry, we asked two questions. First, we asked, was there a lawful detention? Everyone agrees there was a lawful detention here. And the second concern of Terry is whether or not a reasonable person would be warranted in the belief that his safety was in danger under the circumstances. And I think very clearly, for reasons that many of you have already articulated, that was clearly the case here. We have lots of case law from the United States Supreme Court talking about the inherent danger of traffic stops. On top of that, we have case law talking about the inherent danger of guns. Here we have both those circumstances together. It's perfectly true that in the approximately 60 seconds between when defendant is pulled over and when the officer sees the gun, he doesn't during that time do anything that is independently threatening or menacing. But the officer, yeah.
Just because you mentioned traffic stop, would you agree that were we to affirm in this case, the affirmance should be limited to traffic stop situations? The reason I ask that is, because we're not making a decision which only applies to, Mr. Hawkins-Davenport. So, there's like a universal mandate, or it has, wider application, obviously. So, you would not argue, or would you, that were we to affirm here, that would necessarily mean that supposing somebody outside of Philadelphia was walking down a Pennsylvania street with an open carry, gun in a holster on the hip, that person then jaywalked. So the police could lawfully stop that person if jaywalking was enforced as it is, say, in Dallas, Texas, where I was stopped when I was a law student. I didn't get a ticket, just a warning. But it is enforced in some places, believe it or not. Anyway. Would you maintain that the police officer in that circumstance could disarm that person automatically without any further fact, just by virtue of the stop being lawful and the person being armed?
So let me say two things in response to that, Justice Weck. The first is that I think this is an easy case because it's so well established under the case law about the particular inherent danger of car stops. So I think that this case is the easy one. In terms of the jaywalking case, I would argue that that would be okay because I think that if we have the danger would flow from the forced detention combined with having a deadly weapon. Now, I don't want to denigrate the fact that there's a standard that talks about armed and dangerous. And I could imagine some circumstances where somebody would be armed and not dangerous. You can be armed with a large variety of things. You can be armed with a screwdriver. You could be armed with a fork. And if we have something that isn't a deadly weapon, such as a gun, you might need a more particularized analysis. There might also be particular unusual circumstances where a police officer knows in advance that the person he's stopping is lawfully licensed and is somebody who has a completely law-abiding individual, maybe an officer stopping another off-duty officer or something like that, or he knows that the gun is unloaded. But I would argue, if pressed, that in the jaywalking situation, that itself would present a situation where we're simply going and taking custody of the gun temporarily for the duration of the stop would be permissible.
Thank you for not throwing high crime into the mix.
As I've indicated, I think armed and dangerous are both important. It's honestly unclear how much the Terry court thought about what that standard meant, because there are times they say armed and dangerous, and there are other times in Terry they say armed and thus dangerous. But it's clear that the sort of danger that's necessary to be presented, it can be, under some circumstances, something that arises from a particular suspicious or menacing thing that a defendant does, but it doesn't always have to arise in that way. The danger can arise from the situation. And I think the case which is most on point is Pennsylvania versus Mims. Pennsylvania versus Mims is a case where it's a completely routine traffic stop. It's a stop for driving with an expired license. The Commonwealth agreed in Mims that he did nothing suspicious at all. The officer stops him, orders him out of the car, and sees that he has a bulge under his clothing. That's it. The United States Supreme Court said it's absolutely clear the officer was justified in frisking him and removing what turned out to be a gun. Here we have two significant differences from Mims, but I think they both cut in my favor. We have something that not a bulge that might be a gun or something innocuous. We have a gun. And we also have something which is less intrusive, as Mr. Woods said, than a full frisk. We simply have a taking without any touching of the person. So Mr. Woods, my distinguished opponent, really has attempted to distinguish Mims in a couple ways. The way he did just a few minutes ago was to say, well, Mims involved the clandestine act of concealment. It's true that the gun in Mims was concealed, but it's important to recognize that in Mims, there was no allegation or indication that Mr. Mims did anything sneaky, that he went and suddenly grabbed something and put it under his coat. For all we know, it appeared he was simply traveling with the gun under his coat. So it would be very odd to sort of distinguish Mims on that basis, I think, and say that the frisk in Mims was okay and this one wasn't.
Well, Mims too was a concealed situation, which could have been completely lawful, right?
Yes.
But isn't it just as, I may be wrong on this, isn't it just as illegal to conceal a weapon on your body without a concealed carry permit as it is to conceal a weapon in your vehicle?
Well, actually, under Pennsylvania law, the General Assembly in Pennsylvania has been very concerned about guns in vehicles. So if you don't have a license, it's illegal to have a gun in your vehicle, whether it's concealed or open.
Well, that's what I mean.
Equally.
I said concealed in your vehicle doesn't mean in the glove compartment. It means in the vehicle, anywhere.
Right. So concealment is not an element of the crime under 6106. It's treated exactly the same. I want to note there are two other ways that Mr. Woods has attempted in his briefing to distinguish Mims. One is to say that everything that Mims said about frisking was all dictum because it wasn't argued below, and I don't think that's accurate. In the Pennsylvania Superior Court decision in Mims, which is published, there's a specific holding that the frisk was lawful. When it got up to this honorable court, Chief Justice Nix read the dissenting opinion specifically saying it was lawful, and the majority assumed arguendo it was lawful, but ruled against the Commonwealth on a different basis that then was reversed by the U.S. Supreme Court. When the U.S. Supreme Court had it, I think both issues were very much in contention, and the court reached both and remanded for proceedings consistent with its opinion. So I don't think its decision can be dismissed as dictum. I think that the third thing that Mr. Woods has sort of indicated is that sort of MIMS really doesn't provide guidance today because there's been such a change in the law, and we all know that many more people are licensed to carry. I think ultimately that's an issue for the U.S. Supreme Court, but what I would point out is that the fact that so many people are licensed to carry today is relevant for Terry purposes, but that goes to the Hicks issue, the issue of when you can lawfully stop somebody. We're not dealing with that here, as the Hicks opinion took pains to point out. The fact that whether or not you can stop somebody is a different standard than once a police officer has lawfully stopped somebody, he's doing his job. He's forced to be in close quarters with somebody which is armed. That presents a very different issue, and their safety is paramount, particularly since an officer, as the Chief Justice indicated, can be equally jeopardized by somebody who lawfully has a license or who doesn't have a license. The other thing that, I'm sorry.
No, go ahead.
Yeah, the other thing I just wanted to point out is that there was a case that unfortunately I didn't discover in time for my briefing, but I wanted to notify the court about that because I think it's particularly interesting. It's a decision of the Supreme Court of New Mexico called State versus Ketelson, Ketelson, 257, Pacific 3rd, 957. That's New Mexico Supreme Court 2011. And what is so interesting about it is it's very similar facts. It's a completely routine stop where they reach in and grab a gun. And the New Mexico Supreme Court said, not only is this consistent with the Fourth Amendment, it is completely consistent with the heightened protection of the New Mexico Constitution. New Mexico, like Pennsylvania, rejects the automobile exception and has heightened protection, but they said, it's completely fine, even under our heightened state constitution. There's no state constitutional issue here, but that's the one case I've found where this has been independently analyzed under a state Supreme Court and found to pass muster. Thank you. If there are no further questions, I'd ask you to affirm. Thank you.
Thank you both. Excellent arguments. Mr. Minner, would you call the final case for the day? Mr. Wood, if you need a few minutes, that's fine.
I appreciate that. I may take a quick sip of water, and then I'll be ready to go.
Right ahead.
Thank you.
Got a double header here. In this appeal by allowance, we consider whether under Article 1, Section 8 of the Pennsylvania Constitution, police have reasonable suspicion to conduct an investigative detention of an individual based solely on the fact that the individual was observed in close proximity to another person who was smoking marijuana in a public place and then ran upon seeing the police approach them. Please proceed.
Good afternoon, Madam Chief Justice, and may it please the court. My name again is Mike Wood. I am representing...
Just a minute for the
I'm sorry.
Philadelphia sirens to stop. They go by during our criminal cases just for effect.
So in this case, I'm representing Elise Coles, the appellant in this matter. For decades, this court has emphasized that police need individualized reasonable suspicion in order to seize someone. Here, the only individualized reason that police seized Ms. Coles was that she ran from them. However, as this court's precedent makes clear, flight from police is such a tenuous and inconclusive factor that it's not enough to establish reasonable suspicion. And to that flight, the only thing the Commonwealth can add is the fact that Ms. Coles was sitting in a group of people while someone in the group was smoking marijuana. Crucially, however, police never saw Ms. Coles smoking, holding a joint, showing any signs of intoxication, or even smelling like marijuana. In short, police chased her because she ran, and that was illegal. In Commonwealth versus Matos, sure.
You don't disagree that assuming assuming reasonable suspicion sufficiently individualized that the marijuana smoking, that would be a crime.
That's right, yes. So even under the Medical Marijuana Act, while use of edibles and vaporizers is legal, the smoking of marijuana is not. So this doesn't turn on whether she had a license or the issues that were present in Commonwealth versus Barr. So as to the flight component, in Commonwealth versus Matos, this court cautioned against flight being a strong indicator of guilt. It held that allowing police to chase someone because they ran would, quote, frighten countless citizens into surrendering whatever privacy rights they may still have. And in some ways, that language stands in contrast with the words of the U.S. Supreme Court, which in Illinois versus Wardlow, as was discussed at some length earlier today, the Supreme Court suggested not only that it's the consummate act of evasion, but that it's, quote, certainly suggestive of guilt. And as far as I know, this court has never gone that far. This court has rightly recognized that flight is a weak factor that at best has a tenuous relationship with criminal activity.
That's all true, but if I could just
Sure.
try to get to the key point. The gravamen, perhaps. I don't think anybody maintains here that mere flight would be enough. I don't think that's the gravamen. But here, the police approach, because they clearly have reasonable suspicion that the marijuana law is being violated. And so the key issue then is the individualization.
Right.
And so I guess they saw the cloud of smoke or whatever, and they see the queen, and now she flees. So the aggregation of those circumstances, you say, is still not enough.
Right. So that's right. I'm certainly not suggesting that this court shouldn't consider the flight or shouldn't consider the marijuana or anything like that. It's that putting these two things together, given how weak and, at least in the case of the marijuana smoking, how not individualized they are, even together they don't rise to the level of reasonable suspicion. Now, I think it's important to point out that if police wanted to establish reasonable suspicion here, they easily could have done so. All they had to do was take half a second and notice who was holding the joint or the blunt or whatever it was.
Well, that doesn't, why does that matter? Not that I have a lot of experience in this, but this arguably could have been a hot potato situation where they were passing around the joint.
Right, and certainly if they'd seen them passing around the joint, anyone who touches it, they've got reasonable suspicion to stop that person.
Because at that time, it wasn't being passed, but it was a group of people, they said a cloud of marijuana. You're saying that that's not even reasonable suspicion that one or all were sharing a marijuana joint?
Certainly it's reasonable suspicion that somebody in the group was smoking, but reasonable suspicion...
Not a reasonable suspicion that all of them were sharing a joint?
No, without evidence that they were passing it around or that one or more of them was acting intoxicated or something like that. I would suggest that there needs to be individualized suspicion that the person they're stopping has committed a crime. And I think it's important to point out factually, not just did they see the smoke, not just did they smell the odor, but they actually saw the joint in somebody's hand. And at that point, all the officer has to do is look from the joint to a person's face, and there's your reasonable suspicion. So instead, what the officer did was chase after Miss Coles precisely because she ran. And ultimately, reasonableness is the touchstone here. Whatever else reasonableness might mean, it's not reasonable for police officers to ignore evidence that's staring them right in the face. But that's what they did here. So it was this opportunity to individualize that distinguishes this case from the out-of-jurisdiction cases that my colleague cites. Because I think there are some limited situations in which police might be justified in detaining a small group of people for a one-person crime if they have nothing else to go on. For example, in the... I'm sorry.
It's a one-person crime. I keep coming back to these arguments that try to isolate conduct. Who said it's a one-person crime?
I suppose what I mean is there's nothing inherent to the crime of smoking marijuana that requires the persistence of multiple people.
If we accept your analysis and we isolate this incident to look to the one person, these guys are they're doing a little hot potato or passing a joint around, it's only the one person who, when the police officers pull up standing there holding the joint, that can be stopped, right?
If there's no other evidence that anyone else was involved other than their mere presence being there, I would suggest that they have reasonable suspicion for the one person, but not for the others. On the other hand, if they see the joint being passed around, or if they see, say, bloodshot eyes or other signs of intoxication, that gives them individualized suspicion to stop the other people, but we don't have that here.
What about the flight?
Well, the flight, of course, is individualized, but I guess that's why I'm going back to.
We have to put that in isolation as well. So we go in the back and the 7 of us are smoking a joint. I decide I'm going to smoke a joint, the rest of them are. If the police officers walk in, I don't have to flee, do I?
No, you certainly don't have to flee.
You can, but you may.
But you could, if you weren't smoking, and unless there was some other factor that was present there, I would suggest that the officers wouldn't be justified in chasing you. So,
how does the officer conduct an investigatory detention to find out who was smoking? Who had the joint?
well, there are certain circumstances under which they can do that, but they need to establish at the outset that they have reasonable suspicion as to each of the people that they're trying to stop.
But again, how do you know? The purpose of an investigative detention is to, say with me, investigate.
Of course.
So how do you investigate if everybody just flees? I mean, from what you're saying, a police officer can't investigate any crime because unless he catches the one person in the act, the police officer can't approach, they can't walk up, they can't ask a question. Where do we go?
No, I'm certainly not suggesting that the officers can't investigate. I'm suggesting that the tools that are available to them are consistent with the tools that they have during any mere encounter, right? Asking questions, seeing if people want to cooperate, and if they don't...
This isn't a mere encounter.
No.
This is an investigation. Police officer has reasonable suspicion. You just said it. Somebody smoking pot, smoking a joint in that group. So I want to investigate who's got the marijuana, who's smoking, are they all smoking? They all flee. You're telling me I can't do anything except chase the guy with the joint.
That's what I'm suggesting, Your Honor. Unless there's something else there, right? Other signs of intoxication, or they see the joint being passed around or something like that. If all they have to go on is this mere presence in the group and flight without, say, and I hesitate to use the phrase, but high crime area or something like that, then all they really have is flight and this kind of mere presence.
Would your example hold true if there was a circle of individuals trading money for drugs? The only individuals that were culpable were the ones that, when the music stopped, had either the drugs or the money in their hand?
So I think in that situation, certainly the act of selling drugs is kind of by its very nature a multi-person crime. At the very minimum, you have the seller and you have the buyer. And so if you see two people and they're engaged in this transaction, then yes, you've got reasonable suspicion to stop both of them. But there's conduct on behalf of both of those people. Here, really the only conduct that Ms. Coles has is her flight and her decision to associate with these people.
Was there any finding by the trial court that Appellant was not smoking marijuana?
The finding, I believe, was that they were going up to investigate who was smoking, and then she takes off. So I don't think there was one finding one way or the other about whether she was smoking individually. And I think that's ultimately because the officer didn't look from the joint in somebody's hand to the face of that person. So, what's that?
I'm sorry, it was kind of dark?
Yeah, it was 8:30 at night. I think the night had fallen at that point. But certainly there was enough light for the officer to see that there was a joint. And at that point, I certainly would assume there would be enough to, recognize a face, which, I don't know how big this joint was, but certainly smaller than a person's face. So I would like to, well.
If not, it was Cheech and Chong.
Well, you're right. So, before wrapping up, I would like to discuss very briefly this court's decision in re SJ. Because in some ways, it presented similar facts to what we have here. SJ was in a group of people. I think they said it was about 12 people. Somebody in the group is smoking a joint. Police come up, and then he tries to kind of worm his way to the back of the group, hiding from the police officer. And there were two crucial distinctions, though, that I would point out between this case and SJ. First, the stop in SJ, for what it's worth and for whatever this court decides in the Shivers case, occurred in an area that was known for drug use. In fact, the officer who made the arrest in that case had made half a dozen other drug arrests in that very area. Second, and frankly more importantly for the individualized point, is that SJ himself smelled like marijuana. So that gave the officer some reason to think not only that he was present in the group and not only that he was hiding because he didn't want to interact with police. Well, I suppose I don't know how close they were to them. They were... Right. And... Unless they're really good sniffers. I think that's... Right. But I would point to other signs of intoxication that might have been more evident at a distance, right? Well, right, but there's enough light to see that there's a joint here, so there is certainly enough light to make at least some observations. So had we seen, say, slurred speech, or not speech, excuse me, but staggering gait, or some kind of indication that this person had a problem with balance, or that their eyes were bloodshot. I mean, I take your point about the distance between, where the officers were and where she was, but if there was some individualized reason to think she was smoking, that would present a different situation. And I think that's what they had in SJ that they don't have here. Obviously, it's not a high crime area and certainly not an area known for drug use, but more than that, they don't have any indication from her conduct that she had just been smoking, other than the flight, which by itself is not enough. And even considered in conjunction with these other kind of mere presence type factors, I would submit to this court is distinguishable from SJ on that basis.
So,
All right.
How do we get to this particular issue in light of the fact that the Superior Court affirmed the trial court's denial of the suppression motion by finding that your client lacked a reasonable expectation of privacy in the backpack that she abandoned in a house that she had no relationship to?
Well, so we prevailed in front of the trial court, and then the Superior Court reversed that decision, and now we're here for this court's review. So we didn't have any...
The basis of the Superior Court's decision was that she lacked a reasonable expectation of privacy in the backpack because she abandoned it in a house that she ran into and she had no connection to it.
Right, but that was the direct result of the police officer's decision to chase her, which, as this court recognized in Matos, unless that is supported by reasonable suspicion, any abandonment that happens after the chase has started is fruit of the poisonous tree if it's not supported by reasonable suspicion.
Yeah, but Matos, correct me if I'm wrong, Matos and Hodari D in those cases were the police officers implemented a chase. In this particular case, your client ran. The police officers didn't do anything to kind of force her to run. She just ran, which caused the police officers to run, I guess, in the same direction after her.
Right, and so she's seized at the moment the police officers start chasing her. So at that moment, unless they had reasonable suspicion to support the chase, then everything that happens after that is fruit of the poisonous tree.
How do we know they were chasing her? Couldn't they just been running down the street to see what she was running to?
I'd have to defer to the record on that, but I do believe they said we decided to chase her, as a result of seeing her run.
All right, thank you very much,
Thank
Mr.
you.
Wood. Well done. Mr. Trevino? The Commonwealth?
Good afternoon, Your Honors. May it please the Court. Grady Trevino on behalf of the Commonwealth. I want to begin, just before I forget, I think my colleague has unintentionally misstated the relevant facts of SJ in the sense that he's argued in his reply brief in here today that in SJ, one of the relevant facts was that the police smelled an odor of marijuana on SJ himself. While that fact is true, that did not occur until after the police had already stopped SJ. So when this court was considering whether or not there was reasonable suspicion, they did not consider that factor because that factor isn't relevant. This case is very similar to SJ. It's actually stronger than SJ. And let me just begin by, I think it's important that we understand what the relevant facts are in this case. They're very brief. But the police are on patrol. They're driving down the street. They see Ms. Coles and two other people sitting on the corner on some steps. There are multiple plumes of smoke around them. The officers smell burnt marijuana, and they see hand-rolled brown cigarettes. A couple of times the officer says cigarettes, plural. One time he says a hand-rolled cigar, singular. So there's no question that Ms. Coles and two other people are at the precise spot where a crime is then taking place. The police can say they don't know who it is who specifically has the blunt in his or her hand at the time. As the trial court itself says, everything in this case happened very quickly. The police are driving down the street. They see what I just described. They stop their car, and they're attempting to do exactly what Mr. Wood is claiming that they should have done. They stop their car, they get out, they approach on foot to try to investigate, and Ms. Coles, but nobody else, flees from the scene. She runs into the house. The other two people she was with stay at the scene. At that point, the police pursue Ms. Coles She goes into a house, leaves a backpack in there that she had been wearing. The police eventually find a gun in the backpack.
Commonwealth, under Matos, if the moment the police start chasing the individual, the law indicates that the person is seized and should have probable cause. What was the basis for the probable cause when the police officers start chasing his client?
Well, I would say, Your Honor, in this case, we're dealing with reasonable suspicion, not probable cause.
Right.
But what we...
I'm still... Go ahead.
Well, what we had here are the facts that I just described, is Miss Coles and two other people sitting on the corner, multiple plumes of smoke around them, the smell of burnt marijuana, the officers see the brown hand-rolled cigarettes. The officer gets out of the car. There's been no seizure. The police can always get out of the car and approach somebody to talk to them, to say, hey, what's going on? At that point, Miss Coles flees across the street, runs into a house. She's not seized until the police take off after her. The police don't pursue her until she's, of course, already fled. So the flight is clearly relevant. This court in DM has said that that flight is highly relevant.
Based upon what was the reasonable suspicion, your argument, for her being present with individuals who were smoking or smelling marijuana, the officer?
There's no question that there are three people at the scene, Ms. Coles and two other people. There's no question that somebody or some people among that three-person group was smoking marijuana. The police can't say for sure which one person or two people or three people were because everything happens so quickly. But when they get out of the car to try to investigate to see what happened, Miss Coles takes off, flees across the street and into a house. The other two people remain there.
Counsel, if I could follow up on Justice Doherty. They had a generalized suspicion that someone in this group was smoking marijuana. So you're saying the individualized suspicion is based upon her flight?
My argument is that the suspicion is based upon the totality of the circumstances, which this court...
What part of what I said was wrong? There was
I'm not
generalized suspicion
that
someone or some two or three of people in this group of three were smoking marijuana. They had
Correct.
a generalized suspicion.
Correct.
She flees.
Correct.
Individualized suspicion is based upon her flight, correct?
Well, I would say it's not just her flight. That distinguishes her from the other two people who were there.
She has a right to leave. She has a right to run. She has a right to, at that point, there are many reasons she could have wanted to leave that group.
But
I
that's
shouldn't
always...
have been here with these people who are smoking dope. I mean, that could have just been, the thought at the moment, and then she flees. How does that then become individualized suspicion that she was smoking marijuana?
Well, let me say first, Your Honor, in every case where there's reasonable suspicion, we can always come up with innocent explanations as to why a person was...
There was a generalized suspicion that someone was smoking dope.
Right.
The question here is, where was the individualized suspicion that she was absent the fact that she fled?
Well, I would argue that, first of all, there are cases from other jurisdictions following the Fourth Amendment, and this court has repeatedly said that in terms of investigative stops, we follow the Fourth Amendment, we do not depart, where if the suspicion is focused on a small enough group of people, even if they can't tell which one of the two or three people is committing the crime, that's sufficient individualized suspicion for an investigative detention. Now, we don't have to decide that here because we have more than that. We have flight, and it's true. People are...
It's the flight that you're relying on to individualize the suspicion. That's what I'm hung up on. I mean, prior to the fact of her fleeing the scene or leaving this group, there was no individualized suspicion that she had engaged in any criminal activity.
Well, there was individualized suspicion based on the fact that she and only two other people were there, where there were multiple plumes of marijuana smoke wafting around them.
It's generalized suspicion that somebody in that group was smoking dope.
Right, and what I'm saying, Your Honor, is that if we wanted to just limit it to that, there are cases, and I cite them in a footnote because that's not the facts of this case, but there are cases.
Those aren't the facts of this case. They are the facts, aren't they? The police couldn't
No,
identify.
I guess I'm sorry, I didn't get the finish.
The police couldn't identify who was.
That's correct. And there, for example, I cite the case from the Third Circuit where the police drive up and there's two cars that are parked next to one another. The police know that people in, or a person in at least one of those cars is smoking marijuana, but they can't tell which car, and it could be both cars. And the Third Circuit said that's enough to stop both cars. That's sufficient individualized suspicion because we're limiting it to just those people in those two cars. Another case I cite from the Eighth Circuit.
But there was conduct related to both of those two cars from which reasonable suspicion was derived.
I don't believe so, no, Your Honor. It's just the odor of marijuana. That was the only conduct. There's another case that I cite from the Eighth Circuit where the police go into a laundromat and they find a gun magazine and there's two people there, and the Eighth Circuit says that's enough for the police to stop both of those people because there's a limited number of people.
Can I jump in just to see if I can formulate this, if I may? So I take it your answer is that the law is, and here's where the criminal activities afoot, I think, kicks in, apropos Terry, is that the police, they have suspicion, reasonable suspicion that criminal activities afoot, they roll up, and then there's flight. And it's the combination of the flight that ensues with the criminal activity afoot that combines to form the individualized reasonable suspicion. Isn't that the answer?
That's correct, Your Honor. That's the totality of the circumstances. And that's the SJ case. That this.
Let me follow up on that. You can have generalized, I think we're just saying the same thing differently. There's generalized reasonable suspicion that criminal activity is afoot. Generalized reasonable
Among those three particular people. It's not like it's
Exactly.
this entire, well, it's
Exactly.
not very crowded now, but it's not like it's this entire room. There's three people.
I got that. Yeah, I got it, which makes this case different than Missler. But so the only thing that individualizes that generalized reasonable suspicion that criminal activity is afoot is that she flees.
That's correct. That's correct. I'm not going to disagree. I'm not going to disagree, but I'm going to.
I just want to understand
Sure.
if that's what your argument is, and you want us to hold that generalized suspicion of illegal activity can be individualized by the flight of one of the people in the group.
When you have a small number of people, when a crime is occurring there, and when the person flees in response to the police approaching, we consider the totality of the circumstances. That's the test that this court and the United States Supreme Court has repeatedly held is the standard. And so,
If I understand you, following Justice Donahue, I believe this case, as we've argued, presents an opportunity for this court to, in essence, clarify the boundaries of individual suspicion in group settings. So it's your position would be, or your rule for us would to be, that if there is generalized suspicion with a group of individuals, that the generalized suspicion is sufficient and it's elevated by an individual fleeing or walking away from that group. That's what rises to the reasonable suspicion?
I'm not saying it's walking away, it's flight, which this court has specifically stated is extremely relevant. That's the DM case. That's not me. That's the DM case. There's been no argument in this case that DM should be overruled. I'm just saying what this court itself has said.
How does that comport with the notion that flight in and of itself is not an illegal, it's not illegal per se. I mean, you could flee for any reason.
That's correct, Your Honor, but we don't parse out, and this court has said that in not the normal DM case, I'd say there's another DM case that I cite, we don't parse out individual factors and say, well, this is not enough, this is not enough, this is not enough. We look at the totality of the circumstances. And I would ask this court to look at its own decision in SJ. In SJ, what you have is you have a group of 12 people. So the group is much larger than what we have here. Here we have 3 people. SJ, we have 12 people. The police can smell the marijuana, know that some people are smoking marijuana, but they don't see SJ holding a blunt. When the police arrive, the group in SJ begins to walk away. Nobody flees. They begin to walk away, but SJ kind of worms himself to the front of the group. And this occurred in a high crime area.
But there you go. That is the predicate for SJ. I mean, forgetting about any discussion we had otherwise today about high crime areas or anything of that nature, that case was decided in the context of case law that said flight in a high crime area is enough.
I would disagree, Your Honor. That SJ was decided in the 90s. And Illinois versus Ward, though, was, I think, 2000, 2001. SJ was decided before that case. And I would say that what's relevant in terms of the location of the individuals in SJ and in this case is that a crime is taking place right where they are. So the fact that it...
I thought that SJ thing had some effort to conceal or hide.
Right.
No, well, SJ kind of, when the police arrive, the group starts to walk away. SJ, they actually use the word worm, kind of worms his way to the front of the group.
The language was, I believe, quote unquote, attempts to hide among the other members of the group.
Right.
Unquote.
In this case, Ms. Coles flees. As this court has said in DM, it's this court's language, headlong flight is the consummate act of evasion. Once again, there's been no argument, in this case at least, that DM should be overruled, that Pennsylvania provides greater protections than does the U.S. Supreme Court under the federal Constitution. So I understand, Justice Donahue, your concerns, but my argument is that...
I'm not even sure I have concerns with that because you can evade for legal reasons.
That's correct, of course.
But that brings you back to the point that there's nothing wrong with fleeing.
That's correct. I mean, Your Honor, reasonable suspicion, this court itself has said, and it's cited, I think it's Justice Doherty in the TW case that I cite, citing Kansas v. Glover, that reasonable suspicion is considerably less than a preponderance of the evidence. So it can be more likely than not that Ms. Coles is completely innocent, and there can still be reasonable suspicion. And I think if we just look at Terry itself, Terry, there are just 2 men walking back and forth in front of a store window in the middle of an afternoon talking to each other. There's nothing per se illegal about that.
Who the police observed over the course of 20 minutes and then saw them talking to someone else who they perceived at that moment to be the getaway guy. I mean, that was a situation where the police developed their reasonable suspicion over a period of time.
But Your Honor, because the people were walking back and forth looking inside a store window in the afternoon, I don't understand what is per se illegal about that. Maybe they were interested in buying an item in there. Maybe they were interested in a woman who was working in the store. We don't know. And that's the whole point, is that we can always come up with innocent explanations, but that doesn't matter when we're dealing with reasonable suspicion, which is a very low standard.
Are there any other questions for Mr. Greer? Thank you both. Nicely done.
Good argument.
Very nice.
Thank you, Your Honor.
Mr. Minner, would you adjourn for the day?
What's that?